Lordship, my Lordship, yes.
Fresh
My
matter.
Lordship, pending one matter, it's very urgency.
Matters, please give.
The respondent number 4 trying to alienate the
Yes,
property, my
for
Lordship.
If you have moved, you can. Give
My Lordship, I have one small humble submission, my Lordship. I have moved an early hearing IA in WP 1632. I have also filed a memo for listing twice, my Lordship. There is an emergency. The bank guarantee has been expired. Wherein the status was issued to maintain the bank guarantee by the respondent.
mention matter, what can I do?
No, I have moved the early hearing. I have moved the early hearing application also, my Lordship, for listing it. Twice memo also has been listed.
Please Kodi. Rectification of amended Kodi. Please give. You don't have to mention, sir. You please give it. If it's a fresh matter, please give it.
My lord,
Yes.
14%, my lord. It's a my lord, 14%. Earlier in file money matter.
Hakidira. Kodi.
Possession.
One submission, my lord.
One fresh matter.
Grave urgency, end of the list. My property has been seized by the bank, my lord, without due process of law.
Tomorrow, please give it. Matter, urgent matter, end of the list, because today only they have allowed us to strike, indefinite time I have thought, you know, strike before the freedom park. Huh? Right before the freedom park. In respect to case examination, there are no erroneous questions they have right. Please give it, it will come tomorrow. Yes.
My Lord.
Kodri, please give it. Don't have to mention, please give it.
The execution proceedings, my Lord,
Possession will
are
be taken.
scheduled tomorrow.
Respondent bank account has been seized, my lord.
Serial number 1.
There is a stay in the my lords, this petition of 2023. Petitioner has expired, your lordships. Petition notice, your lordship.
Serial number 1.
Above submission, your lordship, I kindly seek apology for the submission.
Serial number 1. Senior advocate should not mention like this. If it is a fresh matter, you please give it, sir. Yes.
They are going to finalize tomorrow, my lord.
Yes.
Despite the order of honorable division bench, my lord.
Yes.
Kindly call tomorrow only.
Kodi. You should not break the conventions like this. It is not proper. Yes.
Serial number 1. Dinesh Nilkant.
Yes. Huh? 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 Huh?
Thereafter, they had cancelled by Interim.
Huh?
We are ready to make full.
Learned counsel. You are appearing? Notice ಆಗಿದೆಯಾ? Notice order ಆಗಿದೆಯಾ ಆಗಲೇ? Learned counsel Sri H.L. Pradeep Kumar takes notice for response number 1 to 4. Issue notice to respond number 5. Learned counsel for petitioner is directed to serve copies of the writ petition along with annexures on the learned counsel for the respondent KD. Yes. Yes.
Serial number 2. Ravichandra M.
Petitioner.
Yes.
Father of the petitioner executed a gift deed in favor of son, name of favor of petitioner. The
Senior Citizens Act.
ಇದರಲ್ಲಿ executed gift deed ಮರೆತುಕೊಟ್ಟೆ but objects the post respondent given liberty to file objection within 2 weeks ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. Within 2 weeks ಅಂದ್ರೆ 2 days before order pass ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ. The respondent filed the objection in 8/8/2000. Given the objection, but the post respondent did not take objection ತಗೊಳ್ದಿರನೇ ಇದರಲ್ಲಿ ಇದು ಮಾಡಿದ್ದಾರೆ ಸರ್. Kindly see the
You have filed objection.
objection file ಮಾಡಿ 22 ಗೆ objection file ಮಾಡಿದೀವಿ. Before 2 days the post respondent has passed the order. Kindly see this.
22/8/2024 you filed the objections.
Objection.
20
ಗೆನೇ order pass ಮಾಡಿದ್ದಾರೆ.
Where is the order?
After in page number 41, 42. 42. Typed copy no, copy also. Liberty to file objection within 2 weeks ಅಂತ ಹಾಕಿದೆ.
42 na.
42 sir.
Order pronounced in the open court,
My lord.
28/2024.
Yes, my lord.
8/8/2024 ಗೆ liberty to file,
Within 2 weeks ಅಂತ ಮಾಡಿದ್ರು.
ಹಾ,
ಅವರು within 2 weeks ಆದ್ಮೇಲೆ 2 days before ಇದು ಪ್ರನೌನ್ಸ್ ಮಾಡಿದ್ರು ಸರ್. ಆರ್ಡರ್ 22 ಗೆ ಅಬ್ಜೆಕ್ಷನ್ ತಗೊಂಡಿದ್ದಾರೆ. Already the property is son Europe petitioner sold the property already in favor of third party.
already sold.
ಮಾಡ್ಬಿಟ್ಟಿದೆ.
ಮತ್ತೆ why are you worried then? Why are you worried?
ಅಲ್ಲ ಸ್ವಾಮಿ
You have
ಇವ್ರು
already sold the property to someone else.
ಮಾರಿದ್ರು ಸ್ವಾಮಿ ಪಿಟಿಷನರ್.
ಹಾ,
ಪಿಟಿಷನರ್ ಮಾರಾಟ ಮಾಡಿದ್ರು.
ಹೌದ್ರಿ, ನಿಮಗೆ ನಿಮ್ ತಂದೆಯವ್ರು ಕೊಟ್ಟಿದ್ದು ಆಸ್ತಿ ನೀವು ಬೇರೆಯವ್ರಿಗೆ ಮಾರಾಟ ಮಾಡಿದೀರ ಆಗ್ಲೇ.
ಹಾ ಸ್ವಾಮಿ.
ಹಾ, ಮತ್ತೆ why are you worried then? There is no effect for this order. This order is passed only against you.
ಹೌದು ಸ್ವಾಮಿ. ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಂತ. ಆರ್ಡರ್ ನಾಟ್ ಫೈಲ್ಡ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ ತಗೊಂಡು ಆರ್ಡರ್ ಮಾಡಿ.
Learned AGA takes notice for respond number 1. Issue notice to respond number 2. Learned counsel for petitioner is directed to serve copy of the writ petition along with annexures on the learned AGA. Full stop. Learned counsel for the petitioner, comma, while taking this court through the order sheets maintained by the assistant commissioner or competent authority, submits that on 8/8/2024, 2 weeks time was granted to the petitioner herein, who was the respondent, comma, to file statement of objections. On 22/8/2024, statement of objections were filed by the petitioner, comma, as found at annexure E. Stop. However, to the shock of the petitioner, the order sheet reflects that on 28/2024, final orders have been pronounced by the assistant commissioner. Full stop. Moreover, comma, the petitioner has already sold the property in question. ಎಲ್ರಿ ಹೇಳಿದೀರಾ ನಿಮ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ?
ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ
ನಿಮ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ಹೇಳಿದಿಲ್ಲ ಆತರ that you have sold the property ಅಂತ? ಎಲ್ಲಿ ಹೇಳಿದೀರಾ?
ಪೇಜ್ ನಂಬರ್ 50 ಮೇಲೆ
50
ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ. After that, respondent needs to amount for his legal estate. He has conveyed the scheduled property in favor of Krishna Reddy, son of Siddhartha. ಹೇಳಿದೆ ಸರ್.
2/11/2023.
ಹಾ ಸರ್.
ಏನ್ ಹೇಳ್ದೆ? In favor of one Shri Krishna Reddy, son of Mr. Siddha Reddy, under registered sale deed dated 2/11/2023. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned order dated 28/2024 in case number MSC (SC) CR 41 of 2022-23 till the next date of here.
Issue number 3, Rudrabhushan CB.
called out. There is no representation.
My lords, I am for the petitioner.
Mandamus and certiorari, my lord. With the mandamus and certiorari, my lord. I will take this honorable court to some of the documents. Page number 29 may be looked into.
You are a borrower.
Yes, my lord, I am a borrower. Page number 29 may be looked into. Lords, on 5/9/2024, respondent bank has issued a letter dated, letter settlement of loan account number so and so. And in this tabular column, my lords, first payment should have been made on 5/9/2024, 25 lakhs. And 29/2024, 25 lakhs. And 20/10/2024, 91 lakhs. That's next, page number 92 may be looked. Page number 92.
This is the settlement plan.
Yes, settlement plan.
90?
Next, 92, my lord.
Hmm.
Lords, on 5/9/2024, the petitioner has deposited 25 lakhs into the subject loan account. And before 29/2024, he should have deposited 25 lakhs. But on 12/9/2024, page number 93, the next page. And 19/9/2024, he deposits 9 lakhs and 6 lakhs respectively. That would amount to 15 lakhs. Lords, the next page is page number 95. Lords, he is petitioner number 3 in this present petition. Somsekhar N. Lords, he will.
If you have not fulfilled the terms of the agreement, nothing can be done. Nothing can be done.
Lords, on 22/9, he was admitted in the hospital. And this is the discharge summary. Lords, on,
Go to the DRT.
Lords, DRT doesn't have the jurisdiction to decide on termination of the notice and decide on the OTA settlement.
No,
Lords, I will just.
Issue notice to the respondent.
I will.
Yes.
Serial number 4,
Yes,
Nishant AV. Lords, I will rely on the.
yes, let them come, we'll see.
Coordinator.
Let them come, we'll see. Yes,
Nishant AV.
yes, next matter, please.
Here for the petitioner, annexure A, page 13. Petitioner, my lords, has been ordered to be blacklisted
Uh,
by the second respondent, and an intimation has been sent to the first respondent. Now, after that communication, my lords, the proceedings are initiated now as to why I should not be blacklisted. There's already an order of blacklisting. Annexure A, page 13. They have come to a decision that I should be blacklisted. This is dated 2nd, 3rd January 2025. The Devendra bin so and so.
It's a communication.
So, my lords.
It's
this
a
is-
communication, take action and send the report. ಕ್ರಮ ಕೈಗೊಂಡು ಕ್ರಮದ ವರದಿಯನ್ನು 3 ದಿನಗಳ ಒಳಗಾಗಿ ಈ ಕಚೇರಿಗೆ ಸಲ್ಲಿಸುವಂತೆ ನಿಗಮದ ಎಲ್ಲಾ ಘಟಕಾಧಿಕಾರಿಗಳಿಗೆ ಕೂಡಲೇ ಕ್ರಮಗೊಳ್ಳಲು ಸೂಚಿಸಲಾಗಿದೆ.
One line.
So consequently, they issued a notice to you.
One in the middle.
ಅವ್ರು ಏನಾದ್ರು ಮಾಡಿರ್ಲಿ, it is a communication, not to you.
One line. One line.
Yes.
ಅರಣ್ಯದಲ್ಲಿ ಮರ ಕದ್ದವರನ್ನು ಕಪ್ಪು ಪಟ್ಟಿಗೆ ಸೇರಿಸಬೇಕಾಗಿರುತ್ತದೆ. And they refer to me, my contract.
A notice has been issued to you now.
They have already.
Please answer.
Prejudged my case.
No. A notice is given to you now.
This is pursuant to this communication.
Correct.
Pursuant.
Notice is given to you. You please answer.
Yes.
ಬರ್ಕೊಳ್ಳಿ. Having regard to the fact that the notice has been issued to the petitioner on 3/1/2025, calling upon him to answer as to why he should not be blacklisted, the petitioner is required to give a reply. And if a reply is given, the respondents are required to take action only in accordance with law. Full stop. Next para. With these observations, without issuing notice to the respondents, the writ petition stands disposed of.
Serial number 5, Somshekari RP.
Successful bidder, the deposited the EMD amount.
Huh?
He has deposited the EMD amount, the sale was confirmed. Thereafter, respond number 2 and 3.
Bidder.
Bidder.
Ah,
Respond number 2 and 3 filed this petition for example. This petition was disposed of on 11/11/2024, directing the respond number 2 and 3 to pay a fine of pay 50,000 rupees to the action purchase and to refund the EMD amount. But now the respond number 2 and 3 deposited the amount, but the bank is not returning the EMD amount at this thing. Therefore, my lord,
who appears for this Union Bank of India?
petition Divya Purandar was paid.
Huh?
Divya Purandar. Next.
Learned Counsel Srimati Divya Purandar is requested to take notice for respond number 1. Issue notice to response number 2 and 3. Learned Counsel for petitioner is directed to serve copy of the writ petition along with annexures on Learned Counsel for respond number 1.
Serial number 6, Sarvanayan.
Petition filed for the mandamus. Consider the annexure B. Okay. Huh? Petitioner has taken the loan from the respondent bank. 3,70,000 crores. OTS. OTS. Paid already substantial. Issue notice to the respondent. But now physical possession into the bank. And they have not taken interest to the unless. Yes.
Serial number 7,
Yes.
Prabhakar HB, MB.
ಇದರಲ್ಲಿ we had taken instruction that additional statement of objection needs to be filed ಅಂತ.
Ah,
But my instructions, my lord, that whatever objections we have filed.
is
it
sufficient.
Sufficient.
Ah, sorry. What do you want to do? Matters to be heard and disposed of finally.
Yes, ma'am.
Interim orders are passed.
No interim orders. No, there is
No
no
interim
interim
order.
order.
ಆಯ್ತು. Although it was submitted earlier by the learned AGA that additional statement of objections may be required to be filed, nevertheless, today the learned AGA submits no additional statement of objections is required to be filed. Stop. Yes. Matter is required to be disposed of finally. Yes.
Serial number 8,
We'll see, sir. Let it come up in seniority. Yes.
serial number 8, Tyagaraaj B.
Huh? Pass over.
But representing advocate for the
Pass over ಕೇಳ್ತಾ ಇದಾರೆ.
Election petition ಅದ್ರಲ್ಲಿ ಜೊತೆಗೆ ಜಾಯಿನ್ ಮಾಡಿರ್ತಾರೆ.
ಏನ?
Election petition, yes, succeeded in the panchayat election on the basis of the mail certificate.
Pass over ಕೇಳ್ತಾ ಇದಾರೆ, sir. He is not asking for an adjournment. He is asking for a pass over.
ಅದು ಎರಡು ಟ್ಯಾಗ್ ಮಾಡಿರ್ತಾರೆ.
ಯಾವ್ದು?
One more petition is pending with WP number
ಹಾ.
27,882/2024.
ಹಾ.
ಅದು ಇದು same party.
Both are separate.
ಆಯ್ತು, pass over.
Serial number 9, Girish B. Baladre.
Recreation club.
Huh?
Recreation club.
Recreation Club. Learned AGA takes notice for all the respondents, same order. Recreation Club.
10, Suresh V.
Filed is, surface not been disposed of from 20.
ಏನು?
Surface proceeding dispose ಮಾಡಿಲ್ಲ.
Dispose ಮಾಡಿಲ್ಲ.
Order ಮಾಡಿಲ್ಲ. Annexure is 2023 in the.
You are a
For a bank
financial bank. What is your prayer?
to direct the learned chief judicial magistrate rural court Bangalore to dispose of the application filed under section 14 of this. It's in annexure C.
2023.
Oh. In annexure C.
Where is the order sheet?
Let's see.
Why it is not disposed of?
Objections ಅಂತ ಹೋಗ್ತಿದೆ.
ಯಾರ್ದು objection?
ಹಾಕ್ಬೇಕು ಅಂತ ಅಬ್ಜೆಕ್ಷನ್ ಹೋಗ್ತೀವಿ.
ಹಾ?
ಈ ಖಾತಾ ಹಾಕ್ಬೇಕು ಅಂತ ಅಬ್ಜೆಕ್ಷನ್.
ಈ ಖಾತಾ.
It's in annexure B.
Why have you not furnished ಈ ಖಾತಾ?
ಈ ಖಾತಾ borrower ಮಾಡಿ. Borrower has to do.
Borrower.
They have pledged the document.
ಈ ಖಾತಾ you want in your name now. We have disposed of one writ petition. A circular has been issued by the government now. You are permitted to file an application seeking a transfer of khata in your name, and e-khata will be made. Please go file an application, get the e-khata, and thereafter place it before the court. Yaudri adu matter? The petitioner, having regard to the prayer made in the writ petition, seeking directions to the learned Chief Judicial Magistrate, Rural Court, Bengaluru, to dispose of the petition filed under section 14 of the Surfae Act in Criminal Miscellaneous number 587 of 2023, this court is of the considered opinion that no notice is required to be issued to the respondents. Full stop. Next para. Learned counsel for the petitioner submits that the learned Chief Judicial Magistrate is insisting that e-khata in respect of the secured assets, in respect of which the petition has been filed before the learned Chief Judicial Magistrate, is required to be filed by the petitioner financial institution. Full stop. Learned counsel submits that the e-khata cannot be obtained by the petitioner. Full stop. Next para. In a recent case decided by this court in WP number so and so, this court has noticed the fact that the state government has issued a circular ಹಾಕೊಂಡು ಮಿಕ್ಕಿದೆಲ್ಲ ಅಲ್ಲಿರೋದನ್ನ ಸೇಮ್ ಹಾಕೊಂಡು so we will dispose of the petition, permit you to go and file an application. BBMP na?
BBMP ಅಲ್ಲ.
BBMP. ಚಳ್ಳಘಟ್ಟ.
ಚಳ್ಳಘಟ್ಟ BBMP ಬರಲ್ಲ, ಗ್ರಾಮ ಪಂಚಾಯತ್.
ಗ್ರಾಮ ಪಂಚಾಯತ. ಹಾ?
ಬೇಗೂರು ಹೋಗಿ, this is BBMP ಮೇಲೆ.
Huh?
BBMP only.
That BBMP. So disposed of, you go file an application, get the e-khata, place it before the learned magistrate.
That one submission, my lord.
Yes.
Because e-khata we can't apply, my lord, because this.
You can, sir. They have made a provision. Please understand.
This BBMP notice.
It is made in favor of the financial institutions only.
Recent, my lord, that BBMP has been issued the lord, in that where the section 14 after sale, that has been. This is, we are not sold, my lord. We are only under section 14 before the magistrate. After sale, that the notification will apply. That BBMP notification last week they passed by BBMP. After sale, we can obtain the e-khata in our financial name. Here still the borrower is having the property in his name. We have only filed a section 14 to take a position of the property, my lord. This notification it does not arise at this stage, my lord.
ಸರಿ, ಹಂಗ ತೆಗ್ದಾಕ್ಬಿಡಿ. ಇದು ಡಿಕ್ಟೇಟ್ ಮಾಡಿದ್ನಲ್ಲ ಇವಾಗ, ಅಲ್ಲೇ ಇರ್ಲಿ. However, learned counsel for the petitioner submits that for the purpose of taking possession of the secured assets, there is no need for the secured creditor to tender the e-khata in respect of the secured assets. Full stop. That is not the requirement in terms of section 14 of the act. Full stop. Next para. The submission of the learned counsel for petitioner is accepted. Full stop. The learned Chief Judicial Magistrate is hereby directed to proceed to consider the petition and dispose of the same without insisting on EATA to be furnished by the petitioner. Full stop. The petition shall be considered and disposed of as expeditiously as possible and at any rate within a period of 6 weeks from the date of receipt of a copy of this order, ordered accordingly.
Maturely.
Yes.
11. Mohan Kumar Adi.
Hearing for petitioner, my lords. Bit of
Classification, my lord.
Huh?
OSU. With Annexure D, page number 43.
Go get an order from the civil court. Yesterday's order. Yesterday's order, same order. There is already a temporary injunction granted in your favor.
My lord,
Go file an application seeking police
so the
protection.
petitioner, police is not a party, first of all.
Huh?
Police is not a party. ಅಲ್ಲ ಇದರಲ್ಲಿ ಕ್ಯಾನ್ಸಲೇಷನ್ 10 ಸಲ ಕೇಳ್ತಾರೆ, ಇಟ್ ಶುಡ್ ಬಿ ಕ್ಲಾಸಿಫೈಡ್ as
ಅದೆಲ್ಲ ಬಿಡ್ರಿ, ಅವ್ರು ಏನಾರು ಕೇಳ್ಕೊಳ್ರಿ. If they want any police protection to implement the temporary injunction granted by the court, they'll have to file an application and it will be considered. Same order, ನೆನ್ನೆ ಒಂದು ಮಾಡಿದ್ದೀನಿ ನೋಡಿ.
ತೋರಿಸಿ ಪೊಲೀಸ್ ಪಾರ್ಟಿ ಇದಾರೆ.
Learned AGA takes notice for. ಕೊಡಿಲಿ.
ಎಲ್ರಿ ಪೊಲೀಸ್ ಪಾರ್ಟಿ ಇದಾರೆ. Petition ತೋರಿಸಿ, ನಮ್ ಕೊಟ್ಟಿರೋ petition ಪೊಲೀಸ್ ಪಾರ್ಟಿ.
All the respondents, yes.
12. Mahadeva RK.
Lords, I may be permitted to appear on top. Thought by judgment of coordinate bench of the honorable court, my lords. Petitioner's vehicle was seized, my lords, by the respondent number 2. In relation to the forest offense, my lords, in FOC number 10 of 2024-25. Petitioner has filed an application on 9/1/2025, my lords, with respondent number 2 for release of this vehicle, my lords. Same has not been considered, my lords, pending for consideration. Therefore, the writ has been filed with the.
Which is that order?
My lords, annexure B, page number 11 may say it is, my lords. Page number 9, my lords. Oral order, my lords. Page number 10, my lords. Case for
Without requirement of bank guarantee. Huh?
ಇದರಲ್ಲಿ they have made an application on 9/1.
Huh?
Lord, I'll just take instructions whether for this release of vehicle, whether bank guarantee, because ಏನ್ seize ಮಾಡಿದ್ದಾರೆ ಏನು ಅಂತ I have no. But whereas in this case, they say there is no bank guarantee not required.
In subsequent case also, my lord. Annexure C, my lord, page number 12.
No, he is not called upon you to furnish bank guarantee.
No, my lord.
Then
My lords, he may, my lords,
what is this?
if
In
it-
anticipation, you cannot file a writ petition. Let him pass an order. Learned AGA takes notice for both the respondents. Learned counsel for petitioner is directed to serve copies of the petition along with annexures on the learned AGA. Full stop. Next para. Learned counsel for the petitioner submits that coordinate benches of this court have passed orders such as the one found at annexure B.
C, D and E, my lord.
B, C and D,
B, C, D and E.
where it has been held that the authorities cannot insist on furnishing bank guarantee for release of the vehicles. Full stop. Next para. However, learned AGA submits that no such information is placed on record to show that the respondents have called upon the petitioner to furnish bank guarantee. Full stop. Next para. The writ petition is therefore disposed of with a direction to the respondent authority, second respondent, to consider the application filed by the petitioner for release of the vehicle in forest offense FOC number 10 of 2024-25, comma, having regard to the judgments of this court, where it has been held that there is no need to furnish bank guarantee for release of the vehicles. Yes.
Number 13, withdrawal of appeal. Petition. And memo for withdrawal.
The petitioner and learned counsel for petitioner have filed a memo stating the petitioner is willing to pay the penalty of rupees 25,000 imposed by the respondent Karnataka Information Commission, and therefore the learned counsel submits that the petition may be disposed of as not pressed. Full stop. Next paragraph. The memo is taken on record subject to all justice. Accordingly, the petition stands dismissed as not pressed.
14, yes, Shashikanta Prasad.
Number 1, my lord. The prayer sought in the petition has become infructuous, my lord.
Learned counsel for the petitioner has filed a memo dated 18/1/2025 stating that the auction scheduled on 6/11/2024 could not be held, and therefore the prayer made in the writ petition has become infructuous. Full stop. The learned counsel would therefore submit that the writ petition may accordingly be disposed of. Full stop. Next paragraph. The memo is taken on record subject to all just exceptions. Full stop. Accordingly, the writ petition stands disposed of as the prayer made in the writ petition has become infructuous.
15, Victor Manoharan, yes.
Learned counsel for petitioners has filed a memo dated 5/12/2024 stating that the respondents have assured to consider the case of the petitioner. Hence, the petitioner seeks leave of the court to withdraw the writ petition. Same order. Dismissed as withdrawn.
Serial number 16, Dare Swamicha.
Where is your memo? Learned counsel for petitioner has filed a memo seeking leave of the court to withdraw the writ petition and approach the debts recovery tribunal for redressal of its grievance. Full stop. Same order. Dismissed as withdrawn.
Admission 17, M. Ramaya, party in person.
Huh?
Well, time. Party in person, M. Ramaya.
Matter is called out. There is no representation for the petitioner. Full stop. This is the 12th time that the matter is coming up for non-compliance of office objections. Full stop. Next paragraph. It appears that the petitioner has lost interest in the matter. Full stop. Accordingly, the CRP stands dismissed for non-prosecution and non-compliance of office objections.
18,
Please.
SBN Prakash, Doctor.
Pass over.
Serial number 19, Abhinav Ramanandi, respondent number.
Matter is called out. There is no representation for the petitioner. Release this matter on 5th of February.
Narayan M. Naik. For respondent.
Huh? At the request of learned counsel for petitioner, release this matter on 27th of January.
21, Satish Chandra.
Respondent number 1 filed as a partition suit for a claiming a share of petitioner's other property. There, the intention of the respondent number plaintiff is that the property purchased by the father of the
Suit for
suit for partition.
partition.
Please.
The
property was, the scheduled properties were purchased in the name of the petitioner's father in the 1962, 1970. But the fact that they claiming that the property purchased by the father of the present petitioner is out of the income of the family.
These are all matters to be considered after evidence is recorded.
No, my lord, one sufficient, my lord.
Huh.
It is like a fact that the father of the.
Maybe, sir, maybe he has purchased it, but they can lead evidence to show that the sale proceeds came from the income of the joint family. They're all matter of evidence. How can you seek rejection of the plaint on this ground? What is this? There is nothing wrong in the order.
My lord, order is at page number 18, my lord.
Yes.
But my submission is that sale date furnished by me.
Avudre.
No, one of the father.
How many such cases you can find which has gone up to the Supreme Court? It's a matter of evidence, sir. They can lead evidence to say, although the sale deed is executed in his name, the funds for that came out of the joint family, and therefore it has to be considered as a joint family property. It's a matter of evidence.
Madam.
Ah.
But my one submission is that fact, the while in their pleadings, they have stated only how the nucleus came into the hands of the petitioner's father and he purchased. There is nothing such a.
ಅದನ್ನ ಎಲ್ಲ ಇದ್ರಲ್ಲಿ ಹೇಳ್ಬೇಕು ಅಂತಿಲ್ಲ.
My one more.
Not necessary.
Sale deed.
There is nothing wrong in the order.
My one sub. Father of the one of the brother had his share is sold to the father of the petitioner. At page number, my lord.
The petitioners are defendants number 10, 15, 17 and 18 in the suit filed at the hands of the first respondent herein. Full stop. The petitioners herein had filed an application in IA number 2 under order 7 rule 11 bracket A and D of CPC, contending that there is no cause of action for filing the partition suit and the same is barred by law. Full stop. It is the contention of the petitioners that even according to the plaint,
Page 32, sir.
ಎಲ್ರಿ ಅದು ಸೇಲ್ ಡೀಡ್?
Sale deed is a page number.
Where have you stated in your application?
Application ಇಲ್ಲಿ ಹೇಳಿ. Objection ಅಲ್ಲಿ.
Application ಅಲ್ಲಿ that is the main ground ಅಲ್ವೇನ್ರಿ?
Really have purchased it ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಮತ್ತೆ?
Purchased it because it proposed it as Narsaya was alive as on the when these properties was purchased with the father of petitioner. So that cannot be a ancestral joint property in the contention. The Narsaya has got 5 sons. One of them, fourth son, is the father of petitioners. So when the Narsaya was alive, if the property is purchased in the name of the
ಆಯ್ತು. ಏನ್ ಹೇಳಿದ್ ನಾವು? Contending that the suit schedule properties were exclusively acquired by their father, Sri Yellaya, from his hard-earned money after he got separated from the joint family in the year 1958-60, and he shifted to Bangalore with his family and started independent life. Full stop. It was contended that not a single proof was placed along with the plaint to show existence of joint family and also about cause of action to file the suit. Full stop. The learned additional civil judge and JMFC, Kunigal, while taking note of several judgments of the Honorable Supreme Court, has come to a conclusion that the cause of action to file a suit for partition is to be determined on the basis of material which may be produced by the parties at appropriate stage in the suit. Full stop. To reject, on the other hand, to reject the plaint under Order 7, Rule 11A and D, what is required to be considered is only the statement in the plaint and not any other material which may be available to the defendant as defense. Full stop. The learned judges held that the burden is cast on the plaintiff to prove that all the suit properties are joint family properties, and that can be done only after permitting the parties to adduce evidence. Full stop. On these grounds, the application filed by the petitioners have been rejected. Full stop. Next para. This court does not find any infirmity in the impugned order. Full stop. Consequently, the writ petition stands dismissed.
22. Abhinav, yes?
Yes. Huh? Interim order is already granted in this petition. Then why is it coming for admission? ಏನ್ರಿ admission ಯಾಕ್ರಿ ಬರುತ್ತೆ ಮತ್ತೆ? Notice was not ordered?
No, the contesting response.
For the caveat.
Notice order ಆಗಿಲ್ವಾ?
Order ಆಗಿದೆ, Your Lordship. I appear on behalf of the council on record.
Huh?
I appear on behalf of the council.
ಕೊಡಿ. Learned counsel, Sri J.C. Kumar has entered appearance for respondent number 1 by filing a caveat petition. Notice to respondents number 2 and 3 have been dispensed for the time being in terms of order dated 19/12/2024. Interim orders have also been passed on the same date. Full stop. Therefore, the matter may require consideration for disposal finally. Yes. Interim order granted earlier stands extended until further orders. Yes.
Obligation.
Serial number 23.
This my lord,
K. Chandrasekhar.
file wakalat today, your lordship. Your lordship, can it be taken up Monday? Undertaking ಒಬ್ರು ಕೊಟ್ಟಿದ್ರು ಮೊನ್ನೆ ಬಂದಾಗ ಕೇವೇಟ್ ಮಿಸ್ ಆಗಿ ಬೇರೆ ಫೈಲ್ ಮಾಡಿದ್ರು. ಇಲ್ಲ ಇದಕ್ಕೆ ಹಾಕಿಲ್ಲ, ಅದ್ರಲ್ಲಿ ಹಾಕಿದ್ರು. ಕೊಟ್ಟಿದ್ದಾರೆ therefore I am. Yesterday it was given your lordship, today I filed wakalat. That's why my lord may have this matter on Monday.
At the request of learned counsel for the respondent, released this matter on 27th of January. The interim directions, the undertaking given by the learned counsel for the respondent on 15/1/2025 shall continue till the next date of hearing.
Also filed wakalat lordship today. My name may be directed to be shown. Morning I filed.
You have filed wakalat for whom?
Wakalat for respondent number 1, your lordship.
Learned counsel
To whom
Sri
the undertaking was given.
H.C. Shivram
Yes, sir.
has filed wakalat for respondent number 1. Office is directed to show the name of the learned counsel in the past.
Grateful.
Yes.
Non-compliance for first time.
My lord, I am appearing for the petitioner, my lord. I'll pray for 3 days time to comply with the office objection. Your lordship may kindly have it on Monday, my lord. There is an urgency.
At the
Not
request
served.
of,
Copy is not served.
at the request of learned counsel for petitioner, release this matter on 27th of January, if office objections are complied.
Obliged, my lord.
The learned counsel is also directed to serve copy of the petition along with annexures on the learned counsel for the caveat respond number 1.
Obliged, my lord. Obliged.
Serial number
Yes.
25.
A week's time is granted to the
For
petitioner
respondent.
for complaints of office objections.
For respondent.
Yes.
Serial number 26. Nishant Unipi.
Huh?
Some urgency, my lord, I think, my lord.
Yes.
But, the petitioner is a forest dweller. He's been staying at the same place for over 100 years from his forefathers' time. But he has filed an application.
Borrower.
Forest dweller.
Huh? Forest dweller.
Forest. Under the Scheduled Tribes and Other Forest Dwellers Act, he has filed an application for determination of his right. That, my lord, I have produced at annexure A, my lord. My lord, when that was pending consideration, my lord, that is pending consideration. While that was pending consideration, my lord, the forest official, the range forest officer at annexure C registers an FIR saying that I am in occupation of a forest land. Basis that, my lord, the assistant conservator of forest passes an eviction order. I challenge that before the chief conservator of forest. But both of them confirm, he also confirms the order of the assistant without making any reference to my application, to my statement. I made an application for my forest right, and that is pending consideration.
Learned AGA takes notice for response number 1 to 3. Issue notice to response number
1 to 3 and 6.
4 and 5. AGA for 1 to 3 and 6. ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಮಾಡ್ಬೇಕ್ರಿ, ಅವ್ರನ್ನ ಸಪರೇಟ್ ಆಗಿ ಯಾಕ್ರಿ ತಹಸೀಲ್ದಾರ್ ಆ ಕಡೆಗೆ ಹಾಕ್ತೀರಾ? Learned counsel for petitioner is directed to serve copies of the petition along with annexures on the learned AGA. Full stop. Next para. Learned counsel for the petitioner submits that the impugned orders have been passed by respondents number 3 and 4. 2 and 3. 2 and 3. Holding that the petitioner is in unauthorized occupation of forest lands, although an application has been filed by the petitioner in terms of annexure A.
That aspect has already been considered by the order. Your Honor, may kindly see page number 23 of the order.
He has not considered.
Page number 23, my lord. Third para. ವಿಚಾರಣೆ ಸಮಯದಲ್ಲಿ ಒತ್ತುವರಿದಾರರು ಶ್ರೀ ಮುನಿಸ್ವಾಮಿ ಬಿನ್ ರಾಜಪ್ಪ ಇವರು ಸದರಿ ಜಮೀನು ಮಂಜೂರಾತಿ ಆಗಿದ್ದು ಕಂದಾಯ ಇಲಾಖೆಗೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು ಇದುವರೆಗೂ ಕಂದಾಯ ಇಲಾಖೆಯಿಂದ ಮಂಜೂರಾತಿ ಆಗಿರುವುದಿಲ್ಲ ಹಾಗೂ ಪ್ರಸ್ತಾವಿತ
ಕಂದಾಯ ಇಲಾಖೆನಾ? You said your rights as a forest dweller, you said. Annexure A is what?
It is an application made there.
To whom?
It is Gram Sabha. But as per the act.
So it's not to the revenue authorities. That information is wrong. ಏನು ಹೇಳ್ದಮ್ಮ? A to the appropriate committee claiming rights as a forest dweller in respect of the lands in question, and the same remains to be considered, the impugned orders have been passed. Full stop. Next para. Consequently, there should be an interim order of stay of the impugned orders at annexures E and F till the next date of hearing. Next para. Office objection is overruled.
Number 27, Nagendra B.
ಅಲ್ಲ ಸ್ಟಾರ್ಟಿಂಗ್ ಎಲ್ಲ ಹಾಕೊಂಡ್ಬಿಡಿಲ್ಲ. Office objection is overruled on starting ಎಲ್ಲ. Yes. Parole. Learned AGA takes notice for all the respondents. Learned counsel for petitioner is directed to serve copy of the writ petition along with annexures on the learned AGA. Full stop. Next para. What is the urgency? 11th January. When is the next ceremony to be held? When is the next ceremony to be held? That the death has already happened. Is there some ceremony to be held? What is the date? ಯಾವ್ದ್ರಿ ಡೇಟ್ ಹೇಳ್ರಿ? ಅದೇ ಏನ್ ಡೇಟು? What is this? There should be some ground, isn't it? If the mother was hospitalized or something, that can be a ground. Now she has passed away. Why you need parole for what? There are some rituals to be conducted. What date? On 1 month. ಏನ್ ಹೇಳಿದಮ್ಮ? Next paragraph. It is the contention of the petitioner that how are you related to this prisoner? As an ex-friend. ಏನ್ ಹೇಳಿದಮ್ಮ? Petitioner that the prisoner, yes, Abhishek's mother, oh, Lohita. ಅದ್ ಹೆಂಗ್ರಿ ಹಂಗ? ವಾಟ್ ಇಸ್ ದಿಸ್? ಅವನ ಹೆಸರಲ್ಲಿ ನೀವು ಪೆಟಿಷನ್ ಹಾಕ್ತೀರಾ ವಿತೌಟ್ ಎನಿ ವಕಾಲತ್? ಇದೆಲ್ಲ you should have filed the petition in your name only. ಏನ್ ಹೇಳಿದೆ? Lohita's mother passed away on 11/1/2025, and the petitioner is the only member of the family surviving, and he has to conduct the obsequies and the last rituals are obsequies and other rituals after the death of the mother, and therefore this prayer for grant of parole. Full stop. Next para. Learned AGA is directed to secure instructions from the respondents and make submissions. Eleven 11th day ceremony entry ಮಾಡೋದು 10th ಆಗಿದೆ. ಏನ? ಹೌದಪ್ಪ, 11th day ceremony ಕಂಡಕ್ಟ್ ಮಾಡ್ತೀರಾ? ಯಾವತ್ ಮಾಡ್ತೀರಾ? 1 month ದ ಏನು ಬರ್ದಿರಲ್ರಿ ನೀವು ಇದರಲ್ಲಿ ಪೆಟಿಷನ್ ಅಲ್ಲಿ? Release this matter on 24th Friday. Yes. ಕರೆಕ್ಟ್ ಆಗಿ ಡೇಟ್ ಎಲ್ಲ ತಿಳ್ಕೊಂಡು ಹೇಳ್ರಿ. Yes.
28 Narendra Nayakar.
Correction of original of section A. that's confused with that. But by take notice.
There are 5 office objections, sir.
I complain.
Ian, what is the urgency?
Included in the revolution. Not with the contract.
Huh?
Is a contract, civil contract.
As long as this sheet is opened, he is not, will be able to bid for.
You
the
please
tenders.
comply with the office.
I'll
objection.
comply, I'll comply.
Learned AGA takes notice for all the respondents. Learned counsel for petitioner is directed to serve copies of the writ petition along with annexures on the learned AGA. Full stop. Next para, release this matter on 29th of January.
Meanwhile, I'll comply.
Full stop. In the meanwhile, office objections will be complied.
29, Rajendra MA.
There are
For the respondent number.
judgments we have passed.
Yes, sir. It's covered.
You please get a copy of that one.
I'll place those.
Dispose of petition.
I'll
Yes.
place those.
Yes.
You have served the copy to the caveat.
Huh?
You have served the copy to the.
4 office objections are there.
I'll complain within a day,
Huh?
within a day's time I'll come because
Your Honor, if I may make a submission on this.
Here, Ray.
this, I am before your lordship invoking the writ jurisdiction, challenging the order passed by the DRT on 10th January 2025.
DRT.
DRT 70 Annexure A. This
Then
question
go
of law.
before the
No, no.
appellate authority.
Yes, my lord. The question applies 286, 287, page number, I may permit to take your lordship. 288, page number. Page number 288, my lord. This is a Udyam registration certificate. This falls under the category for MSME. And bank has also agreed to restructure my loan account at page number 298, man.
MSME.
MSME, CGTMC scheme, where Supreme Court also has come down heavily, and Reserve Bank Committee has also given guidelines. Even Calcutta High Court also passed the judgment stating that when the restructure and reschedule is eligible, that has to be extended. Here, though we have taken up this contention, the DRT has not considered. Kindly see the page number 298, my lord. This is their own correspondence, wherein the bank has agreed to restructure the loan account subject to submitting this Uday, the certificate, that Udayam's registration certificate.
Which is the impugned order?
This is the impugned order, page number 76, Annexure A.
How has the DRT considered this argument of yours?
Yes, DRT said that since I have not produced the MSME certificate.
Paragraph. Which paragraph?
Yes, my lord. Para number, page number 86, my lord.
86.
Last paragraph, my page, para 13.
Yes.
Page number 86, the last paragraph, above 4 lines, as stated above, the applicants have no case that at the stage of declaration of the account as non-performing asset, they had brought to the notice of 4 dependent that they are MSME registered under the MSME Act, and the credit facilities availed by them from Canara Bank were granted under MSME category only. Instead, they allowed to go by saying that submit initiated by the 4 dependent is against the scheduled properties. It was equally incumbent on the part of the applicant to be vigilant enough to follow the process. So we have followed all the process. We have given the certificate. MSME, our head MSME certificate produce model anta ittare. But MSME certificate. But the loan is sanctioned under MSME category. For the past 45 years, I am banking with them. I am banking with them for the past 45 years. The loan is when it's sanctioned under MSME, its loan is renewed, enhanced, disbursement kept on renewed. There is a question of our producing MSME, my lord. And the bank has suppressed the fact of page number 298. That is their own correspondence, their own admission. They have offered us to restructure the loan account. But suddenly, without assigning any reason, they have rejected it. Wherein there one contention they have taken. Since the stocks were not available at that time, that is the reason we are not entitled for restructuring of the loan account. Whereas there is a sales turnover of 150 crores.
All right. Is this not a matter that can be considered by the appellate tribunal?
Yes, my lord. Here is RBI guidelines by mandatory.
Go.
And my submission, my lord. No, my one more submission, my lord. SA 41 of 2025 is pending adjudication. Yesterday, the DRT granted the interim order stay with regard to section 14 of the Act, wherein I place all these facts.
again, I place all these facts before the DRT stating that these are the orders has been passed. These are the have highlighted the salient features of this order passed by the DRT, wherein in contrary to the RBI guidelines, these orders has been passed. Though we have preferred, we have invoked writ jurisdiction. These are the things. And the DRT was very much convinced. Immediately, yesterday they granted with regard to taking physical possession of the property. My humble submission is that if the matter is remanded back, because based on this, so that 14 is already pending adjudication, my lord.
No.
My humble
Sir,
submission, this
no,
may
no.
because RBI, because I am relying on the judgment passed by the
Whatever contentions or grounds you wanted to raise have been raised. The DRT has considered that and passed orders.
but
It
no,
is now for the appellate authority to consider whether
no,
the orders passed by the DRT are correct or not.
no, those are the grounds which
I know, I can understand. All the difficulties of you people are that you don't want to deposit the pre-deposit amount.
17
Ište,
crore,
this
no,
is the
no, no, 17 crores have deposited.
What, huh?
17 crores have deposited after classifying NPA. Details will furnish. 17 crores have deposited.
Now, if you go before the appellate tribunal,
Yes, my lord.
you'll have to deposit, pre-deposit.
But 17,
Ellardu ide problem
no, your 17 crores have been deposited.
already. Then there is no difficulty. Go before the appellate authority. Berkeley.
No, my submission, I am relying on the judgment passed by the Honorable Supreme Court.
Sir, it is something that can be considered by the appellate authority.
No, when the matter
Is the appellate authority precluded from considering this one?
no, your lordship.
Then,
But my submission is, if the matter is
learned
remanded
counsel.
back, your lordship, under section, when matter is pending adjudication, section 14,
Prakash Hegde K has entered appearance for the second respondent bank. Next para, learned counsel for the respondent bank submits that the writ petition has been filed questioning an order passed by the debts recovery tribunal Bengaluru. Full stop. It is submitted that an appeal remedy is available for the petitioner to approach the debts recovery appellate tribunal. And this writ petition cannot be maintained. Even if it is the contention of the petitioner that his grounds which were raised before the DRT that the petitioner is an MSME and therefore such action for recovery of debts could not have been initiated by the respondent bank. Full stop. Next para.
and some of the portion is also falls into the category of agriculture status land is there. Agricultural status land is also
That
there.
counsel for the petitioner, however, submits that another ground has been raised before the debts recovery tribunal that the loan granted to the petitioner is agricultural loan.
Some portion of the lands.
A portion of it is agricultural lands. Agricultural loan
No, it is agricultural land taken as security.
that some of the assets mortgaged with the respondent bank are agricultural lands.
It's taken
And under the provisions of the Surface Act,
section 31I of the act.
the bank cannot be permitted to proceed against agricultural lands. Full stop. Next para. Having regard to the contentions raised by the learned counsel for a respondent regarding maintainability of the writ petition, even if it is the contention of the petitioner that it is an MSME and that some of the secured assets are agricultural lands and the respondent bank could not have proceeded under the provisions of the Surface Act, this court is of the considered opinion that when an appeal remedy is available for the petitioner to question any order passed by the debts recovery tribunal before the appellate tribunal, a writ petition cannot be maintained. Full stop. Next para. Accordingly, the writ petition stands dismissed.
So keeping open all the contention. my lord.
All contentions are kept open. Much obliged.
30, Naveen Kumar, GM.
My lords, for the petitioner in this case, my lords, this is regarding the Surface Act, my lords. My lords praise the liberty to file before the DRT, my lords.
Huh?
Praise this honorable court the.
Want to withdraw the petition?
Yes, my lords.
Please file a memo.
Kindly pass over, my lords. We'll file it.
Pass over.
Non-compliance for second time, Ravi SK.
My lords, I am for the petitioner in this case, my lords.
Order sheet put.
Idralli, there are 3 compliances. One is to serve on the ASG office, amele marking of the idrallirodu annexures tegibeku anta. That will be complied during the course of the day, my lords. I am seeking, we will comply that during the course of the day. ASG office ಗೆ ಬೆಳಿಗ್ಗೆ serve ಮಾಡಿಸಿದೀನಿ sir. With subsequent to the first ಇದಾದ್ಮೇಲೆ ಮತ್ತೆ ಇದು ಮಾಡಿರೋದು. First office objection raise ಆದ್ಮೇಲೆ ಮತ್ತೆ comply ಆದ್ಮೇಲೆ second ಇದು ಬಂದಿರೋದು. There are 3 things. ASG office has been served in the morning. The remaining 3 compliances will be complied during the course of the day, my lord. Here the urgency is, my lords, the petitioner before your lordships is seeking for a stay as against the pre-EMI amount which he is supposed to pay to the HDFC bank. That was the 5th respondent before your lordships. There is a tripartite agreement which was executed between the petitioners, between the bank and the builder. My lords will get that at Annexure H, page 116, my lords.
Who are the petitioners?
Petitioners are the home buyers, my lords. Petitioners are the home buyers. They are also having the agreement to sell. They are the agreement to sell holder as on today, the present this thing. Along with the supplemental agreement wherein the scheme for buyback and paying of the pre-EMI was made by the buyer. I am so sorry, by the builder. My lords, may please come to Annexure G. The operating portion, my lords, will get it at page 112, my lords. 111 and 112, 7.1 point, my lords. Did my lords get it, my lords? 7.1. Ali, construction and possession of the Schedule B apartment. The purchaser has or have availed the loan from HDFC Limited. The developer shall construct on behalf of the purchaser an apartment to be constructed by the developer on the Schedule A property. The vendor and developer shall convey the delivery and of the Schedule B apartment on or before September 2021 as per our schedule with RERA, subject to payment or encashment of the check first so issued by the purchaser. In case of any default by the developer, he shall compensate the purchaser paying interest at 2% per month of the amount remitted or paid till completion of 18 months as aforesaid, or thereafter pay rupees 19,18,982, whichever is higher. In the event the developer is not able to settle assured returns including margin money and outstanding loan amount to the banker against the said unit before 18 months with grace period of 6 months, purchaser shall have option to sell or transfer to external customer. Last point, my lord, the EMIs shall continue to be remitted by the developer alone as long as the loan subsists. That is one. My lords, next is 7.3 nalli ಹೇಳ್ತಾರೆ ಅವರು. 7.3, same page, my lords. The purchaser who have availed loan under the purview of no pre-EMI scheme from HDFC Limited need not remit any rents, rates, taxes or EMIs, etc. from the date of the first disbursement till time of completion of construction of the Schedule B apartment. It is very clear. ಈಗ ಅವರು they have defaulted, ಅಲ್ಲಿ completion ಆಗಿಲ್ಲ, ನನಗೆ ಸೇಲ್ ಡೀಡ್ ಮಾಡಿಲ್ಲ. Now they have stopped making the pre-EMI payment.
How do you say that you fall under this category?
ಯಾವ್ದು?
No pre-EMI.
In fact, that is the scheme under which they had made me to execute this.
That paragraph reads,
please.
Purchasers who have availed under the purview of no pre-EMI scheme from HDFC need not remit any rents.
Please, my lords. ಈಗ tripartite agreement. Please, my lords. Otherdo, that thing is brought in tripartite agreement. Annexure H, my lords. Annexure H, page 116. Namdu operative portion, my lords, is at 120, point number 4. 120, point number 4.
Yes.
The borrower is informed HDFC of the scheme of arrangement between borrower and builder in terms whereof the builder hereby assumes liability of interest payments under the loan agreement as payable by borrower to HDFC till 30/3/2020. ಅಲ್ಲಿ ಅವನು
No pre-EMI scheme.
Well, that is the scheme which was lured. That was the scheme which was lured to the purchasers, that is the petitioners before your lordship, at the time they executed the agreement to sell. ಇದೆಲ್ಲ agreement to sell ಆಗೋ ದಿವಸನೇ this is an arrangement which is made with the bank and the builder. ಅದೇ reason ಗೆ I have made even the bank and even RBI and NHB also as parties, my lords.
Now, what is your immediate grievance?
Immediate grievance is ನನಗೆ ಅವರು ಈ ಪ್ರೀ EMI ಪೇ ಮಾಡುವಂತ ನನಗೆ ಇದು ಮಾಡ್ತಾ ಇದ್ದಾರೆ and my loan account ಇದಾಗಿದೆ. So not to take any precipitative action till next date of hearing with respect to the loan account of the petitioners ಮಾಡೋದು ಆಯ್ತು. That is the interim relief which I am seeking before your lordships. Because ಅವ್ರ surfae as ಇದರಲ್ಲಿ ಆಮೇಲೆ ಚೆಕ್ ಬೌನ್ಸ್ ಕೇಸಸ್ ಇನಿಶಿಯೇಟ್ ಮಾಡ್ತಿದ್ದಾರೆ ನಾನು ಕೊಟ್ಟಿರೋ ಸೆಕ್ಯೂರಿಟಿ.
ರಿಸರ್ವ್ ಬ್ಯಾಂಕ್ ಆಫ್ ಇಂಡಿಯಾ
ಅಲ್ಲಿ ಏನಕ್ಕೆ ಮಾಡಿದೀನಿ ಅಂತಂದ್ರೆ
ಯೂನಿಯನ್ ಆಫ್ ಇಂಡಿಯಾ ಎಲ್ಲಾರನ್ನು ಪಾರ್ಟಿ ಮಾಡ್ತಿರಲ್ರಿ ನೀವು.
ಅದಕ್ಕೆ there is one reason
against them. Why do you want to make them parties?
Ali, the reason is this, my lords. In fact, there was a master circular which was issued by the RBI and guidelines which I have annexed at annexure A to E, my lords.
Notice. Please. To response number
1 to 6 minutes
and 4 to 6.
Please.
Notice to response number 2 and 3 is not necessary for the time being.
Please.
The petitioners are also permitted to serve take out hand summons to respond number 4. For respond number 5. 5 tane.
Please, my lord. HDFC is 5.
Release this matter on 29th of January. Full stop. Next para. In the meanwhile, office objections should be complied with.
Grateful, my lord.
32.
Petitioner minutes.
Yes.
For 2 days time, minutes will apply with all the officers.
A week's time.
In this, there is an efficacious remedy for that. To approach the district registrar. There is a delay in presentation of the document. There is a delay in presentation of the document. As per 23, within 4 months from the date of the execution.
Document.
This is a final decree proceeding. Any document that is to be registered.
Final decree?
Proceeding. MDB. For the registration, within 4 months, the document has to be presented to the what has happened is they have produced the document. The sub-registrar, based on the limitation, he has rejected the registration of the document execution. The lordship in section 25, your lordship. Provision where delay in presentation is unavoidable. He has to explain the delay before the district registrar. Then the district registrar, in his prerogative, will impose some fine or then direct the sub-registrar to execute.
What is Stamp Act?
Registration Act. Registration Act.
Section 25.
25. Provision that a delay is presented in presentation is unavoidable. If owing to urgent necessity or unavoidable accident, any document executed or copy of a decree or order made in India is not presented for registration till after the expiration of the time herein above prescribed in that behalf. The registrar in these cases where the delay presentation does not exceed 4 months may direct that on payment of a fine not exceeding 10 times the amount of the proper registration fee, such document shall be accepted for registration. Any application for such direction may be lodged with the sub-registrar, who shall forward the forwarded to the registrar to whom which is subordinate.
ಅವರೇ ಮಾಡಬೇಕಾಗಿತ್ತು.
Allah, they have to file it.
No. You read subsection 2.
Any application for such direction may be lodged. They have to file an application. This writ petition with this direction can be
Barkol.
My lords, it may be taken up tomorrow, my lords. I'll seek instructions.
Huh?
I'll seek instructions, my lords. Kindly have it tomorrow.
At the request of learned counsel for petitioner, release this matter on 27th of January.
Please.
33. For the respondent bank, my lord. Copy has not served and
Petitioner, your lordship. The only one office objection is the filing of separate IA for dispensation, your lordship.
there is alternative remedy, my lord. The challenge under this surface proceedings, your lordship.
You know?
Surface proceeding has been challenged. There is alternative remedy under the DRT.
20% I have already paid, your lordship. On 15th January 2025, I have paid 12 lakhs, your lordship, to the respondent bank.
What is the amount outstanding?
58 lakh 2,778. The outstanding amount.
Which
for the
document?
Annexure D, your lordship.
Annexure?
D.
My lord, this 13 lakh 90,000 is due
Page
as
number.
on today, my lord. If they pay that amount, their account has been regularized.
Huh?
13 lakh 90,518. If they pay, account will be regularized, my lord.
13.
13,90,518.
Already paid.
12 lakhs, your lordship.
12 lakhs after 12 lakhs, this is due, my lord, to
20%
to come out from NPA, my lord.
20% andre 11 lakh
You
60.
have taken instructions.
Yes, my lord.
Huh?
Yes, my lord.
They need to pay only another 13 lakhs.
13 lakhs 90,518. Today, it is for pay. It
Please
is
pay the amount and get the account regularized.
regularized, your lord.
How much?
13 lakh 90,518 as on today, your lord.
Will be the outstanding EMIs along with penalty. If you pay that much, your account will be regularized, and thereafter you can go on paying the regular.
Regularized EMI.
I need to seek instruction by my
Barkali.
from the clients, your lordship. Kindly have it on 25th.
Learned counsel for the petitioner submits that the directions
13
given
lakh
by this court on
90,518
17/12/2024 have been complied, and the petitioner has deposited rupees
12 lakhs.
12 lakhs with the respondent bank.
Yes, your lordship.
Full stop. Next para. Learned counsel for the respondent bank submits on instructions that if the petitioner were to pay rupees 13 lakhs
90,518 as on today, your lord.
90,000
518.
518 as on date, his account can be regularized.
Regularized.
Full stop. Next para. Release this matter on 5th of February 2025.
My lord.
Full stop.
My lord, after 7th, your lordship. 7th,
After?
7th, my lord.
On 10th of February.
Much of it.
Huh? In the meanwhile, if the petitioner were to deposit the said amount to regularize the account, comma, the petitioner shall be permitted to do so.
Please, your lordship.
Next para. The other office objection stands overruled.
My lord, the writ
Yes.
petition copy.
Interim order may be
Writ
kindly
petition
extended.
copy is not served, please, sir.
Kodri,
Already served. I'll serve.
learned counsel for the petitioner is directed to serve a copy of the writ petition along with annexures, and learned counsel for the respondent bank.
Interim order may be kindly extended.
Interim order granted earlier stands extended till the next date of hearing.
Much obliged.
34. N. Suresha. Appearing on behalf of the respondent, my lords. My lords, the writ petition itself is not maintainable, my lords. As an appeal lies under section 17 of the Surface Act, my lords.
Have they complied with the direction?
No, my lords, they have not complied with the interim order direction.
Matter is called out. There is no representation for the petitioner. Full stop. Learned counsel for the respondent bank points out to daily order dated 18/12.
Serial number 44, my lordship.
34. Where the petitioner was directed to deposit 20% of the outstanding amount due as on date, as on the said date, comma, within 4 weeks, comma, failing which it was directed that the interim order granted shall automatically stand vacated, and the respondent is at liberty to proceed in accordance with law.
Much obliged.
Full stop. Next para. learned counsels, ಅಲ್ಲೇ ಸೇರಿಸ್ಕೊಳ್ಳಿ. Learned counsel submits. ಅದ್ ಬಂತಲ್ಲ, has not complied with the banta. Learned counsel for the respondent bank submits that the petitioner has not complied with the directions issued by this court. Full stop. Next para. Consequently, the writ petition stands dismissed.
35, Sandhya U Prabhu.
Copy ಕೊಡಿ.
Lord, complied the conditional order, my lord, as directed by this
25%.
honorable court, my lord.
Huh?
I've complied, my lord. The conditional order was there, my lord.
1712.
Please, my lord. 5,35,000 pay ಮಾಡಿದ್ದೇನೆ. Filing the complaint.
My lord, copy also not served.
It was
And
sent
writ
by
petition.
process was
And
made.
as on today, there is a 1,03,58,366 is due, my lord.
Huh?
As on today, 1,03,58,366 is due, my lord.
ನೀವ್ ಎಷ್ಟು ಡೆಪಾಸಿಟ್ ಮಾಡಿದಿರಮ್ಮ?
5,35,000.
ಎಲ್ಲಿಂದ ಎಲ್ಲಿಗೆ? How will it be compliance of the directions? 25% of the outstanding amount.
My lord, ಅದರಲ್ಲಿ I have produced annexure, ink page 15 notice one. Ink page 15.
Copy ಕೊಡಿ madam.
Process ಕೊಟ್ಟಿದ್ದೇವೆ ಸರ್, ಬಂದಿರುತ್ತೆ ನಿಮಗೆ ಕಾಪಿ ಇದೆ ನನ್ನ ಹತ್ರ ಇರುತ್ತೆ, ಬಟ್ ನಾನು ಅದನ್ನ ಹತ್ರ ಕೊಡ್ತೀನಿ.
ಹಾ.
Lord, I have paid process and it was sent by post, my lord.
ಹ್ಮ್.
ಅವ್ರ ಕಾಪಿ ಕೊಡ್ತೇನೆ ಆಮೇಲೆ. Ink page 15, my lord.
ಹ್ಮ್.
21,36,890 son.
ಹಾ?
21,36,890.
ಹಾ.
That is outstanding.
My lord, there is a two
That is
demand notice.
outstanding.
Only one demand notice they have furnished by this honorable court. Another demand notice they have not furnished.
ಹಾ.
There is a three accounts, your lordship. One is the-
ಡಿಮಾಂಡ್ ನೋಟಿಸ್ ಅಲ್ಲ ಅದು. What is this?
This is a part of the demand notice.
ಹಾ?
Demand notice. Annexure A, demand notice. ಅದರಲ್ಲಿ ಅವ್ರದೇ outstanding, for what they had demanded, my lord, 21 lakhs, my lord. I've duly complied, my lord. Ink page, ಅವ್ರದೇ statement. Home loans one.
Please give him a copy of the petition.
Please.
My lord, there is a two demand notice has been issued. There is a one property, my lord, that is a home loan, another two OD loans. The OD loan demand notice also issued. There is a due as on today, including three loans is 1 crore 3 lakhs, after complying the 5 lakhs also, my lord. As on today, 1 crore 3,58,366 is the due, my lord.
ಎಷ್ಟು ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದೀರಾ?
ಆಲ್ರೆಡಿ 5 ಲಕ್ಷ. ನಂಗೆ ಯಾವ್ದು ನೋಟಿಸ್ ಬಂದಿತ್ತು ಸ್ವಾಮಿ ಹೋಮ್ ಲೋನ್ದಕ್ಕೆ, ಫಾರ್ ವಿಚ್ ಐ ಆಮ್ ಅ ಬಾರೋವರ್. ಅದಕ್ಕೆ ಬಂದಿರೋದ್ರಲ್ಲಿ ನಾನು 20% ಮೇಲೆ 5,35,000 ಕಟ್ಟಿದ್ದೇನೆ ಸ್ವಾಮಿ.
Your file ವಕಾಲತ್ is it?
Yes, my lord, I
Your
filed.
file ವಕಾಲತ್.
Yes.
Learned counsel for the respondent submits on instructions that the petitioner is liable to pay more than 1 crore.
1 crore 3,58,366.
1 crore 3 lakhs.
3 lakhs, my lord. 58,366 as in today, your lordship.
ಆಸ್ ಪರ್ ಮೈ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ನೋಡಿ ಯಾವ್ದನ್ನ ಕೊಟ್ಟಿದ್ದಾರೆ ಅದನ್ನ ನಾನು ಪೇಪರ್ ಅಲ್ಲಿ ಇರೋದನ್ನೇ ಹಾಕಿರೋದು ಸ್ವಾಮಿ. ಅವ್ರದೇ ಡಿಮಾಂಡ್ ನೋಟಿಸ್ 21 ಲಕ್ಷಕ್ಕೆ.
The two demand notice, only one they have furnished.
Stop. Therefore, it is submitted that even if the petitioner has deposited rupees 5 lakhs,
35,000.
Please. Comma, it will not be in compliance of the directions issued by this court on 17/12/2024.
No, it is
Full
in
stop.
compliance.
Next para, learned counsel for the petitioner, however, draws the attention of this court to annexure A, which is the notice issued under section 13(2) of the SURFACE Act, where the outstanding amount due is shown as 21,36,890, and accordingly 5,35,000 have been deposited by the petitioner which will be in compliance of the directions issued by this court. Full stop. Next para. Learned counsel for petitioner is directed to serve copy of the writ petition along with annexures on the learned counsel for respondent. Release this matter on 29th of January. Full stop. Learned counsel for the respondent is directed to place on record the information to show that the petitioner is liable to pay more than 1 crore as submitted before this court.
Yeah.
Interim order granted earlier stands extended till the next date. of-
Ma'am, request, third ಗೆ 3 ದಿನ ನನ್ನ ಕಾಂಪಿಟಿಷನ್ ಹೋಗ್ತೀನಿ. Third.
10th ಕೊಟ್ಬಿಡಿ ಸ್ವಾಮಿ. 7th I have inauguration.
ಆಯ್ತು. 10th of February. Yes.
Date level.
Much.
What is the office objections? In the meanwhile, office objections shall be complied with.
Greatly.
36, Abdul Ansar P. Number 36.
A week's time is granted to the petitioner for complaints of office objections.
Non-compliance, 8th time. Rajendra M.A.
For the respondent, Lordship.
No, we have completed the office objection, Lordship.
On the previous date of hearing, this honorable court had directed me to produce the interim order passed by the Dharwad High Court, wherein stay is granted in a matter identical to the present case. ಇಲ್ಲಿ alternative remedy ಇದೆ. DRAT ಇಲ್ಲಿ appeal ಹಾಕ್ಬೇಕಾಗಿದೆ. They have challenged the order before this honorable court. They failed to comply with the interim orders, and they have admitted their losses and inability to repay the dues. Previous state ಅಲ್ಲಿ
Yes.
ಧಾರವಾಡ ಹೈಕೋರ್ಟ್ ಸ್ಟೇ ಆರ್ಡರ್ ಪ್ರೆಸೆಂಟ್ ಮಾಡಕ್ಕೆ ಹೇಳಿದ್ರು. This honorable court have presented stay ಕೊಟ್ಟಿದ್ರು.
Because the coordinate bench has quashed the order passed by DRT on limitation to condone the delay. This was remanded.
That order has been stayed ಅಂತ ಹೇಳ್ತಾರೆ.
But ಇಲ್ಲ ನಮ್ದು ಇದು ಬೇರೆ, ಅದು ರಿಟ್ ಪಿಟಿಷನ್ ಅವ್ರು ಬೇರೆ, ಈ ರಿಟ್ ಪಿಟಿಷನ್ ಬೇರೆ.
Similar
section 14. Second 14, yes.
Orders
Yes, madam.
where it was held
Yes, madam.
that section 5 application
Is not-
filed
Yes.
can be considered anta. But that decision has been stayed.
Stay, please.
Hmm.
In fact, the Supreme Court has
But
also.
7 ಅಲ್ಲ,
Supreme
18
Court
ನಲ್ಲಿ
has
your
also
lordship.
held that
Section
delay
18
is
ನಲ್ಲಿ your lordship.
untenable. And the
Lordship.
surface proceedings. The full bench of the Patna High Court has also held that delay in filing essay section 17 application is not maintainable.
Anyway, you are not complied with the interim directions given by the tribunal.
Please.
That is but only on the delay. There is no order has been
No, no,
passed on
no.
the merits and question of
He
law.
has stated and I have recorded it,
And
that you are not complied with the interim directions given by the tribunal.
but partly I think you have complained, the property has also been sold. Some of the properties also the bank has sold.
What
But
do you
ಇಲ್ಲಿ
want now?
the limitation ನಲ್ಲಿ
Ah.
delay is condone ಅಂತ ಹಾಕಿದ್ದಾರೆ. Delay cannot be condone ಅಂತ ಮಾಡಿದ್ದಾರೆ. But even my lordship, if your lordship permit, section 18 ನಲ್ಲಿ we have to prepare appeal. Any order passed by the DRT under section 17 ಅಂತ ಇದೆ.
Anyway, there is no interim order passed in this matter.
No, no.
ಇಲ್ಲ.
You proceed then. You
Please.
proceed in accordance with law.
Yes, fine.
ಅಷ್ಟೇ.
Dismissal
But section
appeal.
Huh?
Our alternative remedy DRAT
No,
ಹೋಗ್ಬೇಕು.
ಹೌದ್ರಿ, there is no interim order passed by this
Sir.
court.
Please, please.
So you are free to proceed, you proceed. ಅಷ್ಟೇ. We will consider,
yes, ma'am.
we will
Section-
consider the matter on
Yes,
merits.
yes, section 18 ನಲ್ಲಿ ಒಂದೇ ನಿಮಿಷ your lordship. Section 18 says.
Not now, sir.
Yes.
When such orders which are already passed have been taken up before the division bench and such orders are stayed, what is the use of this court passing the same orders? And there is no interim relief given to you also.
Yes.
On the basis of facts also, our law submit
Learned counsel
ಮಾಡ್ಕೊತಾರೆ.
for
But
the
subject out from
respondent
the
bank
division bench. Matter may be taken up. Your lordship.
has furnished a copy of the order dated 16/4/2024 in writ appeal number 1008080 of 2024 at Dharwad bench, staying one such decision of a learned single judge passed in WP number 101238 of 2024. Full stop. Statement of objections may be filed by the respondent. Already filed. Statement of objections have already been filed at the hands of the respondent bank. Full stop. Matter requires final considerations. Yes.
Office objections we have complained, madam. All the office objections have been complied. Ain't it the office?
Startingly, learned counsel for the petitioner submits that office objections have been complied. Full stop. Office to verify.
Yes, ma'am.
Yes.
Order copy one. Order copy.
You please give a copy.
Please.
Xerox.
Xerox is there.
Please file it with a memo.
Please.
Yes.
Oblige, madam.
Yes.
Order serial number 38, P. Anand.
This case I am for the petitioner.
In respect of respondent number 3.
Respondent and 3 is the
application.
beneficiary of the land acquisition proceedings.
Non-filing.
I will file necessary application, 1 week time maybe.
Learned counsel for the petitioner seeks for a week's time to file necessary application regarding the implement of respondent number 3. Although the said respondent was not a party to the proceedings arising out of the impugned order. Yes. A week's time is accordingly granted.
39, N. Krishnayam.
For respondent.
So IA for further hearing and fix a short date, my lord. Fix a short date for next week, my lord.
I filed an application for early hearing, my lord. Date with, my lord. Lord, I filed an application under Order 7, Rule 11 before the Honorable Civil Court. My application is rejected. In fact, my lord, there is a compromise decree between the parties. Instead of filing an application before that Honorable Court which decided the compromise, they file a separate suit.
My lord, in this case, you are not challenging the decree, my lord. It is a separate this one, my lord. We are challenging the sale deed, my lord.
My lord, that issue has been settled, my lord, by this Honorable Court.
That it is clearly held in that order, my lord. I
will. But the date may fix, my lord. I'll go on with the matter.
Release this matter on 29th of January in the orders list. Full stop. However, the matter will be heard and disposed of finally. Yes.
My lord, interim order, my lord.
Interim order granted earlier stands extended in the next date of hearing.
Serial number 40, Kiran B.S.
Raise for a short accommodation. A short date may be given. A minor office objection is there. Just have to write the date here.
List this matter after service of notice on respondent number 3 to 6. In the meanwhile, office objection shall be complied with. Yes.
41, Harish M.G.
My lord, bank has furnished a statement, my lord, on 1/12/2024 itself, my lord. On last occasion, he has made a submission that bank has not furnished a statement of account that we have furnished on 1/12/2024 itself, my lord. And
112,
1/12/2024, man. At page number 3, my lord.
Huh?
At page number 3.
No, when did you file it before the court?
Court ಮುಂದೆ file ಮಾಡಿರಲಿಲ್ಲ. But we have furnished as per the direction of this honorable court, my lord, we have furnished a statement long back.
Without filing it before the court?
Honorable court has directed me to furnish a statement, my lord.
ಹೌದು.
ಅದನ್ನ ನಾನು on 1/12 itself we have given.
Without filing a copy before the court?
Court, I forgot to file a copy too. I apologize.
Learned counsel for the respondent bank submits that
My lord, this honorable court on wide order dated 2011.
statement of accounts showing the outstanding loan amount in terms of the directions issued by this court dated 10/1/2025 was furnished to the learned counsel for petitioner on 13/1.
15/1 we have one more time we have furnished on 15/1.
15/1/2025.
And prior to that also we have given. My lord, this honorable court has a pause and entry.
Where is that information?
He has acknowledged, the petitioner has acknowledged the receipt of the statement. That is at page number 1.
Is it so difficult for you to give a copy here to the court? Instead of doing all this exercise? Huh?
My lord, I can.
ಕೊಟ್ಟಿದೀವಿ ಅಂತ ಎಲ್ಲ ಹೇಳಿದಿರ ಇದರಲ್ಲಿ and there is no information. What is that information you have given them? It's not here at all.
My lord, you mentioned, I hear with
What is that information?
Statement of account.
ಎಲ್ಲಿದೆ? Where is the copy here?
We have given.
Nothing is there.
No, we have given.
Please give a copy to the court and serve it on the learned counsel for petitioner.
No, my lord, the petitioner has acknowledged for.
Please give a copy to the court, sir. Court also has to look into it.
I'll give a kindly give me a short date. I'll furnish it to the court, my lord.
Full stop. However, this court finds that no such information was placed before this court. Full stop. Therefore, learned counsel for the respondent bank is once again directed to furnish all that information before this court by the next date of hearing.
My lord, in the
while serving a copy once again on the learned counsel for the petitioner. Release this matter on 29th of January. Interim order granted earlier stands extended till the next date of hearing. Yes. In the meanwhile, steps shall also be taken by the petitioner for service of notice on response number 2 to 5. Yes.
42, V. Mohan.
For the petitioner, my lord.
Yes.
I am for the respondent number 2, my lords.
Number 1 of
I'm for respondent number 3 and 4, my lord.
Petitioner is a tenant in the premises, my lord.
Objections have been raised on IA number 1 of 2024.
It is a vacating.
Filed by respondent number 1.
Yes, ma'am. Tenant is a tenant petition, my lord.
You'll have to comply with the office objection, sir. What is the office objection? Copy not served on learned counsel for petitioner. Have you got a copy?
Copy not.
I have served I have got the acknowledgement. I have received the acknowledgement. I'll file it in the counter, my lord. Copy.
Copy ಕೊಡ್ರಿ ಅವ್ರಿಗೆ. ನೀವು acknowledgement ಕೊಟ್ರಿ ಏನ್ರಿ ಪ್ರಯೋಜನ?
I'll serve.
Give a copy.
I'll serve, my lord.
Learned counsel for respondent number 1 is directed to serve a copy of IA number 1 of 2024 on learned counsel for petitioner. And 1 of 2025. ಎರಡೂನು.
Interim order may be extended.
My lord, it's a tenant writ petition. There are 12 crores and order is there. They have taken stay with regard to entire surface proceeding cannot be initiated. by the borrowers. Again, he is just a tenant, my lord. In terms of the interim order,
You are only a tenant.
yes, my lord.
Yes, ma'am. Bona fide tenant, registered tenant. ma'am.
So,
It's my lease agreement valid till to 2028. ma'am.
maybe, but that property is already mortgaged to the bank.
Yes.
They will have first charge.
No, no, there is a RFA is
May
pending.
have
ma'am.
any dispute with the owner of the property, but that will not permit you to question the measures initiated by the
I
bank.
don't have any knowledge about.
My
that.
lord, may I submit, my
My
lord?
lord, in addition to that, they had approached the DRT.
My lord,
also.
may I submit, if my lordship permits, may I submit
Lord,
something, my lords?
Kindly
My lord,
peruse the
all,
page number, annexure H, my lord.
Learned counsel for the respondent bank submits that the petitioner contends to be a tenant
Yes, ma'am.
under the
In the surface and the scheduled property, my lord.
under the
my lord, may I submit for a while?
owner, who is in fact a borrower at the hands of the respondent bank. And the respondent bank has first charge over the secured assets. Full stop. Even if there is a dispute between the owner and the tenant, that will not preclude the bank from proceeding in terms of the provisions of the
But not to
Surface Act.
disclose us. means
My lord, may I
purchase the
submit for a
property.
while?
Yes,
Already
yes,
a
sir.
arbitration petition is pending, my lordship, before this court, in
Release
which
this
this
matter.
respondent number one is the party.
Release this
And
matter on 29th of January.
There is an already existing interim order.
Already
in
they had
surface,
already,
my lord.
they had already uploaded DRT also, my lord. They have filed a section 14, SA 14 under 17 A, my lord. Challenge the possession notice also.
That is a different
That-
cause of action. my
That,
lord.
even,
For preliminary hearing,
Interim,
with an understanding that the matter will be considered and disposed of on the next date of
the
hearing.
interim order may be extended.
Interim order granted earlier stands extended in the next date of hearing.
Much obliged.
Number 43, Ganapati Bhatt.
In this
Early
case, my
hearing.
lord, respondents has been
My
served.
lord, I'm accepting notice on behalf of respondent number
Already
2, my
copy
lords.
has been served
On the
them.
last date, I had
Kindly
made
see,
the same. I
copy has been
am
served.
accepting notice on behalf of respondent number 2, my lord.
In this case,
Respondent number 2 got notice
counsel
accept
see.
ಮಾಡ್ತಾ ಇದೀನಿ. Manu K, last date of hearing, I made the same submission, but it is recorded as I have undertaken for respondent number 3. Respondent number 3, my lord, should be by the AGA if I'm not wrong.
Counsel Sri Manu K. Why have you not filed wakalat?
My lords, I'm filing it today, my lords. I will just received now.
Submits that he has received the wakalat
Yes, my lord.
on behalf of respondent number 2, and the same will be filed in the office
one,
by tomorrow.
one submission.
My lords, and one more submission, my lords, for
Office objection is
Office
concerned.
to show the name of learned counsel Sri Manu K for respondent number 2.
Yes.
my lords, for 3, my name may have to be deleted, my lords. Last date,
Who appears
it
for
is
this 3?
3 should be a AGA, my lords. It's the e-procurement portal.
Learned AGA takes notice for respondent number 3 also.
Office objection insofar as annexure J is concerned, my lord, that is published by the respondent number 3 in the e-portal. Therefore, that publication that we have produced, which is, my lord, stated in my council note, that this is the available copy because they have not passed separate order. Under those circumstances that we have produced. If they have passed order, this is, my lord, that rejection of my bid, even after receipt of the, my lord, the EMI, the
Office objections are overruled.
kindly see here, my lord, my interim prayer which I have sought is
ಏನ್ರಿ ಬೇಕು?
ಒಂದು ನಿಮಿಷ ನೋಡಿ.
Huh?
ಒಂದು ನಿಮಿಷ interim order, ಒಂದು second, my lord.
It cannot be considered
ಅಲ್ಲ,
again, sir.
ಅಲ್ಲ, ಒಂದ್ ಸೆಕೆಂಡ್ ತಾವು ನೋಡ್ಬಿಟ್ರೆ ಆಮೇಲೆ
Yes.
kindly see annex, ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತ they have not till today, one second here.
Next matter, please.
ಅಲ್ಲ, one second, because
Not
they
at this
have
stage,
not,
sir.
ಅಲ್ಲ,
Can't go on making submissions again and again for interim prayer.
one,
That
no,
stage is
I
over.
have, because notice has
Yes.
been issued for a moment, my lord. ಇವತ್ತಿಗೂ ಕೂಡ they have
been
not
permitted to
allotted.
Go ahead. Yes.
ಒಂದು
Yes.
ಡೇಟ್ ಆದ್ರೂ ಕೊಡಿ ಸರ್, ಇಲ್ಲ ವಕಾಲತ್ ಆಗ್ತದೆ. Date may be fixed. I have moved before this court,
For what, sir?
my lord, to consider, because I have deposited 5,50,000. And my lord, my name has not been reflected by the respondents as a participant. And now they are allotting to the third
Whatever
party.
interim directions had to be given by this court when hearing you for, when the matter came up for preliminary hearing.
Yes, my lord.
Now again, I can't consider that one now
The
at this stage.
court has
Not
issued
possible,
notice.
sir.
Date
Yes.
may be fixed, my lord.
Yes.
Date may be given next week, any date may.
What, sir?
For consideration, otherwise dispose ಮಾಡಿ. In case, my lord, EMD amount is there with them. And my lord, that they have not even replied to us after receipt of money in time that we have paid. Therefore, my lord, whether.
Release this matter on 29th of January.
Please.
Yes.
Lord, serial number 44, Lords, the petitioners played fraud on the court. Lords, if Lordships, IA number 1 is concerned, it is for early hearing, my Lords. The matter is now anyway before your Lordships. May I just request your Lordships to take the statement of objections filed, my Lords. Lords, what happened? This petitioner, along with his family members, filed a civil suit. And the civil suits were dismissed. They filed a first appeal.
Civil suit for what?
Lord, civil suit saying that the property was partitioned and mortgage is created by only one member. We brought it to the notice of the court that he was the power of attorney holder of all other family members and he had created a mortgage. Suit was dismissed. Lords, they came before this honorable court in a first appeal. Learned senior counsel appeared on their behalf. Matter was argued at length when this honorable court expressed, if you only pay the money, I will extend some benefit. Otherwise, I want to dismiss the appeal. They filed an affidavit saying that you give me 4 weeks time, we are going to pay 10 crores. 50 crores is the outstanding amount. So filed an affidavit. They did not pay even a single rupee. Lords, the coordinate bench which was handling the RFA, Lords, vacated the interim order which was granted. Without even mentioning that this undertaking was given, without mentioning that the civil suits are dismissed, without even mentioning, my lord, that they had earlier filed a SA before the DRT, where possession notice was challenged, SA was dismissed, the DRAT, my lords, also dismissed the appeal. By concealing everything, they take a solitary stand before this honorable court, again saying that, though there was a partition again in the family members, the father has fraudulently created a mortgage and an interim order is granted. Kindly have a look at, my lords, this is, my lords, may just rely upon one judgment, my lords, of the Supreme Court, which essentially dealt with the same issue. Lords, of course, a very old judgment, my lords, even before Surface Act came.
Matter is called out. There is no representation for the petitioner. Full stop.
My humble request, my lord, I could not able to look into my lord, because my camera is something happened. Therefore, my humble request, my lord, what my learned friend stated, it is absolutely false. Because I have stated at para number 10, all the particulars I have stated, my lord.
Learned senior counsel Shri D.R. Ravishankar appearing for respond number.
Lords, respond number 1.
1. The secured creditor submits that the petitioner has concealed the fact that a suit filed at the hands of the petitioner was dismissed at the instance of the first respondent, and thereafter, during the proceedings in RFA before this court, although an undertaking was given by the petitioner that he would deposit
10 crores.
10 crores.
On or before 15th April 2024.
On or before 15th of April 2024. And when the petitioner failed to comply with such an undertaking, the interim order of stay, which was earlier granted by the court, was vacated.
On 16/4/24.
On 16/4/2024. Full stop. Here in this writ petition, a submission was made by the petitioner that Schedule B property was allotted to the share of the petitioner under registered partition deed entered into between the petitioner and his father. And his father has fraudulently mortgaged the property in favor of the respondent bank. Full stop. Accordingly, an interim order has been passed by this court. Full stop. Next para.
Lords, just one more sentence may I add, my lords.
Early, I am giving a date.
Lords, possession was taken because what he has stated here is that he is not yet dispossessed. This is again a false statement.
My humble request, my lord, my father's property, I have no objection, my lord.
At the request
I have
of
not
the
mortgaged,
learned,
my lord.
Counsel for petitioner, who has made submissions through video conference, release this matter on 29th of January 2025 for consideration of and disposal of the writ petition finally.
It's at the
Please.
stage of preliminary hearing, my lords. For
For
preliminary hearing. Lords, 50 crores we are required to recover, my
Yeah,
lords.
order
Yes.
bandru need to be.
Let it be in the stage of orders itself,
Orders,
please.
for orders, yes.
45, Kavita D.
IP for the caveat or yes, my lord, she has not served copy on me and moved
And
memo and
notice
got the
to my
interim
lord.
order.
I've sent notice, my lord, entire set to the respondent bank. I've paid PF, my lord. Here, the order was complete partly, my lord.
They were on caveat, isn't it?
I've served, I've
No.
intimated it was delivered to,
Huh?
through WhatsApp, I've served the copy of soft copy, my lord. After
Who,
that, I
madam?
have paid the PF also, my lord,
ಅಲ್ಲ,
along
ಯಾರಿಗ್
with entire
ಕೊಟ್ಟಿದ್ದೀವಿ?
set.
ಯಾರಿಗ್ ಸರ್ವ್ ಮಾಡಿದ್ದು? No, no.
All right,
my
learned
lord,
counsel for
I'll
the
furnish the proof, my
respondent
lord.
bank submits that she has not received copy of the writ petition, although a caveat petition was filed.
Please.
Full stop. What, have you complied with the directions?
No, she,
Partly complied, my lord. I've deposited 10 lakhs, my lord.
What is the outstanding amount?
1 crore 50 lakhs is there, my lord. OE is allowed and recovery certificate issued. That is challenged by same petitioner, got dismissed. Appeal, securitization appeal is pending before the DRT. It may be, your lordship kindly directed them to,
My lord, I supposed to pay 9,73,000 and 9,73,000. That is 25%, out of which I have deposited 10 lakhs. I supposed to deposit 25%, my lord. That is 18 lakhs 97,000 I supposed to deposit, out of which I have deposited 10 lakhs, my
On
lord.
what basis are you saying that?
My lord, and the redemption notice is annexure Q, my lord.
Huh?
And the redemption notice is annexure Q. That is, in that one, my lord, the outstanding amount is 89 lakhs. Out of 89 lakhs, 25% was ordered. Earlier, I approached Honorable Tribunal, my lord. Tribunal was ordered for me to deposit 19,47,000, out of which I have deposited 10 lakhs. Remaining 9,47,000 I supposed to deposit, my lord. Within 2 days, I'll deposit and I'll comply the order fully, my lord.
my lord, essay is pending. Later adjudicate there in a DRT, my lord, please. Same order challenge before this honorable tribunal, my lord.
This
please.
order to annexure N.
Yes, my lord. Page number 73. my lord. In page number 75, impugned order is there, my lord. 19,47,120 I supposed to deposit, out of which I have deposited 10 lakhs, my lord.
For recovery of 77,88,474.
Yes, my lord. That is
Huh?
annexure M, my lord.
Even if you take that much, what would be 25%?
19 lakhs, my lord.
Huh?
19 lakhs.
But the order is
19 lakhs.
outstanding amount due as of today.
As of today, I don't know, my lord, because they have not given me. As per this possession notice, 77 lakhs. I have deposited 10 lakhs. my
ನೀವು
lord.
ಅಲ್ಲಿ ಇಂಟ್ರಿಮ್ ಡೈರೆಕ್ಷನ್ ಅಲ್ಲೂ ಕಂಪ್ಲೈ ಮಾಡಲಿಲ್ಲ, ಇಲ್ಲಿ ಇಂಟ್ರಿಮ್ ಡೈರೆಕ್ಷನ್ ಇಲ್ಲೂ ಕಂಪ್ಲೈ ಮಾಡಿಲ್ಲ. What is the use then?
I have complied partly, my lord. 10
Essay
lakhs I have
523
deposited,
of
my lord.
24 is pending, my lord, same case.
10 lakhs I have deposited, they have taken,
17
my lord, that amount.
On 17/12/2024, the following order was passed. Extract ಮಾಡ್ಕೊಂಬಿಡಿ. Learned counsel for the respondent bank submits that the petitioner has not complied with the directions issued by this court. Full stop. Learned counsel for petitioner admits that the petitioner has deposited rupees
10 lakhs, my lord.
10 lakhs
10 lakhs DD I have deposited
with the respondent bank on
19th, my lord. Yesterday, my lord. Day before yesterday, I have deposited.
19/1.
21, my lord. Monday.
21.
Monday I have deposited.
21/2024 at 25. Full stop. this again will be after the period of 4 weeks granted by this court. Full stop. The petitioner is before this court aggrieved of the notice Yellama, what is annexure Q?
My lord, it was not.
Huh?
Annexure M, page number 72, my lord.
The petitioner is before this court seeking directions to the respondent bank to consider the representation given at annexure Q for consideration of one-time settlement. Full stop. Learned counsel for the respondent bank submits that the essay filed by the petitioner is still pending consideration before the tribunal, debts recovery tribunal. Full stop. Next para. In view of the non-compliance of the directions issued by this court and the fact that the petitioner is already before the debts recovery tribunal, comma, the writ petition stands dismissed.
48, Kavita N.
46.
46.
Appear for the respondent, bank, my lord.
Hide your-
Take notice and file power on behalf of the bank.
Learned counsel Shri
S. Lakshmi Narayana.
S. Lakshmi Narayana undertakes to appear for
Respondent, one respondent. 46.
the respondent. Have you complied with the directions?
She has complied here,
Huh?
complied and
What information have you placed on record?
may pass over here. Please.
My lord, they have deposited the 25%. My lord.
They have
Taken
deposited.
instructions, my lord. It can be posted for disposal.
Learned counsel for the petitioner submits that the directions issued by this court on 17/12/2024 have been complied. Full stop. Next para. At the request of learned counsel for the respondent, release this matter on 29th of January.
Please.
47, Gangadharappa C.
Paid the P of minutes, and
Huh?
also furnished the copies of the writ petitions, and I have paid the PF also. The interim order is complied minutes. I have filed the memo also.
$22,000.
Yes, minutes. The demand notice they have issued on, they have mentioned that the date of notice as on the outstanding amount is 81,160.
Huh?
Annexure A, the page number 11 minutes.
Learned counsel for the petitioner submits that a memo dated 15/1/2025 has been filed along with the copy of the receipt showing the deposit made by the petitioner in compliance of the directions issued by this court on 17/12/2024. Full stop. Learned counsel would also submit that he has taken steps. Yes, today. For service of notice on the respondents this morning. Yes. Full stop. Office to verify and issue notice.
Interim order maybe.
Interim order granted earlier stands extended till the next date of the.
48, K. Shashikant Prasad.
My lords, in 48, I appear for the respondent bank. My lords, the petitioners were directed to deposit 25% within 4 weeks, which got over on the 14th of January, which they didn't comply. Later, they have paid yesterday. My lords, yesterday, they have made the payment as per the interim order. My lords, it was not made in time. However, the petitioners have also approached this court earlier in another writ petition, which is also pending before this court.
Learned counsel.
My lords, Vignesh Shetty's name. Maybe.
Shri Vignesh Shetty undertakes to appear for
Respondent bank.
the respondent bank. Office to show the name of the learned counsel in the cause list. Next para, learned counsel for the petitioner submits that the petitioner has complied with the directions issued on 17/12/2024. Full stop. However, acknowledgement for having deposited the same has not been filed before this court. Full stop. Release this matter on 29th of January.
My lords, it may be
By the
tagged
next date of
along.
hearing, the petitioner shall furnish the acknowledgement for having deposited the amount before the respondent bank.
My lords, it may be tagged along with the pending matter in which they have challenged the very same order. My lords, it's WP number 19511 of 24.
19511
of 2024.
List WP number 19511 of 2024 along with this matter.
Very well. Because that interim order was not complied.
How can you file petitions after petitions like this?
The same section 14 order is challenged in both the petitions.
Yes.
Great. My lords, they may be directed to serve me a copy.
Learned counsel for petitioner is directed to serve a copy of the petition along with annexures on the learned counsel for the respondent.
Great.
49, Kavita N.
There for the respondent, my lord. The complaint, the order.
Same order.
In
Either
submission, my lord. In this
46, same order.
Please, my lord. They have complied it, but in this case, my lord, the auction is already taken place, my lord. So there was a directions of this court that it shall not be confirmed. Auction was completed. So not to confirm.
It will be
Maybe
listed
taken
on
up on
29.
27th.
27. 29.
Please.
Yes.
Number 50.
Copies may be directed to serve copies.
Yes.
Devi Prasad Shetty.
I appear for the respondent number 3, my lord. This is the conditional order passed by this honorable court subject to deposit 25% of the award amount for 13,38,000. Till today, it is not deposited.
They have not complied.
As per my instruction.
Matter is called out. There is no representation for the petitioner. Learned counsel, Shri Ramachandra R. Naik, appearing for the respondent, K-Waiter. K-Waiter respondent submits that the petitioner has not complied with the directions issued on 19/12/2024. Full stop. Next para. Release this matter on 29th of January. Full stop. If there is no representation for the petitioner on the next date of hearing, the writ petition will be dismissed. Yes.
My lord, liberty to, already we have filed the execution petition. We have filed the execution petition for execute the award.
Okay, next week we'll see.
Please.
Yes.
51.
Representing the petition counsel.
For
Nine.
respondent bank, my lord, in this matter, my lord, the sale was conducted and sale was confirmed and sale certificate is also issued. And possession also handed over to the auction purchaser before passing interim order.
Your lordship may
The
kindly,
interim order is not complied.
this honorable court has passed.
Interim order is not complied.
Your lordship may kindly, 19/12, this honorable court has passed an interim order.
Yes.
granted 4 weeks time to deposit 25% of
Yes.
the claim amount.
Yes.
We have communicated the order on 19th itself by sending an email, for which they did not send any reply. After 4 days,
ಏನ್ email?
interim order is passed with
ಹೌದು.
that was brought to the notice of the
ಆಯ್ತು.
ಆಯ್ತು.
ಹಾ.
Then he sent an intimation to the petitioner stating that action was conducted on 6th of December and sale was confirmed on on the day itself.
Yes.
And therefore we are not accepting any amount.
Yes.
Your lordship may kindly say absolutely there was no intimation to the petitioner with regard to the confirmation of the sale. And even it is very strange thing that auction sale and the date of auction sale.
Sir, why did you not deposit the amount?
Your lordship did not accept, they already sold the property.
Where is the information?
Information that.
What information is there?
Your
That,
lordship
you have taken a DD and in their name.
No,
you have sent it.
Your lordship.
Check ಎಲ್ಲ ಆಗೋದಿಲ್ಲ.
Your lordship
Not
kindly say we had 4 weeks time as per the interim order.
Correct.
passed.
When did you present the DD along with your
Your lordship may kindly
communication?
send the intimation.
What information do you have?
Lord, the sale notice is under challenge. My lord, before passing interim order, sale was.
No, let us see what steps they have taken for complaints of the order.
Even earlier also, my lord, writ petition was filed wherein also stay was granted. They have not deposited. Next second sale, after sale, my lord, this writ petition was filed and copy also not furnished, my lord, on the first date of hearing. And my name is also wrongly shown, my lord, but for
Your lordship
last
may
date of
kindly
hearing,
intimation sent to the
I was not
petitioner,
able to appear before.
which discloses that they have already sold the property and nothing is left for me to pay the amount. Your lordship may kindly see.
Sir, what is that you did
Your lordship may
to
kindly
comply with the
see,
directions?
just we have intimated
Barkole.
one submission. 4
Which
weeks
is
time.
that
with the-
previous writ petition?
Your lordship may kindly.
Previous writ petition, my lord, 21156 of 21.
211
56 of 21. 24.
of 2024.
Please.
One
Do
submission.
you have the details as to when the interim order was passed?
Yes, yes.
When that writ petition was dismissed?
That was not dismissed, my lord. That was pending.
It is still pending.
Still pending and there was interim order is not complied.
Your lordship may kindly see,
lord,
there
this-
was one proposal for one-time settlement.
That copy
They
is not
called
there, my
upon
lord.
the petitioner to.
Other copy ಇಲ್ಲ. But ಇದು auction ಆಗಿದ್ದು confirm ಆಗಿದ್ದು and sale certificate issue.
Allah, when interim directions were issued in that matter,
That date, my lord, I'm not.
you don't know.
That was not complied.
One
my lord.
submission.
It's
your
Still
lordship.
pending.
Learned counsel for the respondent bank submits that the petitioner has not complied with the directions issued by this court on 19/12/2024. Full stop. Learned counsel would further submit that the petitioner had earlier filed WP number 21156 of 2024. Where similar interim order of stay was granted by this court, subject to the petitioner depositing rupees 1 crore on or before 19/8/2024. Full stop. The petitioners have not complied the said directions issued in the said writ petition also. Full stop. Next para. Learned senior counsel appearing for the petitioner, however, seeks to submit that the petitioner sent a communication to the respondent bank. ಕೊಡಿ.
ಕೊಟ್ಟಿದ್ದು.
ಇದಾ?
ಅದರಲ್ಲಿ ಕಮ್ಯುನಿಕೇಶನ್ ಬಗ್ಗೆ ಅವರೇ ರೆಫರೆನ್ಸ್ ಆಗ್ತಾರೆ. ನಾವು ಕಮ್ಯುನಿಕೇಶನ್ ಬಗ್ಗೆ ಅದ್ರಲ್ಲಿ ರೆಫರೆನ್ಸ್ ಇದೆ. ನಾವು ಕಳ್ಸಿದ್ದು ರೈಟ್ ನೋ ಐ ಡೋಂಟ್ ಹ್ಯಾವ್. ಅದರಲ್ಲೇ ರೆಫರೆನ್ಸ್ ಇದೆ. ಇಂಟಿಮೇಶನ್ ಇಸ್ ವಿತ್ ಮೀ.
ಇದು ಅವ್ರು ಕಳ್ಸಿರೋದಾ?
ಅವ್ರು ಕಳ್ಸಿರೋದು ನಮಗೆ.
ಅವ್ರು ಕಳ್ಸಿರೋದು.
6ನೇ ತಾರೀಕು ಆಕ್ಷನ್ ಮಾಡಿ 6ನೇ ತಾರೀಕೆ ಸೇಲ್ ಕನ್ಫರ್ಮೇಶನ್ ಮಾಡ್ತಾರೆ. ಪ್ರಾಪರ್ಟಿ ಇಸ್ ವರ್ತ್ ಅಬೌಟ್ 19 crores. They sold it for 10.5 crores. Even now, I make a submission before your lordship that we are prepared to deposit the bid amount. We are very prompt in that.
Sir, you have not complied with the directions
Your
issued in
lordship,
the earlier
there was no opportunity for me to comply. There was 4 weeks time for me
ಏನ್ ಹೇಳಿದೆ?
comply the order.
On 19/12/2024, regarding the orders passed by this court. Full stop. However, the respondents have sent a communication on the very next day stating that the sale notice was issued on 30/10/2024 and e-auction was scheduled on 6/12/2024. And sale certificate has been issued in favor of the successful bidder on 18/12/2024. Next para. This, however, will not preclude the petitioner from complying with the directions issued by this court. Full stop. Next para. Release this matter on 29th of January along with WP number 21156 of 2024. Yes, please. 52.
My lords, in serial number 52, I am representing R3, my lords.
In the
My lords,
meantime,
I have-
interim order may be extended.
Yen interim order, sir, you are not complied. How can I
Your
extend?
lordship, they did
You have not complied with the directions.
Your
How
lordship,
can I extend? Not
one
possible.
submission, madam. When
Yes.
they,
52. Yes.
Serial number 52, I appear for the.
Huh?
My lords, serial number 52, I am representing respondent number 3. I have been served copy only of.
One nimsha. Huh? Huh? ಏನಾಗಿದೆ ಅದು? I have given a date. It will come on 29th. You please come. Yes.
My lords, one small submission, my lords. I am representing R3 in this matter. I have been served the copy of the stay order only. I have not served with a copy of the petitioner or annexure. Nothing has been served upon me. Kindly, the petitioner may be directed to furnish the copy of the petition along with annexures to R3, my lords.
We have paid, PF.
List the matter after service of notice on respond number 4. Full stop. In the meanwhile, learned counsel for petitioner is directed to serve a copy of the writ petition along with annexures on learned counsel for respond number 3.
Yes, my lords.
All right.
53, interim order.
Interim order granted earlier stands extended in the next date of hearing.
53.
Lord, in this
My lord,
matter,
I am for the petitioner. I have not complied the interim order, my lord. Liberty may be given to approach DRT because I am a tenant,
for-
my lord.
further in this case, my lord, the petitioner is neither a borrower nor a guarantor. My lord, he is claiming that he is a lessee under the lease agreement dated 4/9/2014.
Learned counsel for the respondent
And my
and
lord,
submits that the petitioner is neither a borrower nor a guarantor.
guarantor, my lord,
Full stop. However, the petitioner claims to be a tenant
Tenant.
claims to be a
Lessee.
tenant.
under the
Scheduled promises.
Tenant in the scheduled premises.
Lord, when the 2013, when we initiated the measures, my lord, he approached this honorable court and has taken the status quo in the year 2017. 2024, my lord, he dragged, although he dragged the issue, 2024.
This is Srimati Geeta Venkatesh.
Yes, my lord, this is the order.
Kodi, the order.
10/1/2017, a status quo was ordered by this honorable court in that writ petition for the measure initiated under the provisions of the Surface Act. My lord, thereafter, my lord, this matter was listed for complaints office objection. This office objection was not complied.
Council
7 years, this matter has been dragged.
has also pointed out too. An order dated 8th of November 2024. Writ petition number 1269 of 2017 filed by the petitioner.
Claims to be a tenant. 7 ವರ್ಷ drag ಮಾಡಿದ್ದು.
My lord, here owner is absconded, my lord. Till today, I am in possession, my lord.
And this is the writ petitions. They are telling that they are the tenants. The lease is for 3 years. That too, after the mortgage, my lord, my loan is in the year 2006, measures have been initiated in the year 2012. Not even a single rupee has been recovered, my lord, from the order granted by this honorable court status quo order. My lord, when
A writ petition filed by the petitioner was dismissed on 8th of November 2024. But the petitioner has enjoyed an order of
status quo,
an order of status quo
which was granted on 10/1/2017
for nearly 7 years.
7 years. 7 years. My lord, again, the petitioner is before the court, my lord, on a fallacious ground.
Learned
This
counsel
has
would
to be
also
dismissed on
submit
cost, my lord, in this matter.
that the petitioner has not complied with the directions issued by this court on 20/12/2024, where the petitioner was directed to deposit 25% of the outstanding amount due within 4 weeks from the date of the order, failing which it was directed that the interim order granted to automatically stand vacated and the respondent bank would be at liberty to proceed in accordance with law. Full stop.
Taken as
Next
granted.
para.
This honorable
Learned
court.
counsel for the petitioner fairly concedes that the petitioner has not complied with the directions issued by this court. Full stop. Next para. Consequently, the writ petition stands dismissed. Yes.
My lord, I am permitted to proceed in accordance with law in this matter. my lord.
Of course. ಅದಾಗ್ಲೇ ಆರ್ಡರ್ ಆಗೋದು.
Sir, ಇದನ್ನು ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡಿಲ್ಲ ಈ ರಿಟ್ ಪಿಟಿಷನ್, ಇನ್ನೊಂದು ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕೊಂಡು ಬಂದಿದ್ದಾರೆ ಇವಾಗ. ಕಾಪಿ ಕೊಡಕ್ಕೆ ಕೇಳಿಟ್ಟಿದೀವಿ ನಾವು, ಕಾಪಿನೂ ಕೊಟ್ಟಿಲ್ಲ ನೀವು.
All right.
Before Anif MH.
Matter is called out. There is no representation for the petitioner. This court had passed the following order on 24/12/2024. Extract ಮಾಡ್ಕೊಂಡು. Next para. No information is placed on record to show compliance of the directions issued by this court. Full stop. Next para. Consequently, the writ petition stands dismissed.
Vinay Kumar MD.
For petition in this case, my lord. I complied with the directions, my lord.
55.
55.
I appear for the respondent number 10, my lord. Bank. Here what happened, my lord? This loan was sanctioned in 2002. This scheduled property was mortgaged to the bank in 2003.
No, my lord, it is not a case. Dena finance, sir.
Oh, sorry, my lord, 55.
Huh?
In this case, my lord, the outstanding amount is 3,46,000, my lord. The honorable court directed me to deposit 1,50,000. I have deposited before I have taken the steps, my lord. Yesterday, I have taken the steps, my lord. The remaining office objections are there, my lord. I will comply within a week, my lord.
Learned counsel for the petitioner submits that a memo dated 17th of January 2025 has been filed along with a copy of the deposit challan showing that the petitioner has deposited rupees 1,50,000 and complied with the directions issued by this court. Full stop. Learned counsel submits that steps have also been taken
Taken, my lord.
for service of notice on the respondent this morning,
Yesterday, my lord.
yesterday. Full stop. Office to verify and issue notice. Next para. Interim order granted earlier stands extended till the next date appears.
Hearing implicatory application.
Yes.
Application for 7 Rule 11 came to be rejected, which is why the present suit for bare injunction. I am the defendant appellant before your lordships. The plaintiff alleges that I was present on 19/5/2019, for which he also files a criminal proceedings.
Issue notice to the respondent.
My lords, if your lordships could
Notice have-
peruse
notice has been
one
issued.
line of the plaint, my lords, one line at page number 77.
Huh?
One line of the plaint, my lords, page number 77. He has demolished the structure. For that, very rudely he taunted at the plaintiff by saying that I can
Are
do
you
what?
reading?
First paragraph, my lord, page number 77. I can do whatever I like. It is my father's property. So the defendant had already said it is his father's property. A suit, when I've already claimed that it is my father's property, a suit for bare injunction would not even be maintainable. He'll have to seek declaratory reliefs. Kindly see page number 80 is the prayer minutes. He's only sought for permanent injunction.
Sir, he said in paragraph number 3, the plaintiff has purchased the suit schedule property for a valuable consideration.
My lord, that is
from one street so
disputed
and
by,
so and so.
that is disputed.
That statement what you read
Please, my lords.
is an extraction of what you stated.
Is what I have
That cannot
stated.
be an admission. Issue notice to the respondent. Yes.
Grateful. my lords.
Ipana. 3R.
Therefore, respondent number 10 in this. Just come
Yes.
on to the last occasion. Petitioners may kindly be directed to serve a copy of the petition and.
Respondent 10.
I prefer respondent number 6.
New Year, my lord, I appear for respondent number 10 here, my lord. This matter is pending for last more than 20 years. This matter, that loan was sanctioned in 2003. And property was mortgaged in 2003. And that, my lord, then 2008, this honorable court, that bank filed the OA before the debt recovery tribunal. OA was decreed in 2018. When the OA was filed, then this borrower is 1, 2, and 3. Then that all family members started partition suit. That partition suit and all that bank filed an application stating that that is not maintainable. This honorable court, without any mentioning the reason, that dismissed it, stating that I have got the jurisdiction to try. Now, my lord, this matter, now that recovery certificate of decree issued the sale proclamation. Against sale proclamation order, this writ petition has been filed. And my lord, these are all my lord, just to protect the recovery proceedings, all the steps are taken now.
May I just?
Now, my lord, that bank is 22 years now. Earlier it was decreed for 1.4 lakhs. Now it has become the 2 crores.
May I just clarify this,
Person.
my lords, subject to what my learned friend says. Kindly have a look at the cost title, my lords. I'll just take your lordships to the cost title and take your lordships to the judgment. Lords, they are re-agitating the matter after participating in the civil suit. Civil suit is already decreed. Now they wanted to again go against the decree of the civil court and wanted to raise a contention. Now, second respondent, GM Manjunath, creates a mortgage. He is in no way concerned with this property nor with the family. Then a suit for partition is filed in OS number 58 of 2008 at page number 15. Sixth respondent is the bank. Ali, manager, Canara Bank, Sheshidripuram, Shumaga City. They are the bank. Notice this, if your lordships were to see Savita, Vanita, Vidya, Soumya, they are the petitions before your lordships. Geeta Shivkumar, third respondent is GR Manjunatha. No, it's not GM Manjunath. GM Manjunath is son of GC Murigappa. This GR Manjunatha is GM Renukappa, who is the original owner of the property. Now, this suit is decreed after participation by the bank at page number 27.
This GM Manjunath.
GM Manjunath is not concerned with this family. Bank has accepted a mortgage by GM Manjunath in respect of the property which never belonged to either Murigappa or which belonged to Manjunath. So bank initiated proceedings after the suit was filed saying that this is default, so on and so forth. Bank was also implemented in the suit because they wanted to claim a right in the property. Bank filed its objections, page number 15, my lords, and then page 27, there is a decree. Plaintiff and defendant number 5 together are entitled for their half legitimate share in the suit properties by metes and bounds. Defendant number 1 to 4 are together entitled for the legitimate half share in the suit schedule property by metes and bounds. So the property under the decree of the civil code with the participation of the bank has already been decided.
And defendant number 5.
Defendant number 5, may not see one more daughter.
So other half goes to defendant number 1 to defendant number 4.
1 to 4. This decree aito. Next final decree, which was initiated, in that this GM Manjunath has filed an application for impleading, which is apparently at the instance of the bank. The reason why he comes to be impleaded, in this is, they wanted to initiate prosecution against him saying that he's done this and that the arrest should be caused because of this. So page number 60, page number 92. GM Manjunath. Parties to IA number 1. And the daughter Leela. Both of them filed IA numbers 1 and 2. Now that application is allowed before the final decree court. So final decree is still pending. But once the rights of the parties are decided, there is nothing to be adjudicated because the bank is a party to these proceedings. Now the question is this, Milords, when there is an order by the competent court that to which the bank is also a party, can they circumvent the decree of the court by taking recourse to surface proceedings or DRT proceedings? Page 25, if your lords were to see, my lords. Page 25. This is very important because para 24. In fact, the senior manager of the 6th defendant is examined before this court as page number 25, my lords, in this, which is part of the judgment in OS number 58 of 2008.
Paragraph?
Paragraph number 24. In fact, the senior manager of the 6th defendant is examined before this court as PW2. This witness during the cross-examination has admitted that the suit property is a joint property belonging to plaintiff 1 to 4 and defendants 1 to 4. In fact, the bank authorities are claiming that property has been mortgaged by when one Manjunatha has availed the loan. Not having conceded to all the claims which is put forth by the petitioners before the trial court, permitting a decree to be passed. Final decree proceedings is in progress.
Paragraph 25, Odi.
Lords, Sarvamangalamma has executed a GPI in favor of Manjunatha, thereby has mortgaged the suit property by depositing the title deeds. In fact, when the suit scheduled property is a joint family property belonging to deceased Sachidananda and Renukappa, Sarvamangalamma had no manner of right whatsoever to execute either GPI or deposit the title deeds in the 6th defendant bank. The loan transaction, whatever has happened in between Manjunatha and bank authorities, is definitely not binding on the rights of the plaintiff and defendant number 1 to 4 or the suit scheduled properties. This finding has become final.
My lord, this.
You did not challenge this?
Not yet.
Oh, that, my lord, this before that original suit, they filed an application stating that they have mortgaged the property, and because they are the owner of the property and all, that application was rejected on the ground that the court has got the jurisdiction.
Yeah, early application.
And before original suit, when they file original suit,
now there is a judgment.
And now the judgment, my lord, judgment, not whatever share they got, bank has got the right to enforce that share.
Yaar bedo. That person who mortgaged has no share here.
No, he has filed an application for impleading that. He has also, Manjunath has filed an application for impleading, my lord.
Nothing, by that nothing will happen.
No, that it may kindly post it for another one day.
You have suffered a judgment.
My lord, one day just.
Not even challenged it. What can be done?
That partition suit that bank has not challenged, that is true.
There is a decree, sir. There is a finding against you.
Against me, my lord, that
Some Manjunatha has mortgaged it who had no rights
no,
over
my
the
lord, that
property.
who is Manjunatha, my lord, just give me 1 day time, my lord. I'll tell that who is.
Kuntala.
No, other was the like.
Paragraph number 25 ಅಲ್ಲಿ
24 now.
25 years.
one Sarvamangalamma,
Ni-
it appears has executed a power of
Power of attorney.
in favor of this Manjunatha.
Manjunathe.
Sarvamangalamma herself had no right over the property, and from where will this Manjunatha get the right to mortgage the property?
It is me 1 day time, your lordship may kindly give 1 day time, and day after tomorrow, I'll just submit people. It's only one clarification that I'll submit.
But there is a concept called as issue estoppel. Once between the parties, if findings of fact is recorded by the competent court, for all further proceedings before whichsoever authority, those findings are binding against the parties. So Hope Plantations, 2018 Supreme Court. I guess.
Learned Senior Counsel, Shri D.R. Ravishankar, appearing for the petitioners, has pointed out from Annexure A, which is a judgment decree passed in OS number 58 of 2008, declaring that the petitioners herein, who are the plaintiffs in the suit, have half share in the suit scheduled property. Similarly, it has been decreed that dependents number 1 to 4 also have the remaining half share in the suit scheduled property.
Lords, that is respondent 4 to 7 in the writ petition.
Anyway,
Not-
dependents.
I-
More importantly, it is pointed out that the respondent bank is dependent number 6 in the suit, and the contentions raised by the bank have been negated in the judgment. Full stop. It is submitted that although the bank has suffered such a decree, it did not prefer any appeal challenging the judgment and decree, and therefore the judgment and decree passed in the year 2014 has become final.
My lord, one second, my lord.
Expera. At the request of learned counsel for the respondent bank, release this matter on 29th of January.
Yes, my lord. That Manjunatha has already filed RFP. This is pending before the honorable court, challenge the judgment. Anyway, I'll put up, my lord.
But meanwhile, they may be permitted to have a copy of the petition.
I'll serve it on my learned friend.
29th, I'll submit, my lord.
Interim order granted earlier stands extended till the next date of hearing.
Lords.
Yes.
Serial number 58. Balagangadhar GS.
For respondent, my lord.
My lord, the petitioners, my lord, their houses are getting damaged by the
Before-
blasting work.
Before they continue, my lord, one submission. They have filed an IA, my lord. I have taken instruction, but I will file written objections to this, my 27th maybe, my lord. IA they have filed, my lord.
My lord, for
27th,
My lord,
I'm
I-
not asking for a long date, my lord. 27th.
one submission, my lord. Your lordship may kindly peruse the earlier proceedings. There, my lord, the blasting work which is taken up by the project, my lord, and the contractor, my lord, is damaging our houses. We gave many representations. Then, my lord, this honorable court directed, my lord, report from the Tahsildar. And Tahsildar has also submitted a report that, my lord, our houses are getting damaged. Now we have sought for a mandamus, my lord, let them preserve properly our property. In fact, my lord, this is before this honorable court. In fact, my lord, the learned AG has already submitted. Your lordship may kindly peruse, my lord, our homes are getting damaged. This was in
On
pursuance,
instruction,
my
I am
lord,
submitting, my lord. I'm
in
sorry.
pursuance of, my lord, earlier order dated 24/4, my lord. Tama
Already
predecessor order ಮಾಡಿದ್ದು.
This petition was filed
Please,
in February 2023.
please, my lord.
What interim relief did you seek?
My lord, now, my lord, in spite of this,
Baga. No, you didn't seek any interim relief. is it?
we sought the interim relief.
Ah.
Then, my lord,
And it was granted?
No, man.
no.
Then, my lord, what has happened, my lord? The government was directed, my lord, whether permission is granted. They submitted, no permission is granted. Then, my lord, Tahsildar is directed to submit a report, spot report. Then they did not do anything in the meanwhile. Again, they have started, my lord. In fact, series of other writ petitions are also before this honorable court, my lord. Similarly,
Number code.
please, my lord.
My lord, on
My
instructions,
lord,
I am submitting.
35,682 of 24 and 35.
List work out today, we will call all those matters.
Please, my lord, please. In the meanwhile, my lord, they may be directed not to precipitate further, my lord.
How can they do it if they have no license, sir?
My lord, after
How can you do it without license?
reasons, and they have taken permission.
ಇಲ್ಲಿ ಲೈಸೆನ್ಸ್ ಇಲ್ಲ ಅಂತ ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ ಕೋರ್ಟ್ ಮುಂದೆ ತಾವು ನೋಡಬಹುದು 23/4/24 ಅಲ್ಲಿ.
With regard to that, I don't have any instructions, my lord.
23/4/24 ಆರ್ಡರ್ ಶೀಟ್ ತಾವು ನೋಡಿದ್ರೆ
My lord, it is a government
ಆರ್ಡರ್
company.
ಶೀಟ್ ದಟ್ ಮೇ ಕೈಂಡ್ಲಿ ಬಿ ಪೇರ್ ಯೂಸ್, ಮೈ ಲಾರ್ಡ್.
It is a government company, my lord. Vishweshwaraya Jala Nigam, my lord. My lord, without permission of this one, we will not do. That is there, my lord. Vishweshwaraya Jala Nigam.
Please.
Respondent number 4 and 5.
For digging the
My lord,
canal
it is for the
irrigation
drinking
canal.
water. This is for the
Irrigation
drinking
canal.
water purpose, my lord.
Irrigation canal, they are doing the blasting work.
My lord,
Now, my lord, on 23/4/2024, order sheet may kindly be perused, my lord. There was the question by this honorable court that, my lord, learned AG on instruction seeks to submit that no permission for undertaking any blasting work is given to respondent number 6. This is what, my lord. Therefore, my lord, statement
my
of objections are an affidavit by the person who is alleged to have granted such license. Now, my lord, DC says that, my lord, he has granted the license. Again, he has extended the same, renewed the same. Now, my lord, therefore, report was, my lord, in fact, my lord, the government ought to have.
It may be a wrong instruction because
Please.
it is not respond number 6. It is respond number 4 and 5, who are government entities,
No, my lord.
who are seeking to do this.
My lord, they have delegated.
Not be any permission in favor of respond number 6.
No, my lord.
He is only undertaking the works on behalf
Works
of.
on behalf
Yes, my lord. That's why, my lord, my submission is respondent number 6 has been allotted that work, my lord.
So how can there be permission in respect of respond number 6, sir?
But my
Permission will be granted to respond number 4
yes, my
and
lord.
5.
That's why,
Why he is saying, we have permission to do that.
please, my lord.
my lord, I am not saying that they are not being given.
If it's a government entity and they are
Without permission.
wanting to do some
Please.
activity for the benefit of the people,
My lord, I know
how
my,
can you
my lord.
cause any objection like this?
my lord, I know my limitations.
Perfect.
But, my lord, let them, my lord, take all the
There is
precautionary
counsel
measures,
for
my lord.
response number 4 and 5. Submits a copy of IA number 1 of 2025 has been
Received.
furnished to the learned counsel
Please, my lord.
only today,
No, my
No, my
lord.
lord.
2 days back, I have
2 days
received.
back.
2 days ago. And he would like to go
File
through
me.
the
Please,
application and seek instructions and make submissions. Full stop.
Connected
Release
matters.
this matter
My
on
lord, along with
29th
other
of
connected matters. Along with, I will given a list also.
list WP number so and so along with this matter.
Please,
Yes.
much. My lord, in the meanwhile, my anxious submission is if the government wants to place any reply to this. my lord,
Our government ಮಾಡ್ತಾರ ಅವರು, they will take all precautionary measures. Why are you
Now
causing
also we have
obstructions like
taken,
this?
my lord.
obstruction.
If
ma-
it is an activity done for the benefit of the general public,
Yes, my lord.
you should not cause obstructions like this.
Definitely.
On
my lord.
instruction
I know
and
my
submit.
limitations. my lord.
On instruction and
All that you wanted to say
Safeguard
was,
our interest.
please direct them to take
Yes, my
appropriate
That's my prayer.
precautions ಅಷ್ಟೇ.
Please.
Then we can dispose of the writ petition.
Then that also matter may also be kindly be taken up for consideration.
All right,
Together.
let it come up on 29th.
Please,
Please,
Please get the permission that you have taken.
Please, ma'am.
We will dispose of the writ petition.
Please, my lord.
Yes.
Much.
Matsudan,
Appear for the pleading applicant. For petition, I need 2 weeks time,
Huh?
2 weeks time.
For?
Files, for objection. Application filed by the proposal.
I have sought to include myself as a party respondent. My lords, this is a industrial land, my lords, where KIDB has executed a lease deed. They have handed over the possession as well. Possession certificate is issued. Now they
No
are not,
interim orders?
my lords, there's another connected matter.
No interim direction?
In this matter, there is no interim order. There was a lease deed which was executed in the favor of the petitioner herein that came to be cancelled. Subsequently, they have filed a petition, my lords. In that petition, my lords, this petition and that petition were to be tagged together. That petition is not listed. Both the petitions, my lords, are to be listed.
ತಗೊಳ್ರಿ ಅದು. List this matter along with the WP number
144
number
double four double.
14400
of 2024, comma, on 29th of January.
Please,
Yes.
I'm grateful.
Serial number 60. Jindra,
Yes.
The impleading application notes.
Huh?
Objections are ready, my lords. I will file the registry. They have filed four IAs.
For amendment,
Amendment and yeah, 1 to 5, 2 to 4 of
temporary injunction.
please.
ಹಾ,
Tamil issue not to change the cause.
ಇದಕ್ಕೆಲ್ಲದಕ್ಕೂ objection ready ಇದೆಯಾ?
Ready there, ready. Main object in ready, in petition.
You are appearing for whom?
Impleading application, applicants.
Your application has not been allowed still.
Already allowed, my lords, by an order.
Application is allowed.
Then why are you calling yourself impleading applicant? What is your number? Implead ಆಗಿದ್ರೆ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ ಹೇಳ್ರಿ. ಆಗಿಲ್ಲ.
By an order dated.
Huh?
12/3/23, my lords. Respond number 6.
12/3/2023.
2023.
Huh?
2023. The application came to be allowed, the impleading application.
12/3 na?
Alla, 12/12, no, sorry,
12/12.
12/12/2023.
ಅಮೆಂಡೇ ಮಾಡಿಲ್ರಿ ನೀವು ಕಾಸ್ಟ್ ಟೈಟ್ಲು?
Permitted to amend.
Huh?
I'm permitted to amend the cost.
ಮಾಡಿದ್ದೀರಾ? You are
Petitions.
Yoganandachar.
Please.
Yoganandachar and NB Vedamurthy.
Yes.
Huh? But amended cost title ಹಾಕಿಲ್ಲ. Please file amended cost title.
2 days time.
Learned counsel for the petitioners is directed to file amended cost title. By the next date of hearing.
Please.
Next para, learned counsel for the newly impleaded respondent submits that objections to IAs
IA 1 to 5.
1 to 5 and objections.
1 to 5 are ready.
Ready.
Full stop. Learned counsel is requested to file the same in the office while serving a copy on the learned counsel for petitioner and the learned counsel for the respondent KDB.
AG.
KDB ತಾನೆ?
ಇಲ್ಲ.
Huh?
Date of KDB.
Learned AGA.
AG.
Yes. Release this matter on 29th of January.
Please.
61. Venkatarama Reddy L.
I for the petitioner. Unless earlier the writ petition was filed challenging the proceedings initiated under section 54 of the Forest Act. Annexure K, and was challenged, notice. Unless this honorable court on in the writ petition on 20/12/2023 granted interim stay of disposition. Unless in spite of pendency of this writ petition and there is a stay, the Forest Authority has passed the final order in section 64A Act. That has been challenged now in the IA. Unless IA, now earlier position was
Petition is still pending.
same petition, this petition only.
Huh?
This petition only. I challenged the notice issued under 64A and this honorable
Annexure K andra ನೀವು?
annexure K in the writ petition. Now present annexure R in the IA. Annexure K,
Page number?
page number 68.
ಅಲ್ಲ, this
This was
annexure
challenged.
K is a notice.
Notice, this was challenged.
Challenge in which writ petition?
This writ petition.
And there is an order of stay.
Stay. And in spite of the stay of disposition, now the fourth respondent forest officer has passed the order dated 18/12/24, which I have produced along with IA. Now I have filed an IA for stay of that final order, which has been passed by the Forest Authority. In spite of the pendency of this writ petition and there is in spite of stay. IA, my lord. So today it come on the IA filed by me.
So you will have to file an amendment application.
That is, since I have challenged all the entire proceedings.
So subsequent developments, so amendment application.
That I will do, my lord. Now, please.
You will have to seek amendment and seek raise a challenge to the subsequent order.
That I will do, my lord. That
Please file
amendment I
those
will sort.
applications also.
Now, the only thing, protection, he has given only 30 days to.
ಇನ್ನೊಂದು connecting matter ಇದೆ. ಇನ್ನೊಂದು connecting matter ಇದೆ WP number 23169/23. Similar and
ಅದು ನಾಳೆ ಬರ್ಬೋದು ಸರ್. ಅದರಲ್ಲೂ ಸೇಮ್ ಮಾಡಿದ್ದಾರೆ.
ಈ ಆರ್ಡರ್
ಪ್ಲೀಸ್.
that has already been stayed.
ಹೌದು, ಅದರಲ್ಲೂ ಆಗಿದೆ, ಇದರಲ್ಲೂ
ಅದರಲ್ಲಿ ಇನ್ನು ಸ್ಟೇ ಆರ್ಡರ್ ಆಗಿಲ್ಲ.
ಇಲ್ಲ, ನಾಳೆ ಬರ್ತದೆ ಸರ್, ಅದು ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೇನೆ.
Learned counsel for the petitioner submits
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ
that although ಯಾವ್ದು interim order?
Interim order dated 20/12/2023.
An interim order of stay has been passed by this court on 20/12/2023. In respect of
Property in scheduled property.
all further proceedings pursuant to notice dated 21/9/2023, comma, nevertheless, the respondent,
Fourth respondent.
the fourth respondent range forest officer,
Please, my lord, for 3 and 4. Deputy Conservator of Forest and Range Forest.
In this matter, my lord, we will get the intersection of the.
And the order passed by us 3 or R3.
the assistant conservator of forest has passed final orders invoking section 64A bracket 1 of the Karnataka Forest Act. And therefore, IA number 1 of 2025 has been filed by the petitioner seeking stay of the said order.
Please.
Full stop. Next para. Learned counsel for the petitioner is directed to serve a copy of the IA on learned AGA.
Serve ಮಾಡಿ ಹಾಕಿರೋದು ಕೊಡ್ತೇನೆ ಇನ್ನೊಂದು
ಕಾಪಿ ಇಲ್ಲ.
Next para. Having regard to the interim orders passed by this court on 20/12/2023, staying all further proceedings, comma, the officer could not have proceeded to consider the matter, and therefore there shall be an ad interim order of stay of the subsequent order
dated 18/12/2024.
dated 18/12/2024
2024.
till the next date of hearing.
Please. This matter is covered by your lordship judgment, that is Lakshmamma case. Without joint inspection and joint survey, there can't be a proceedings under section 64.
All right. The other matter is coming up tomorrow, please. Yes.
On behalf of for the first respondent.
Huh?
This is the matter, my lord. The tender was for supply of forged steel media grinding balls. My lord, this is to extract gold from gold ore. So, my lord, the tender was called for. We were the successful bidder. Lord, in the meanwhile, what has happened is we were supposed to supply, my lord, 65 mm and 125 mm those grinding balls. The first consignment of 65 mm and 125 mm was received by them and the amount was paid. The second consignment of 125 mm, my lord, was received and they had no objection. However, with regard to 65 mm, my lord, they had an objection with regard to 65 mm. They did not give any reason as to why. They simply said we cannot accept it, though it was in their custody. Subsequently, for the next year, my lord, the tender was called. And my lord, our bid was rejected. The technical bid was rejected on the ground that this has been rejected. The 65 mm balls, my lord, has been rejected. Then, my lord, this matter while pending before this honorable court, if your lordship were to just turn to the order dated 9/9/2024 passed by the learned single judge.
Sir.
Because there was a dispute with regard to the tolerance level of the manganese, which they said, my lord, does not fall in the prescribed limit, which we said it falls. So when the matter came up before this honorable court, my lord, at the learned single judge, my lord, sent it there. I'll just read that order. Heard so and so, represent the petitioner counsel and so and so.
Matter will have
Respondent
to be
number
heard.
1 is hereby direct.
Huh? Either it has to be heard. There is
But
an amendment, whatever my learned friend is
request,
saying.
my lord, is this, my lord. I have
There is
no
an
objection for the matter being heard. In fact, my lord, from this order and from 19, my lord, all that we were requesting, my lord, was that 65 mm, my lord, the petitioners are in trouble, my lord. They're facing financial hardship. In fact, we had made that submission, my lord, before, my lord, the learned single judge, that 65 mm, which is in their custody, let them make that payment, which is subject to the writ petition.
Please
Lord,
see
they
the
don't
prayers.
want to make that payment. In fact, my lord, why I'm trying to read this order passed by the learned single judges, my lord, they appointed, my lord, your lordship may kindly see that order, my lord, directed to send 65 mm forged grinding media ball supplied by the petitioner under the purchase order so and so to Raghavendra Spectrometallurgical Laboratory for testing within 1 week. So, my lord, based on that, my lord, the court said if it is under tolerance level, then you accept it and make the payment.
There is
The
no.
report came. May I just complete, please?
Lords, we are now going into, please see the prayers.
No,
What
no.
my learned
No,
friend is
my
saying.
lord, that is for him to say whatever. Let me complete. He can't, my lord, tell what I should argue. I'm the petitioner, my lord.
Yes.
My learned friend probably is not aware of the 1912 order passed by this honorable
Lords, I was
court.
appearing.
Let him not stop me, my lord. Let me make my submission.
Yes.
I don't know why, my lord, he is jumping and he's so anxious about this. So, my lord, the report came, my lord, where they said the tolerance level is correct. My lord, they had to then make the payment. What they do, my lord, they produce it that saying that this, they have given it. They, my lord, without unilaterally, without even coming to this honorable court, they conduct one more test. And they say, no, no, this does not come under that. Then, my lord, on 19 to 12, your lordship may kindly see the order. 16/12/2024. Lord, because this matter, my lord, continuously before the learned single judge, we were requesting that 65 mm, my lord, which is there lying with them, let them make payment, my lord. I'm suffering, my lord. I mean, the hardship I have. So the order passed was petitioner to approach the respondent number 1, following the communication dated 14/12/2024 to consider the claim of the petitioner for release of the amount for having supplied 65 mm forged steel grinding media ball, relist on so and so. So, my lord, this was there. Now, for this, what they say, the learned single judges only asked us to consider. My lord, now in fact, they had issued a notice, come for a settlement. Now their settlement terms are, we'll do one more test on this. My lord, 125 mm, let them do or whatever. My lord, this 65 mm, at least, my lord, some payment has to be made to me. They don't make that payment to me, my lord.
No. What did you supply?
My lord, this forged steel
ball,
media
iron
grinding
ball.
balls. My lord, that, my lord, is used for, my lord, to take out the gold from the gold ore. So, my lord, that there are two specifications, 65 mm and 125 mm. The size of the ball, 65 mm and 120. So, the first tender, my lord, which we were supposed to supply, my lord, we were the successful bidder.
Yes.
And, my lord, we had supplied. The first consignment was accepted, paid, 65 and 125. Second consignment of 125 and 65 is supplied. They accepted both. 125, my lord, they accepted and made the payment for 125. No quarrel with regard to that. 65 mm, they said, no, we cannot accept.
When did this happen?
My lord, this happened in 10/2/2024. Second consignment, my lord, which was not given, my lord, that was on 10/2/2024. So that, my lord, they rejected the 65 mm, not the 125 mm. So, my lord, then what happened was, my lord, they called for the new
So,
test.
asking for payment regarding what?
65 mm. My lord, because when this matter came up before this honorable court, when we were saying, my lord, then the court said, since you're saying that it does not fall under the required tolerance level, let third party, my lord, which they had only suggested, my lord, let them conduct and let the report be submitted to the court. So then the court can decide as to whether the payment can be made or not. My lord, this court, my lord, on that is on 9/9/2024 passed that order.
Oh, ultimately, if they have called for certain material from your side,
Yes, ma'am.
it has to be put to use,
Yes, ma'am.
isn't it?
Yes, ma'am.
They are getting it, they are procuring it from you
Yes.
for manufacture, for
For extracting gold from gold.
extracting gold.
Yes.
If your product has not been used for that process and it has been rejected, how can we direct them to make payment?
No. Now, what has happened is this. They reject it on the ground, my lord, that it is not under the proper tolerance level,
Correct.
which we disputed.
Correct.
So this court, my lord, directed, my lord, to have my lord, the third party get a test done. And that was what was the order passed. That is, if your lordship sees 9/9, Raghavendra Spectrometallurgical Laboratory. They said, please send it there by the order passed by this honorable court.
Then what is the difficulty for you?
I'll just submit. Let's.
Why don't you make use of the
Adagala,
which is already given?
My lords, I'll just submit. See the main prayers in the writ petition for a moment. Main prayers. Writ petition amend madidru, amended writ alle. The writ is filed challenging the subsequent tender rejection.
Yes.
This was pertaining to the old one.
Correct.
IA3 ಒಂದು ನಿಮಿಷ IA3 amendment ಇವಾಗ ಹೊಸದಾಗ ಹಾಕಿದ್ದಾರೆ IA3. ಅದ್ರ prayers ನೋಡಿ amendment ಇನ್ನೂ allow ಆಗಿಲ್ಲ. He is challenging the rejection of 65 mm by virtue of an amendment. ಅದು ನಮ್ಮ problem ಏನು ಅಂದ್ರೆ, then now please come to the page 167 of his writ petition. ಇದೆಲ್ಲ ಗೊತ್ತಿದ್ದು, he has initiated arbitration proceedings. Now how does he come to the court and now say, please come to 167 for a moment?
In fact, my lord,
one
rejection
minute,
of
now
the
that my
tender.
turn has come, let me complete.
All
Please come to 167.
Let us continue.
Please.
I think your lordship's intelligence.
No adjournment now, sir. We'll see. Sir, memo book, sir. Memo book.
So what time will the court reconvene after lunch?
After lunch,
What time after lunch?
2:30.
All right, thank you.
Thank you.
Sir, court officer. Sir, court officer. Sir, court officer. Hello? Hello? Hello, court officer? The court officer? Court officer?
ಹೇಳಿ ಸರ್, ಹಲೋ.
ನಾನು ಶರ್ಮಾ.
Yes,
ಆ
sir.
ಸೀರಿಯಲ್ ನಂಬರ್ 71 ಇದೆ ನೋಡಿ, ಅಲ್ಲಿ ಒಂದು 8-10 ಕೇಸ್ ಕಂಬೈನ್ ಮಾಡಿದ್ದಾರೆ. ಯಾರಾದ್ರೂ ಟೈಮ್ ಕೇಳಿದಾರೋ ಅಂತ ನನಗೆ ಬೇಕಿತ್ತು.
ಯಾರು ಕೇಳಿಲ್ಲ ಸರ್, ಅದರ್
File-
ಸೈಡ್ ಇದ್ರೆ ಮಾತ್ರ ಕೊಡೋದು.
ಸರಿ, ಹಾಗಾದ್ರೆ ವೇಟ್ ಮಾಡ್ತೀನಿ.
ಅದರ್ ಸೈಡ್ ಕೌನ್ಸಿಲ್ ಪ್ರೆಸೆಂಟ್ ಇದ್ರೆ ಮಾತ್ರ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್, ಅದರ್ವೈಸ್ ನೋ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಸರ್.
ಸರಿ ಅಲ್ಲ, ಸುರಾದ್ ಅವರು ಏನೋ ಟೈಮ್ ಕೇಳಿದ್ರು ಅಂತ ನಾನು ಇದ್ದೇನೆ, ಒಂದರಲ್ಲಿದ್ದೀನಿ. 8-9 ಇದೆ ನೋಡಿ ಒಟ್ಟು. ಕೋವಿಡ್ 5 ಟೈಮಿನದ್ದು ಅದರ ಬಗ್ಗೆ. ಸರಿ, ಓಕೆ. ಆಗಿಲ್ಲ ಸರಿ, ಓಕೆ. ಐ ವಿಲ್ ಬಿ ದೇರ್. ಆನ್ಲೈನ್ ಬರ್ತೀನಿ. ಥ್ಯಾಂಕ್ ಯು. ಸಾರಿ, ನಿಮ್ಗೆ ತೊಂದರೆ ಕೊಟ್ಟೆ.
ಪರವಾಗಿಲ್ಲ ಸರ್, ನೋ ಇಶ್ಯೂಸ್. ಮಾರ್ನಿಂಗ್ ಬೆಳಿಗ್ಗೆ ಕೊಟ್ಬಿಟ್ಟು ಹೇಳಿ ಅಷ್ಟೇ. ಬೆಳಿಗ್ಗೆ ಇವಾಗ ತಗೊಳೋದಿಲ್ಲ ಹೇಳಿ ನೋಡಿ ಅಷ್ಟೇ, ಮೆಮೋಸ್ ತಗೊಳಲ್ಲ ಈಗ. ಫೋರ್ ಅಂತ ಮಾಡ್ಬೇಕು ಏನು ಸೀರಿಯಲ್ ನಂಬರ್ ಏನು 60 ಏನು ಫೋರ್ ಅಂತ ಮಾಡಬೇಕು 32ನಾ ಫೋರ್ ಆಗ್ಬೇಕು 32 ಅಂತ ಆಗುತ್ತೆ. ಸರಿ ಆಮೇಲೆ ಕೊಡಿ, ಕೇಳ್ಬಿಟ್ಟು ಕೊಡಿ. ರೀಚ್ ಆದ್ಮೇಲೆ ಕೇಳಿ ಕೊಡ್ತೀನಿ. ಸೆಟ್ಲ್ಮೆಂಟಾ ರೆಡಿ ಇದೀನಾ? ಅದರ್ ಸೈಡ್ ಇಬ್ರು ಇದಾರೆ, ರೆಡಿ ಆಗಿದ್ದಾರೆ ಸರ್. ಆಯ್ತು ಹೇಳ್ತೀನಿ. ಇದಾದ್ಮೇಲೆ 3 ಪಾಸ್ ಅವರ್ ಆಗುತ್ತೆ ಅಷ್ಟೇ. ಇದಾದ್ಮೇಲೆ ತಗೋಣ. ಮಾಡ್ಬೇಕು ಒಂದು ಪೇಷಂಟ್ ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕು. ಇದೆ ಅದು ಫಸ್ಟ್ ಮಾಡ್ರಾ ಬೆಳಿಗ್ಗೆನೂ ಕೊಡಿ, ನಾಳೆನೂ ಬರ್ತಾ ಇತ್ತು. ಇವತ್ತು ಬೆಳಿಗ್ಗೆ ಕೊಟ್ಟಿದ್ರೆ ನಾಳೆಗೆ ಬಂದ್ಬಿಡೋದು. ತಗೊಳೋದಿಲ್ಲ, ಬೆಳಿಗ್ಗೆ ಕೊಟ್ರೆ ನಾಳೆ ಇದಕ್ಕೆ ಫಾಲೋ ಅಪ್ ಇಟ್ ವಿಲ್ ಕಮ್. ನಾಳೆ ಫ್ರೈಡೇನಾ ಕೇಳಿ ನೋಡಿ.
Serial number 75, it is for reporting settlement.
Huh?
Serial number 75 and 76 are for reporting settlements. Settlement is possible. I have filed an application and none of the respondent is opposing it. It's a surface matter. We were tenants. The property has been sold by bank. Now bank is in possession of
Reporting settlement.
reporting settlement.
It was sent for mediation, is it?
It was not sent for mediation. We have.
Between
we
the
have-
parties
we have-
only.
We have discussed with amongst ourselves.
Who is there on their,
Respondent.
I'm for respondent bank.
you are for the respondent?
Respondent.
Now it's a surface matter. We were tenants. We paid advance amount to the owner. Owner is respondent number 2. Now the property has been auctioned by bank. Bank is in possession of excess amount. From out of the excess amount, it is possible for them to pay us proportionately, and bank is agreeing. And landlord has no objection.
Who is appearing for the landlord? So it can be disposed of.
It can be disposed.
File a joint memo. You file a joint memo, whatever is the terms, you file a joint memo, we'll dispose of.
File it tomorrow.
Below number 63, my lord.
Serial number 75. Learned counsel for the petitioner as well as the respondents submit that the parties have arrived at a settlement. Full stop. If that is so, the parties may file a joint memo and the writ petition will accordingly be disposed of.
Correct.
Yes.
Below serial number
A date may
63,
please
my
be
lord.
fixed. Tomorrow or day, tomorrow.
List this matter. You want tomorrow itself?
Tomorrow or Monday.
List this matter on 27th of January. Yes.
Serial number
Serial number
63, my lord.
66, my lord.
And for the petitioner, we've engaged the senior counsel. He's unavailable today. He's got some personal inconvenience.
Who is on the other side?
Respondents are all here. my lord.
63. Please.
63. It may be had on Monday or Tuesday, my lord.
Pleadings have been completed in this.
Pleadings are completed.
Pleadings have been completed.
The Deputy Solicitor General of India, who is appearing for Union of India?
Mr. Shanti Bhushan appears.
That's what.
I'll inform him, my lord. I'll inform Mr.
Huh?
Shanti Bhushan. This is the matter pertaining to right to be forgotten.
Serial number 63. At the request of learned counsel for petitioner, release this matter
Tuesday, my lord. 28th.
on 28th of January.
Deeply obliged.
Serial number 66.
72, my lord. Serial number 72, my lord. I'm for petitioner, 72.1. In 3 weeks' time, my lord. The reason, my lord, my senior met with an accident, my lord. I have informed the respondent.
They have to be here and say no objection.
My lords, I'm a petitioner in another matter, my lords, and respondent in this case. Lords, a short
72.
accommodation may be given, a short.
72.1, 72.1.
Please, my lords.
At the request of learned counsel for petitioner, release this matter
Short accommodation.
on 29th of January.
No, my lord.
29th is fine.
Sir,
lords.
Huh?
Major operation has been done, my lord.
Ah.
Kindly, 1 month, maybe. I have already informed.
Informed ಅಂದ್ರೆ ಅವ್ರು ಹೇಳ್ಬೇಕಲ್ರಿ ಆಯ್ತು ಇಟ್ಸ್ ಆಲ್ ರೈಟ್ ಇಫ್ ಇಟ್ಸ್ ಅ ಮೇಜರ್
Two
ಆಕ್ಸಿಡೆಂಟ್
weeks ಆದ್ರೆ ಕೊಡ್ಲಿ. 2 weeks is okay. But it's not beyond.
release this matter on 5th of February. Yes.
Serial number 66, my lord. 66 and 67, my lord. Appear for respondent, inform the
Informed ಆಗಲ್ಲ, they have to be here. They have to be here and say no objection. Otherwise, you can mention when the matter reaches. Huh? What is the urgency? Huh? All right. ತಗೊಳ್ಳಿ.
Serial number 74, madam. I appear for the petition. 2 weeks time, madam.
Who is on the other side?
Yeah, government is there.
Only government.
Please.
74.
Please.
Serial number 65. Here for
74. At the request of learned counsel for the petitioner, release this matter
2 weeks time, madam. Failure.
on 4th of February.
Please, madam. Interim order mail.
Interim order granted earlier stands extended in the next date of hearing.
serial number 65.
Hmm.
For respond number.
2
2 weeks time may be time.
Who is for the petitioner? Yes.
Serial number 70, my lord, kindly, 6 time, my lord.
Same appa, other side illa ಅಂತಂದ್ರೆ no.
71 ನಾನು ಅಪಿಯರ್ ಆಗ್ತೀನಿ. ಐ ಆಮ್ ಫಾರ್ ದಿ
71.
ಅವ್ರು ಯಾವ್ದು 71 ಹೇಳಿದ್ರ?
70.
70.
70 ನಾನು 71. ಐ ಆಮ್ ಸಾರಿ.
The other side is
ಆ 71 9 ಇದೆ.
70.
yes, my lord.
Serial number 70 at the request of learned counsel for petitioner. Release this matter on 29th. 70 ತಾನೆ?
Yes, my lord.
71 ಅಲ್ಲಿ ಕಂಬೈನ್ಡ್ 9 ಕೇಸ್ಗಳು ಒಟ್ಟಿಗಿದೆ.
Mr. Hirematted,
Yes, my lord.
Mahesh Ayya.
Yes,
On 29th of January.
please.
Yes.
Continuation.
71 ನಲ್ಲಿ ಯಾರಾದ್ರು ಕೇಳಿದ್ರು ಅಂತ ಐ ಆಮ್ ಸಾರಿ. ಐ ಆಮ್ ಅಲ್ಲಿ 9 ಕೇಸ್ಗಳು ಒಟ್ಟಿಗಿದೆ ಕಂಬೈನ್ಡ್.
ಇಲ್ಲ 71 ಇಲ್ಲ.
ಸರಿ, ಓಕೆ.
Yes.
Pointing out page 167 ಒಂದ್ ನಿಮಿಷ ನೋಡಿದ್ರೆ I3 ಕೊಡ. Repetition al page 167. That's a notice issued by them, my lords, the petitioners, on 21/6/2024. This is pertaining to the earlier tender where that, lords, they were successful and that we had rejected their 65 mm. 167, my lords.
Annexure?
Yes, anta ide. Annexure, yes.
Yes, S1.
Yes, anta ide. S1 almost S1 ಅಲ್ಲಿ ಇಲ್ಲ, S ಅಲ್ಲಿ.
S is page number 162 ನಂದ್ರಲ್ಲಿ.
Lords, ಇಲ್ಲಿ ನಮ್ಗೆ amended writ ಅಲ್ಲಿ. Amended writ ಅಲ್ಲಿ.
Whatever. This is what we find here.
ಇಲ್ಲ, amended writ ಅಂತ ಒಂದು ಹಾಕಿದ್ದಾರೆ ಅವರು. ಕೆಳಗಡೆ ಇರಬೇಕು. Lords, subject to correction.
ಇವೆ.
ಅದು
Pointing out annexure, yes.
Yes.
ಆಯ್ತು.
ಅದರಲ್ಲಿ they refer to all our earlier communications and rejection. And please turn to the next page, para 5, my lords. So, my lords, it starts with my client is ready and call upon you. Your consent to appoint his lordship, Honorable Mr. Justice Hinchgiri, Ashok B. Hinchgiri, as an arbitrator and the arbitration proceedings to be conducted in the Karnataka Arbitration Center, so and so, and in the event you disagree, to appoint the aforesaid arbitrator as suggested by my client, you may suggest any other arbitrator of your choice, and my client shall have no objection.
Arbitration notice.
Arbitration notice, ಅದು ರಿಜೆಕ್ಟ್ ಅಲ್ಲ ಆಗಿದೆ ಇದಕ್ಕೆ. ಅದಕ್ಕೆ ಅದು ಅಲ್ಲೇ ನಿಂತೋಯ್ತು. They did not go further. ನಾವು ರಿಟ್ ಅಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿರೋ ತಾವು ಮೇನ್ ಪ್ರೇಯರ್ ನೋಡಿದ್ರೆ, ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ issued a new tender. ಟೆಂಡರ್ ಅಲ್ಲಿ ಅದು ರಿಜೆಕ್ಟ್ ಆಯ್ತು. ರಿಜೆಕ್ಷನ್ ಆರ್ಡರ್ ನ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು ರಿಟ್ ಅಲ್ಲಿ. This was never an issue, my lords, of my rejection of his sample of the earlier tender. Then now IA3 they have filed.
That is a matter for consideration before the arbitrator. How can you make this?
IA3.
May I make this? Now this, my learned friend says that idu madidru sumne adu. We, my lord, issued this notice. They keep quiet. They don't do anything to this. We have said either we appoint or give your choice, we'll accept. They keep quiet. They don't do anything. Now what my learned senior, my lord, he's saying is, Lord, what that 65 mm, my lord, which was rejected in the earlier tender, based on the rejection, my lord, in the subsequent tender, my lord, they reject our technical bid on the ground that that we have rejected your 65 mm. And pursuant to all this arbitration notice, my lord, all these series of orders have been passed by the learned single judge. So, my lord, this 65 mm, my lord, the first consignment, my lord, 65 mm and 125 mm, my lord, the first consignment they accept and make the payment, which pertaining to the earlier tender. The second consignment of 65 mm and 125 mm, 125 mm, my lord, they have no issues, my lord, they make the payment. 65 mm, my lord, they reject it on 10/2/2024, and on 6/4 they try to give some reason after 2 months. So, my lord, what happens is now during the pendency of this writ petition, your lordship may kindly see the rejection of the tender, my lord. We also, my lord, go under section 69 of the KTTP Act. My lord, within 1 month, no orders are passed, nothing has happened. We are before this honorable court. Subsequently, my lord, the 65 mm, this honorable court, my lord, passed an order that get it tested by a third party. Based on that, why don't you accept it, my lord? That order, I'll again at the cost of repetition, my lord, I'll read. So, my lord, when that was, my lord, the report came in our favor, Now what they see, my lord, your lordship may kindly see the conduct. In that, my lord, in that report, 125 mm of the other balls which I have supplied, that, my lord, the report rejects that no, it is not under the specified limits. 65 mm, they say it's within the specified limits. So 65 mm, they say you do a retest. 125, because it comes in their favor, they don't even say about the test. So 65 mm, my lord, which has come in my favor, and what they do, my lord, when they file a memo with the test report, they unilaterally, in the teeth of the order passed by this honorable court, they do one test and say, no, your thing, it does not come in the specified thing. So, my lord, then subsequently, when this matter, my lord, was argued, and we brought out our hardship. All that I'm saying now also is, my lord, like when we brought out this hardship before this honorable court, that they are suffering with regard to 125 and with regard that all those things can be considered. 65 mm, which you have already given to you, at least to that, my lord, you give us the money, whatever the condition this court, even now also I'm making this submission. Whatever, my lord, an indemnity bond or whatever, subject to result of that, let them at least release the money for that 65 mm, my lord. That is my limited prayer as on today. They have, my lord, kept it with them since that day, my lord. They, my lord, and your lordship may kindly see 125 mm, my lord, they don't want a retest because that report has gone in their favor. The report which has come in my favor, they say you will do a retest. They come here, my lord, and say that before this court that we have called them for an amicable settlement. Lord, amicable settlement, they say it has to be tested again, my lord. How fair is that? And my lord, this court says, with regard to release of the money, please consider a direction is issued to them. My lord, technically, my lord, I'm not saying that they are wrong, but technically they say the learned single judge has said to consider. So we have considered. Lord, that is for release of the money because, my lord, this was argued and we said, let them release the money only with regard to 65 mm. Lord, your lordship may kindly see. Arbitration, my lord, we have issued a notice. They don't respond. They don't do anything and they keep quiet till now. My lord, we go before challenging the tender cancellation, my lord, we go under section 16. They do not pass any orders. We come before this honorable court. And what the learned sin is saying is that the subsequent tender, my lord, which has been rejected, is on the basis of my earlier consignment, second consignment, which I have supplied to them. That which they have rejected, which is the subject matter, which this court, my lord, directed a third party, which gave a report. So, my lord, if that is cleared, my lord, then what happened?
What you are trying to say is that without even testing it, based on the previous consignment and the rejection of the same.
Yes, ma'am.
They have
rejected my tender on the technical.
That is your contention.
Yes, and as per the rules, my lord, under this Hatti Gold Mines, what they do, my lord, is L1 and L2. So, my lord, if there are L1 and L2, L1, my lord, gets to supply 60% and L2 gets to supply 40%. My lord, but here, now there are no L2 at all. So now they have given it to the other person, not because they reject my technical bid on the ground that your earlier consignment has already been rejected, which is again subject matter here and which is being considered. Though my writ petition is right, my writ petition was with regard to the cancellation because there was no order passed by them within a month, which they're supposed to do. We are before this court. Well, but then when we have asked for it and when orders have been passed, saying that you get a test done and when the test report comes, even today, my lord, all that I'm saying is they are in hardship. They are in financial hardship. Let them, my lord, whatever conditions your lordship say or what my learned friend wants to say, at least, my lord, to that extent, I'm not talking about the 125 mm or the third consignment. The second consignment, that 65 mm, my lord, which as per the order passed by this honorable court and as the report submitted by them to this honorable court by the person appointed by this honorable court, which has been accepted, let them at least release that money subject to whatever conditions. That's all is my limited prayer.
My lords, we have not accepted. We have rejected that. We have told him to take it back. If it is lying in my yard, what will I do with it? If I pay the amount, it will not, my lords, I am a public listed company. I will only go into loss. And he went, my lords, that's the problem here. Lords, he invokes arbitration. If I don't do anything, he should have filed a section 11 application here, go into arbitration. He writes that writ petition is filed challenging this subsequent tender. Now that subsequent tender, the successful bidder has finished his quantity also of supply. So it has become virtually infructuous. Rejection of his technical bid, he files an appeal. Appeal is not taken up. He does not even seek for a mandamus. He comes and challenges here. Now IA3 for amendment is filed, which is not even allowed by this honorable court.
There is no interim order.
There is no interim order.
Initially, my lord, about the tender, there was an interim order. My lord, then they
That
came
was
and said
modified.
that, initially there was an interim order. My lord, that
was
is,
for the
your lordship
subsequent
will
tender,
see 23/7/2024. There, so
All
and so
further
issue emergent
proceedings,
notice
subsequent
returnable. In the
tender was
meanwhile,
taken.
all further proceedings pursuant to the impugned tender notification at Annex T, so and so are stayed till the next date of hearing. So this was done. Then subsequently, my lord, on 9-9, which I read to your lordships, there your lordship may kindly see the order, my lord. 9-9.
Lords, ಅದಾದ್ಮೇಲೆ agreement ಆಗಿದೆ, modify ಆಗಿದೆ. Then
My lord,
Lord, you
here
filed
what 9-9.
before that
so and so-
29-8 ತಾವು ನೋಡಿ, 29-8.
29-8.
Please see 29-8 order. Challenge the agreement dated 9/7/24, enter in.
My lord, the application filed to amend the writ petition permitting the petitioner to challenge the agreement dated 9/7 entered by the respondent so and so, impugned tender and also the purchase orders dated, letters dated so and so. Learned no objection for allowing the application. Accordingly, IA2 is allowed the petitioner permitted to amend the petition and file an amended petition. Liberty is reserved to the respondent to file additional statement of objection. Interim
Modified.
order.
When was it
confirmed-
modified?
My lords, ಅಲ್ಲೇ 29-8 ಅಲ್ಲೇ last two sentences ಮೇಲೆ. The respondents are at liberty to proceed with respect to item numbers 1 and 2 in accordance with law.
Then your lordship may kindly see
ಅದ್ರಲ್ಲಿ
on
attend-
9-9, the next order. The next order your lordship may
What is
kindly
that
see.
item number 1 and 2?
1 and 2, my lords, is the 65 and 120 ಅಲ್ಲ, ಬೇರೆ ಇದೆ.
So therefore, interim order in respect of this items.
ಇವ್ರದ್ದು ಹಳೆ ಟೆಂಡರ್ದು 9-9 ನೋಡಿ ತಾವು 9-9
New tender.
ಪುನಃ
Interim
modify
order
ಆಗಿದೆ.
is respect to the new tender.
Please see,
Interim
that
order
is-
is
that's-
with respect to the
it's
new
all to
tender.
the new tender.
9-9.
9-9 ಅಲ್ಲಿ, my lords, please come to after the last para. Meanwhile, respondent number 4 ಅಂತಿದೆ ತಮಗ್ ಸಿಕ್ಕಿದ್ರೆ.
Yeah.
4 to supply item numbers 3 and 4 of the tender document dated 16/3/24 to respondent 1 subject to outcome of this petition. In case 125 balls supplied by the petitioner is not accepted, respondent 1 to accept the same subject to test report to be conducted by a third.
This is what, not third party. That is,
This is all
your
new
lordship then
tender.
sees on the top. Your lordship may kindly see on the
Correct.
top that respondent number 1 is hereby directed to send 65 mm forged grinding media ball supplied by the petitioner under the purchase order dated so and so to Raghavendra Spectrometallurgical Laboratory for testing within 1 week from today, and place a copy of the report before the court on or before the next date of hearing. My lord, the court even fixed that within 1 week it has to be done.
Correct.
Yes.
There is
And
no,
if it is done and it is to be done, and if your lordship sees this has been accepted, my lord, if this has been accepted, my lord, then there are two rights that
happened?
accrue to me.
What
One,
happened on the next date of hearing?
ಅಷ್ಟೇ
my lord,
ಇನ್ನೇನಿಲ್ಲ. My lord,
then,
please come to
my lord, they
22-9.
file a memo.
Enclosing the test report.
That giving the test report, and they also, my lord, produce one more test report, my lord, doing a test even without any orders by this honorable court after this report, and they say, no, we reject. So unilaterally, when the matters are pending and in the teeth of the order passed by this honorable court. Document number 2, my lord, that thing filed by them, that was filed on 30/10/2024. My lord, what I'm submitting is after 9/9/2024, when this honorable court, my lord, now two rights accrue to me. Once the test goes in my favor, my lord, since they reject my subsequent tender of 65 mm, on the ground that your 65 mm in the previous tender has been rejected, so your technical bid is rejected. So, my lord, if it has come in my favor, then my subsequent tender, my lord, they could not have rejected is one. Second, no, the 65 mm, my lord, which I've already supplied, at least they should pay that money for that 65 mm.
My lord,
Within the tolerance level which is there.
My lord,
Your
supply
lordship
is
kindly
different,
see how it
consumption is
happens.
different.
My
My
lord,
learned
I want to, my lord,
Supply is different, consumption is different. We have rejected at the outright.
No, now if the report is in their favor.
One report
Saying that yes, it is.
Within the
tolerance
within
level.
the tolerance limit,
i-
within
if-
the tolerance
ah,
limit.
Then all that you have to do is use it.
My lords, I
It is
cannot
with
use.
you.
My lords, we had given them one more option. We have filed an application saying we'll redo a test on 125 and 65, not. No. Lords, because our report says it is not within the top. There are two
They do not
samples.
want a retest of
My lords,
125 mm.
I
Your lordship
just-
kindly see the
my
content.
learned friend
125
allowed.
is rejected by this
I-
committee appointed by
I
the
think, my
court.
lords, either I am
When-
allowed or
when
he is
this
allowed.
court- When this court has directed,
Only test and place the test report.
Correct.
That's all.
now that report is in their favor.
One report is in their favor. Then we got another test.
How?
My lords,
Why did you do it?
Lord, then we have filed another application. We have filed
Without
No
another.
order passed.
Without taking permission from.
Yes,
this-
That your lordship may discard that report. Doesn't matter. We have filed application saying, please have one more test. We have one more test for 65 and 125, not only one. Lords, because there are variations, there are different samples, there are variations. 125 has got rejected.
No.
My lords, now 125 gets rejected.
Ah.
125, which was accepted earlier, now gets rejected. So we are only saying, you want a way out, get both 165 and 125. It's after all drawn, sample is drawn in their presence, not in my unilateral thing. Get it done, both 125. It's not that I'm saying only 65. I'm saying do both. But today, to say you accept to 65, pay me the money, Lords, that is not even the scope. That is the amendment which he is seeking. That amendment is not even allowed by my lords.
No, the problem is you rejected the subsequent tender based on what you
Earlier.
found in the previous.
Lords, that
could not have been done.
Lords, that is where he is.
Therefore, this court directed that sample should be sent
Yes.
for independent
Lords,
testing.
that both of us, we are only saying we still want to.
Now
my
the
lords,
report has come in their favor.
one report is in their favor. The earlier report was against them. Lords, the earlier report which we got a test done, it was against them. The subsequent
How
report.
many reports test?
Lords,
One test is in
my
their
lords, only
favor,
one test report is in their favor. One
That is
test
by the court, my lord, appointed by
Lords,
the court, not, it's
I
not
think, my
independent,
lords,
by the court.
if my learned friend wants to, my lords, I only saying this.
Yes.
This honorable court never insisted that we should accept it.
See,
That's-
the only silver lining that this court sees in this matter is that this is not a perishable commodity.
It is not a perishable
It
commodity.
is not a perishable commodity, and once an expert says, no, it meets the requisite standard, you cannot say, no, I will send it for one more verification, not permissible.
The earlier report which we,
Not
lords, that is a part of the tender document. Now,
That
my
is
lords,
what
if it-
you have got done.
lords,
Now, when the court has directed,
now,
when the court has directed that it has to be sent to
Yes.
one particular
I-
expert,
correct. my
and
lords.
that expert gives an opinion
Of-
that it meets the requisite
No,
standard.
no, 1 minute. That expert also says, my lords, earlier 125 was accepted.
I would like to see that report. Where is that report?
Now, my lords, 125 is rejected by the current, in the current
One
report.
twenty-five is rejected, correct? So my
Now,
lord, he does not
125 is-
accept both. 125 of ours is rejected, but 65 has been accepted.
My lords, if 125 is rejected in the current report, now how does this survive?
But both are
That is
different,
why
my
we
lord.
are
I don't
saying-
know. Either reject both or accept both.
You didn't have any problem regarding
Now,
125.
125 is rejected. That's a problem. Retest.
That was not rejected by you.
My lords,
That was not rejected by
that
you.
is the, now,
Andre, see, what it shows is that there may be small variation.
variations.
There may be small variation. It doesn't mean it cannot be used at all.
Yes.
My lords, the problem is.
And since it is not a perishable commodity, it is still lying with you. Please make use of it.
My lords,
Make the
what
payment.
we are saying is,
Yes.
we told him in the first instance itself, you take it back. He does not challenge that. He does not challenge it.
Why you should take it back now? See, the expert is saying, yes,
That,
it
my lords,
meets the
that,
requisite standard.
that,
Please use it.
my lords, that is not even a,
To find any difficulty in the process, then you can come back.
my lords, that is
Now-
precisely our thing.
You have not even used it.
Lords, we have not used because the test report did not satisfy our.
Now there is a test report which says,
Lords, beyond
yes,
that,
it meets the requisite standard.
lords, if it's still,
And when the product is still lying with you, you please make use of it and.
lords,
make
if I
the payment.
cannot make use of it, I will only have to pay money without even making use of it.
You make use of it. That is
Yes,
what
it will
saying.
not work. If
Not
it,
that you have to give it back.
no,
make
we have
use of
said you
it
take
and,
it back.
make
My
the
lords, we have,
payment.
otherwise, my lord, that's why we placed,
But
my lords,
They
we have
being an
said,
authority, my lord, they have to be fair.
lords, we
What
are
is my
only
mistake
saying
in
this.
Lord, they should understand the hardship
Yes.
we'll go through.
My lords, we are
Let
only,
them, my lord, put some condition. Your
Lords,
lord,
I am-
put some condition.
If-
My lord, give us some execute some indemnity bond.
Please make use of the product.
lords,
If you
yes.
find any difficulty, you please come back.
lords, we will have to rerun a test on that before I use that product. If we rerun a test,
Make use of it. Don't try to send
lords,
it,
I cannot make
send
use.
it again
Lords,
for experts.
it is like this, my lords. If it does not, if there is a impurity in it, manganese content or something is more, it does not work for me. I can't even put it to the thing. Lord, these are small iron
They are,
balls. Otherwise, my lords, why do I give the specifications? I give a specification so that it goes into the system. If it does not match that criteria, my lords, otherwise, why will I use it? I can't use it.
My lord,
And
your
he
lordship has
keeps
seen-
quiet. My lords, from June, he keeps quiet. He also kept quiet. Now, his amendment is only that challenging my
and
rejection
going
order.
on technical aspect.
Of
Neither,
course, it is technical.
neither the court knows, nor the two of you know how exactly this works.
Yes, accepted.
Lords,
We are simply making submissions of whatever little knowledge we have.
yeah, absolutely.
That is not the way. You will also have to consider the difficulty of a businessman.
My lords, then.
And your lordship
My
may
lords,
kindly see the
I
order.
think if my learned friend allows,
The order
which order,
is-
my lords, so far there is no order, my lords, which says I have to take it. If my learned friend wants to insist on that, there is no such order. The only order which this honorable court said is,
There is a report which says
after that, my lords, after that report,
what this court would direct is, you put that product into use.
Yes.
If you really find any difficulty, you come back to the court.
till then I
Don't
can't.
Don't simply say now, no, we will still want to send it for.
But then without interfering with the second tender, your
Ah.
lordships are saying, without interfering with the second tender, because he has already filed it.
We are not saying anything regarding the second tender now. There is already interim orders passed.
That, my lords, the virtually it has
And the
allowed.
rejection of this tender was only based on the previous experience,
Yes.
isn't
Now
it?
we will still.
That product is still lying with you. Please make use of it, put it to use. If you find any difficulty, come back to the.
My lords, may I just make this? Your lordship may just pass over, we'll just take instructions
Yes,
on
yes.
that and come back.
Yes.
So that whatever it is, I'll have to.
Because see, after all, if you make use of it and you find no difficulty, we
It's a-
should not unnecessarily penalize him.
No, but
So therefore,
if, my lords,
you
if.
please take instructions. The material is lying with you. You put it into use. If you still find any difficulty, you come back to the court.
Just we'll get instructions,
Yes.
whether part of it we can still try it,
Yes. you
not
can
the
try.
entire thing.
Yes, you can try.
And if it does not match our thing, my lords, we'll have to.
ನಾನು ಹೇಳ್ತಾ ಇರೋದು, how it will be put into use, whether the whole thing will be put at one time or a small portion of it is taken, we do not know.
That's why I want to, my lords, we'll
See,
find out and come back. I'll just find out how the procedure is
Yes.
so that whether it can be done.
Yes.
That is one. Now, my lords, 125 is rejected. That's another issue.
That
Did
will.
not reject it,
The test has rejected.
correct?
Ah.
So therefore, that is why I am saying there may be small variations. We do not know. But when you put it to use, if you really find some difficulty, you can come back to the court.
My lord, your lordship
Just
may kindly
pass over.
see. My lord, I'm not telling your lordships, my lord, being fair that about 125 I had never even said, which has been rejected. Only 65. In fact, the order dated 16/12 passed by this court. My lord, because of this hardship caused, my lord, the learned single judge said, release that money at least with regard to that 65 mm. That was the order passed on
To
16/12.
consider.
Consider.
That also cannot be directed, because if they are saying, see, we are not able to use it, and without using it, if we direct them to pay the amount, that also will not be proper. So that is why I am saying,
Yes, ma'am.
please put it to use and find out if it really can be used. Please go ahead and make the payment. Then you also will have no difficulty.
We'll just come back just
And
before.
this is a state government undertaking,
Yes, ma'am.
isn't it?
That is why, my lords,
Yes.
that's the worry.
Yes.
In fact, the earlier order said he can come for a settlement. The entire, my lords.
Settlement, they are again saying test.
Settlement to see, unnecessarily simply sitting across the table and trying to settle the matters of no use. If the product can be really used, please put it to use and pay them the money.
Let me
And
just.
no allegation will come against you. If you really put it to use and the product is used, he is live, he is eligible to ask for money,
Yes.
Correct.
isn't it? That is why I am
If it
saying.
does not, my lords, what I want to find out is if a sample size of that
Correct.
can be put to use and
Yes.
see.
Correct.
In spite of it, if it does not match, my
Correct,
lords, I will have to.
Correct,
But till then, I can't release the money. He doesn't.
not
That
necessary.
we'll just find out and come back.
Pass over.
Before.
All
ಸ್ವಲ್ಪ
right, pass over.
ಕೇಳ್ಕೊಡ್ಲಿ. ಇಲ್ಲ ನಾಳೆಗೆ ಇಟ್ಕೊಳ್ಳಿ. ನಾಳೆ we'll just talk. Only on this aspect now.
Release this matter tomorrow at 2:30 p.m.
2:30. Let's pass over. ನಾಳೆ ನಾನು ಊರಲ್ಲಿ ಇಲ್ಲ.
ಆಯ್ತು, pass over.
Pass on, please.
Passed over matters, serial number 8. Tyagaraja B.
This case,
Serial number 8.
senior counsel Vivek Barid is appointed. The lordship may list it on 6th February.
Your lordship.
Yeah, meanwhile, your lordship may kindly tag the writ petition number 27/8/2024 between the same party.
The lordship may kindly see. ನಾವು
ಬ್ಯಾಕ್ವರ್ಡ್ ಕ್ಲಾಸ್ ಬಿ ನೋಟಿಫಿಕೇಶನ್ ಕಂಡೀಷನ್ ಅನ್ನ ಬೈ ಜನರಲ್ ಆರ್ಡರ್ ಸ್ಟೇ ಮಾಡಿದೀವಿ. ಅಲ್ಲ, ಲಾಸ್ಟ್ ಪೇಜ್ ನೋಡ್ಬೇಕು, ಪೇಜ್ 5, ಟೈಪ್ಡ್ ಪೇಜ್ 5 ನೋಡಿದ್ರೆ, in that view of the matter, this court is of the considered opinion that the benefit should not only be restricted to the petitioner, but also should go to all such persons having regard to the principles explained in by the Honorable Supreme Court. Consequently, there shall be an interim stay of operation of the note appended to category B of the impugned notification dated 13/195 at annexure C. During the election to the post of Adhyaksha, Upadhyaksha of Gram Panchayats in this state, which are scheduled to commence very soon. Government nವರು ಅದನ್ನ ಜನರಲ್ ಕೊಡಬೇಡಿ, ಬರೀ ಪಟಿಷನರ್ ಕನ್ಫೈನ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆದ ನಂತರನು ಇಟ್ ವಾಸ್ ಗ್ರಾಂಟೆಡ್. ಈಗ ನಮ್ದು ಕಾಸ್ಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಆಫ್ಟರ್ ದಿ ಎಲೆಕ್ಷನ್ ಇಟ್ ಇಸ್ ಸಾಟ್ ಟು ಬಿ ಸೆಟ್ ಅಸೈಡ್ ಆನ್ ದಿ ಗ್ರೌಂಡ್ ಆಫ್ ಇನ್ಕಮ್.
False certificate, income certificate has been obtained, that has been cancelled. Tahsildar has issued this without even inquiry also. Mandatory requirement, Tahsildar issued the certificate only on the application filed by the petitioner. The mandatory requirement he has to inquire. And that has been cancelled by the Assistant Commissioner. That has been challenged before the Channel Court. Now the question is regarding his election petition is pending before the Channel Court and in WP number 27/884/2024. Both may kindly be tagged. Necessary order may kindly pass because we have appointed the Vivek Subbareddy, the senior counsel, since he is busy with the election of our association. My only request is you will also list it on 6th for both the petitions. When at this stage also he has not been displaced. He is still working as a president of the village panchayat, Bagalur village panchayat. That is not in dispute. Let even the election petition be clubbed with this petition, it can be decided both the petitions by your lordship.
So consequently, you contested.
I contested. Thereafterwards, the caste certificate is cancelled on the ground, your income is more. That very requirement is stayed. Of course, ಈ ಆರ್ಡರ್ ತೋರಿಸಿದ ಮೇಲೂ ನಿಮ್ಗೆ ಎಲ್ಲ ಐತೆ ಆರ್ಡರ್ ಅಂತ ಹೇಳಿ ಅಂದಿದ್ದಕ್ಕೆ ನಾನು ಒಂದು ಪೆಟಿಷನ್ ಹಾಕಿ ಅದರಲ್ಲಿ his lordship just Shyam Prasad referring to your lordship's order, there is already a general order, therefore it may not be necessary, but anyway it is stayed ಅಂತ ಹೇಳಿ ಅದರಲ್ಲೂ ಮಾಡಿದ್ರು. In spite of it, Assistant Commissioner sets.
So by pointing out to income criteria,
yes,
you are saying that is the concept of creamy layer.
Yeah.
It is based on the income criteria.
Yes. He is an income tax assessor.
In respect of admission appointment, not in respect
education,
of elections.
education and employment.
Employment, not in respect of elections. On the other hand, the Supreme Court says imposing such conditions will work other way around because those who doesn't have the resource cannot probably succeed in the election. ತಾವ ಕೃಷ್ಣಮೂರ್ತಿ ಕೇಸನ್ನ ಅದಕ್ಕಾಗಿ ನೋಡನೆ ಮಾಡಿ. Therefore, not that I am against.
No, after election, this your caste certificate has been cancelled.
Cancelled.
Yes, after election. And the election, his election is also challenged in that writ petition referred by me.
ಅಲ್ಲ ನಮ್ಗೆ ನಾವು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದು ಇನ್ಕಮ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅನ್ನ ಈ ಗ್ರೌಂಡ್ ಮೇಲೆ ಮಾಡೋದಕ್ಕೆ.
Which is the impugned order?
Annexure R, page 127. ಅದರಲ್ಲಿ ಪ್ಯಾರಾ 12ದಲ್ಲಿ ಸ್ಟೇ ಆಗಿದ್ದನ್ನ ರೆಫರ್ ಮಾಡ್ತಾರೆ. ಇನ್ ಸ್ಪೈಟ್ ಆಫ್ ಇಟ್, Page 137 ನಲ್ಲಿ ತಾವು ನೋಡಿದ್ರೆ election petition in ಹೇಳಿ ನಂತರ the said writ petition was nowhere connected to the above appeal. In the said circumstance, it is necessarily required to obtain a detailed report with regard to impugned caste and income certificate issued by so and so. Further, on perusal of the order sheet pertaining to the caste and income certificate of the respondent, it reveals that the respondent authority has not received any detailed report from the village accountant as well as from revenue inspector, has not mentioned the documents which were as such caste and income certificate issued by respondent authority without obtaining essential report from the, including the village accountant. Hence,
Now you are a member of what?
I am member of Bagalur Panchayat, now elected as president.
Gram Panchayat.
Gram Panchayat. This Gram Panchayat notification is
Yalanka Taluk.
Yalanka.
Village Panchayat.
You are appearing for whom?
I am appearing for the Cavators Council. Respond number 5, my lord.
You are the complainant.
Complainant.
I am the complainant and the election petition also filed by me. And it is pending for the Southern Court.
Rival candidate.
Election petition.
Yes, challenging the election of the petitioner.
Or challenge madidru, election petition is dismissed. Now it is pending in a writ petition.
In writ petition.
You also contested.
Yes, I contested. My income is lesser than, but his income is more than what he has taken in the certificate. Tahsildar without boarding any inquiry.
AGA takes notice for response number 1 to 4. Learned Counsel Shri M. Ramachandra Gowda has entered appearance for response number 5.
I am Ramachandra H.
Ramachandraya.
Yes, my
M.
colleague.
Ramachandraya.
H. He is
Has
Cavator Advocate Ramachandra Gowda, my colleague.
You want your name to be shown?
No, I will file I will undertake to file wakalat.
Huh?
I will undertake to file wakalat.
M. Ramachandra Gowda has
Yes.
entered appearance for response number 5 by filing a caveat petition. Who is response number 6?
Response number 6 is one of the contestants. She's also contested.
Huh?
She's also contested. She's also contested in the election, your lord. She is not secure.
Why?
ಅಲ್ಲ ಇಲ್ಲಿ ಆರ್ಡರ್ ನಲ್ಲಿ ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ, ಹಾಗಾಗಿ we were forced to make her ಆಕ್ಚುಲಿ ಅವರೇನು ಅಪಿಯರ್ ಆಗ್ಲಿಲ್ಲ, ಇದನ್ನು ಮಾಡಿ ಪೇಜ್ 128 ನಲ್ಲಿ
ಆಯ್ತು. Issue notice to respond number 6. Learned Counsel for petitioner is directed to serve copies of the petition along with annexures on the learned AGA as well as Learned Counsel for respond number 5. Next para. Learned Senior Counsel Shri Jaykumar S. Patil appearing for the petitioner submits that despite interim orders being passed by this court, what happened to that petition? It was disposed of, is it?
ಇಲ್ಲ ಇಲ್ಲ
That election is still pending, my lord.
Despite interim orders being passed by this court, in WP number 15169 of 2023, dated 17/7/2023, upholding the contentions of the petitioner therein, that consequent to the Honorable Apex Court declaring in the case of K. Krishnamurthy, bracketly doctor, close, and others versus Union of India and another, bracketly 2010, close 7 SCC 202. Where it was clarified that there cannot be exclusion of the creamy layer even in respect of backward communities in the context of political reservation, comma, a note was put up
Note appended to the notification dated 13/1/95.
Category B.
In notification dated 31/1/1995.
13.
13
13
1995.
13.
ಇಲ್ಲಿ 31/1 ಅಂತ ಇದೆ.
ಇಲ್ಲಿ 13
ಹೌದು.
13
1995. That no person falling under category B shall be entitled to the benefit of reservation in the seats and offices of Adhyaksha and Upadhyaksha of Zilla Panchayat, Taluk Panchayat and Gram Panchayat if he or she draws salary which is not less than that of class 2 officer, semicolon, is a income tax assessee bar wealth tax assessee, semicolon, assessed to sales tax,
8 acres.
or has more than 8 acres of rain-fed or dry land or its equivalent, comma, which is nothing but application of the concept of creamy layer. Full stop. This court accordingly stayed the operation of the note in note commas ಅಲ್ಲಿ appended to category B of the impugned notification dated 13/3/1995
13
and further directed that the benefit of the interim order shall inure to all concerned persons and will not be restricted only to the petitioner.
Please.
Full stop. Despite noticing such interim order where a prima facie opinion was given by this court that having regard to the clarification given by the Honorable Supreme Court that insofar as reservation in elections the concept of creamy layer cannot be made applicable even in respect of backward communities, comma, the Assistant Commissioner, Bangalore North Subdivision, has passed the impugned order applying the income criteria and accordingly cancelled the caste certificate, caste and income certificate of the petitioner. Full stop. Learned Senior Counsel submits that as a consequence of the impugned order, the petitioner will be disqualified from continuing as a
Adhyaksha.
member or the Adhyaksha of the Gram Panchayat. Full stop. Next para. Consequently, there shall be an interim order of stay of the impugned order
At annexure R.
at annexure R till the next date of hearing.
Please.
Yes.
Will tag this matter along with WP number 27, WP number 27/884
That is regarding
election, other election challenge.
election on what ground?
On the, by producing false certificate, income certificate.
Huh?
By producing income tax certificate issued by the Tahsildar, he contested the election.
All right. List WP number?
27,
Hmm.
884, but 2024.
Along with this matter. Yes.
Serial number 18.
I appear for petitioner, my lord.
Please, I appear to respond.
In this case, my friend has filed an application to vacate the interim relief granted.
Huh?
In fact, they have moved an execution petition also. If the interim-
Vacating interim.
Yes,
Vacating.
Vacating.
These are all matters to be decided finally. No consideration of your interim prayer for vacating.
The order that was passed, may I just, the order that was passed was requesting the executing court to defer the matter. That interim order, my lords, was not extended. Thereafter, my lords, when the matter had been taken up, after I filed the application, then, my lords, at that juncture, the matter was sought to be heard.
Then if it is not extended, why did you file the application?
That therefore, my lords, the matter may be heard. That's what I'm saying.
Huh?
The matter may be heard. That's all I'm
That
saying.
is what. The matter has to be heard finally and decided. That's all.
Please, but it's a very
in fact, the
short
interim order
matter.
may
my
kindly be
lords.
extended.
No, may I make this request?
Otherwise, they will execute the decree and virtually this petition also becomes infructuous.
No.
The decree is itself a nullity.
Where is your application?
I filed in the earliest juncture.
No, he is submitting that the interim order granted earlier was not extended.
No, actually, it was actually informed that is
No,
extended.
that is why I am asking you, where is your application to extend the interim order?
Then I'll file an application.
You'll have to file an application.
Tomorrow itself, I'll file the application.
May I
Till
make-
that, at least it may defer.
Lords, may I make one request, lords? I'm on the other side. I'm just making it. Lords, this matter is a suit for ejectment, lords. Lords, the respondent, lords, the defendant. lords,
Small
is-
causes.
Small causes court.
So
Decree of-
final orders have been passed.
Final order has been passed. Oh, my lords,
Allowing the petition or
suit is decreed.
decreed?
Oh, my lords, the
He is a tenant.
No, I'm not a tenant. Actually, there is.
I'll just make my
Yes.
submission. Lords, there is some dispute with respect to it. They've itself, lords, told that the tenancy is not proper. All those issues are taken. At the end of the day, lords, she is none other than my late husband's sister. Lords, lords, I'm a widow. Lords, I have a daughter. Lords, she's attained some marriageable age. Lords, I'm in need of this property. Lords, let them, lords, at least come forward with some form of settlement. Either they'll hand over possession to me or they want some amount of money. Let them just come forward and say that. Lords. Because if your lordship admits it, lords, the great respect, lords, we don't know when it will come up for hearing. I'm really in need of some help, lords. That is the only reason, lords, I'm making this request.
I have no objection if they're coming forward for settlement.
Madi.
But they're, on the other hand, they say they have paid the money. There's not the contention actually. One hand that they say that they have paid the money, but that is not the real contention at all. And if they are ready for settlement, we are also agreeable for settlement. We'll sit over and see that the things are.
Lords, in that event, your lordship may refer it to the mediation center, lords. We will appear.
Having heard the learned counsels for some time, this court is of the considered opinion that the matter may require mediation.
Yes, mediation.
For settlement. Please. Full stop. Accordingly, the matter stands referred to the Bangalore Mediation Center.
Yes.
Full stop. Parties are directed to appear before the mediation center on
It's 15th.
First of February.
It's 15th of February, if my friend is okay with it.
1st of February, Saturday agutte.
There's a wedding in the family, that's the reason. Please, your lordship may have it on first. It's all
1st of February 2025. Without waiting for further notice.
Please.
Till that time, let them not execute.
Office is directed to forward the papers to the Bangalore Mediation Center forthwith. Please release this matter on 10th of February.
Yes.
Lords,
Yes.
Let them not execute
Sorry.
the decree, that's it.
No,
Can they do it, sir, when the
would not
matter has
poss-
been sent? for
Lords, my
mediation?
client has just instructed me that she's not available on first, my lords. Your lords may have it on any other date. my lords.
ಹೇಳಿ
15ನೇ ತಾರೀಕೆ ಮಾಡ್ಬಿಡಿ.
ಎಷ್ಟು
15th of February. So third Saturday
ಆಯ್ತು 15th of February.
For mediation.
for mediation.
Okay.
Release this matter on 25th of February.
Please,
Much obliged.
please. I'm so
Yes.
grateful.
Much obliged.
Yes.
Serial number 30. 30.
Lots for the petitioner in this case, filing the withdrawal. Lots liberty. Till then, no precipitative action is taken by the respondent bank. 1 week time, my lords, will approach the DRT.
Learned counsel for petitioner has filed a memo dated 22/1/2025 seeking leave of this court to withdraw the writ petition. While submitting that the petitioner will approach the debts recovery tribunal seeking appropriate relief. Full stop. Next para, the memo is taken on record subject to all just exceptions. Full stop. Accordingly, the writ petition stands dismissed as withdrawn.
My lords, no precipitative action is taken by the respondent bank until we.
Yes.
Serial number 62. Serial number 64.
Hearing for the respondent bank, madam.
My lord,
Yes.
the respondent bank, my lord, to freeze my accounts, against which, my lord, the present writ petition is filed. My lord, I am a partnership firm, my lord, on 29/7/2004. The partnership was reconstituted, my lord. On 25/5/2020, 1P Vinayak Bandari written a letter. So he is retired from the firm. Thereafter, my lord, on 14/1/2021, one BR Kamal, who is nowhere connected to the firm, writes a letter to the bank saying that there is a dispute in the partnership firm. The partnership is dissolved. And thereafter, my lord, on 21/1/2021, he also takes out a paper publication in the name of the retired partner, saying that there is a dispute, partnership is going to wound up. After receiving these two letters, my lord, my accounts have been freezed by the bank. There is no order, my lord, from any court. There is no order from any tribunal. Not that, my lord, the bank says, my lord, I have got liability of 2.98 crores to them.
2022 writ petition.
Yes, my lord. Matter
What
was
has
list-
happened from
It
the,
was listed several times, my lord, which is not, the matter was not reached.
no interim orders?
No interim orders, my lord.
Then what are you doing then?
Therefore, my lord, it was, every time, my lord, it was understood that the matter will be heard and disposed of. So one
Yes.
of the,
Yes, my lord, the partnership dispute, my lord, this reconstitution or the retirement has not been informed to the bank at all. My lord, as per the original partnership deed, my lord, which has been produced by the petitioners at page 25, my lord. Specifically page 28, my lord, partnership 28, my lord.
No.
Yes, my lord.
Why did you take the step of freezing the account?
My lord, there are liabilities which, it's not just a current account, my lord, that was CC account. It was a loan liability, my lord. And there was a paper publication which was issued and letter has
By
been
whom?
issued by Vinayak Bandari, one of the partners. My lord, they claim fictitious, all those things are under investigation.
No. What was the occasion for you to freeze the account?
My lord, this is
Under
a
which
partnership.
provision?
This is a partnership at will, my lord, which is terminable by any of one of the partners.
Yes.
They have taken a paper publication which has been produced by the petitioners, my lord. Paper publication in Udayavani newspaper. Notice of dissolution, my lord. Public notice has been taken at page 41, my lord. And there is a letter which has been issued, which I have produced in my objections. At page 41, this is Vinayak Bandari, partner number 10. Thereafter, Vinayak Bandari has also written a letter to the bank. I have produced it in my statement of objections, my lord. That it has been dissolved. My lord, page 22 of my objections, my lord. My
What
lord,
is this?
thereafter, we have sought for explanation. It is not that unilaterally. We have sought for explanation. Please tell us. At page 23, this letter immediately thereafter we have issued, after the paper publication, my lord, we have asked them to seeking explanation. My lord, thereafter, two other partners have come in, my lord, at page 25.
He is placing reliance on a decision of mine at annexure F.
Yes, my lord, but the
What is
subtle
this?
difference is, my lord, in that decision, it was the partner himself. It was one of the partners himself. And he's the only one. And so they have sought for freezing of the accounts. And he himself comes and requests. My lord, here it is a different case. It's a dispute. My lord, at page 25, two other partners have actually written that there is no retirement, there is no reconstitution. They go back to the original partnership deed, which they have produced. My lord, our only endeavor here is, my lord, is to come out clean, because if it's reconstituted, if there are other partners who are not liable, just tell us, come out with a reconstitution, and we will drop the documents again, and they have to sign. That's all. Now, it is not a question of we have nothing to do with the disputes.
I am liable to pay the liability only 2.98 crores, my lord. My assets, my lord, with them 15.5 crores. As on today, my lord, the 2.98 crores have also been cleared, my lord. And there is no order, my lord, restraining them to freeze my accounts, my lord. Without any provision, my lord, without any authority, without any law, my lord, can they do, my lord? I'm a running undertaking. There may be a dispute within the partners. How they are liable to that, my lord? As long as the checks are being cleared, money is there, my lord. Whatever the differences between me or the retiring partner, we'll clear it off.
Well, that
How
they're
they
saying,
will,
my
how
lord,
they
we
will
don't
get a
know.
right, my lord,
My lord, once the
on my money,
partnership
my
is
lord.
dissolved,
I
then
got
the question
liable
of
to-
who is
partnership
liable
is
will
not
always
dissolved, my
become.
lord. The partnership deed may kindly be perused. Partnership not dissolved at all.
No, it is a partnership at will.
No.
My lord,
no.
if they're challenging that the partner is not issued, that is a subject of criminal investigation. They
number
filed
30
FIR. We don't know what has
Sir,
happened to it.
Page number 30 and page number 30, my lord, clause 13 and 40. If during the continuance of the partnership, any partner dies or retires,
That
the
they
legal
may inform.
representative of the deceased partner or the retiring partner shall not be entitled to claim that the remaining partner shall not carry on the business under the firm name
Correct,
so and
well,
so.
that-
The goodwill of the firm shall belong to the continuing partner. The retiring partner or the legal representative of the deceased partner, if any, shall be entitled only to the amount standing in the credit of his personal account, including the capital account, as the date last taking of account, so and simple at 10% of interim, date of last so and so. Date of retirement as on the date of death, as the case may be, and he shall not be entitled to claim that assets of the firm be revalued or for any share of the goodwill of the firm, nor shall be entitled to demand the usage in the name of the firm or any other trade adopted by the firm.
My
My
lord,
lord, the partnership will continue.
we don't dispute that, but have they informed that at the time of retirement? All this has come to light after the dispute. What prevented them in 2020
My lord,
itself?
I've written them the multiple letters.
No, my lord, have they have not produced any letter before 2021?
Without
Before.
any authority, my lord, they can't seize my accounts, my lord. They cannot freeze my account, my lord. There should be an order from the court. If there is an order from the court, my lord, they're justified. If there is no order from any statutory authority.
ಆಯ್ತು ಇದು ಒಂದ್ ಕಡೆ ವಾಟ್ ಹ್ಯಾಪೆಂಡ್ ಆಫ್ಟರ್ ದಟ್ ನೋಟಿಸ್ ವಾಸ್ ಇಶ್ಯೂಡ್
Which notice, my lord?
ದಟ್ ಒನ್ ಆಫ್ ದಿ ಪಾರ್ಟ್ನರ್ಸ್ ಪಬ್ಲಿಷ್ಡ್
There is a suit pending, my lord.
Huh?
There is a suit
Yes.
pending.
For
before-
what?
Suit for party, the accounts.
Huh?
Suit for accounts.
Dispute.
Petition of accounts,
Yes, ma'am.
which means the partnership will still continuing.
Partnership is continuing.
Continuing.
Continuing. My lord, even his letter also, my lord, he has writes a letter, my lord, the same retiring partner, I may trying to place on that letter, my lord. Saying that you also see us, my lord, I'm retiring from the firm.
Lord, this they have not produced before the bank, my lord. This is 2020. My lord, if there is any change,
How could you unilaterally freeze the account
my lord, this is
at the
only,
instance of one partner?
my lord, also
Retiring
other
partner.
two partners have
That is
come up
what
with
we
them.
have held in that this judgment at annexure F.
Yes, my lord.
Cannot
My lord,
do
it
it.
is- My lord, it is in fact the partnership firm which has requested for freezing, my
Well,
lord, in
there may
this.
be several disputes between the partners. It is bound to happen.
Yes, my lord.
But just because one of the partners publishes some notice in the newspaper, can you take note of that one and freeze the account?
That amounts to dissolution, my lord. The partnership is dissolved. And so therefore
They
the
have to come
liabilities
before,
is,
they have to come before you and say, yes, we have dissolved the partnership firm. We do not want to continue the partnership firm and therefore close this account.
my lord, they have issued a
There is
paper
the question of
publication.
freezing the account.
My lord, My lord, this is a question of loan liabilities, my lord. And so therefore, based on the paper publication, based on the letter issued and continuous mails received, and also letters issued by the other partners, we have frozen the account, also sought for explanation from the petitioner.
We have held,
My lord, in this case, my lord, my lord, the earlier case is where the partnership firm itself is one of the parties asking for freezing of the accounts. In this case, my lord, at page 43, earlier this judgment, my lord, it is the case where the partnership firm itself has asked for freezing of the account. In this case, it is not a partnership firm, it's one of the partners.
Again, it's one individual managing partner.
My lord, yes, my lord, in this case, there is no dispute. It was sought. My lord, it is because there were irregular online transactions and misappropriation of funds, which is why the managing partner representing the partnership firm has sought for freezing. And thereafter, once the same person is sought for defreezing. So, my lord, my humble submission is it is not applicable to this case where there's a dispute.
There is a dispute here also. That is why we have said, if there is a dispute, parties have to go to the civil court. And if there is any order passed by the civil court directing freezing of the account or closure of the account, then you can proceed. How can you do it at the instance of one of the partners?
My lord, 3 other partners, my lord, it is.
And the suit is still pending. Consideration.
Yes, my lord, dispute is still pending. In fact, they have filed an FIR, which is investigation is still going on their
Declaration
allegations.
that the partnership is closed.
But then this is a dissolution which has happened, which is of course in dispute. Yes, my lord. But then there is a public notice which is issued. There are liabilities involved of several crores. And tomorrow we don't want the partners to.
Undertaking, my lord, that liability is cleared. If that liability is not cleared, my lord, let them freeze the amount to that amount, the rest of the amount, let me transact with them. That is the only bank, my lord, I'm transacting. 15.5 crores are my assets with them. And liability, my lord, 2.98 crores. That is also cleared, my lord. In case even if they have doubts, my lord, the 2.98 crore may they let them keep towards their liability. Let me transact on the remaining amount, my lord, on 13 crores. My lord, that entire amount liability has been cleared. Entire liability has been cleared.
We've not. I have to get a confirmation of the bank as far as
Subject to
my lord,
that, my
there
lord,
are 2
let me
accounts.
transact.
Why you not made the other person a party respondent here?
The retiring partner, my lord.
Yes.
And several 2 other partners.
I'm not arrayed him as a party.
Why?
He has been retired, my lord. There is a resolution passed.
They have not
For us.
produced, my lord.
I produced it.
Here, not to the bank.
there
There
is a
are 2
resolution.
other partners, my lord. May kindly see at page 25, my lord. Lord, also we don't want to expose ourselves to another liability of third other warring partners, my lord. Other 2 partners have disputed the very
My lord,
retirement.
I'm giving an undertaking, my lord. Whatever the liability arises, because of this, my lord, I'm undertaking to make good of that such liability, my lord. They cannot freeze my account, my lord. They don't have any right without there being an order, my lord, from any statutory authority. From last 100 years, I'm banking with them, my lord. My relationship with them is from last 100 years. And there is FIR registered against the person who has issued this letter, my lord, B.R. Kamath. The charge sheet was filed against him.
The partnership firm had borrowed any money from you?
Yes, my lord. That is why we froze the
What
account.
action did you take?
My lord,
Recover the amount?
No, it is-
That's clear, my lord. That's clear.
Huh?
That is clear.
I'll get a
2.98.
confirmation about that. My lord, there are 2 accounts. One is current account, one is CC loan account, my lord, for which they've mortgaged the property. That they've been servicing the interest, my lord. So therefore, it is not declared as NPA. But insofar as liabilities, yes, my lord.
How will they pay it? If the partnership firm is no more, how will they pay it?
My lord, those
Should help
4
me to
accounts
go,
have been frozen, my lord.
Receive the money from them, but you freeze the account.
My lord, current account has been frozen, my lord, and the CC loan account.
They should at least help me to grow, my lord, because I'm giving them the business.
the petitioners are aggrieved of the freezing of their current account
Two accounts, my lord. Current account and the CC loan account, my lord. The
and
cash credit account.
cash credit account
Cash credit
On
facility
book
against
debts, my lord.
books of debts.
CCB.
at the hands of the respondent bank. Full stop. It appears that the respondent bank has proceeded to take such an action pursuant to a public notice
Dated 21/1/2021.
appearing in a newspaper on 21/1/2021.
Not yet appointed.
That all the partners have decided to dissolve the partnership firm in the name and style of Messrs. School Book Company, comma, with effect from 30/1/2021. Full stop. Next para, learned counsel for the petitioner submits that petitioner number 1 partnership firm has been in existence for more than a century and assets worth more than 15.5 crores are mortgaged to the respondent bank. The liability of rupees 2.98 crores have been discharged and there was no occasion for the respondent bank to have taken such a step without informing all the other partners in the partnership firm and seeking their opinion. Full stop. Moreover, comma, it is submitted that who has filed the suit?
The
One of the partners.
The
arbitration.
retiring partner.
Why, retiring partner, arbitration, initiated,
Suit.
arbitration proceedings,
Arbitration.
arbitration proceedings.
The retiring partner has initiated arbitration proceedings.
Arbitrator is not appointed, notices have been issued.
And the decision to close down the partnership firm is yet to be taken. Full stop. Under these circumstances, the respondent bank would not have freezed the accounts of the petitioner. Full stop. Reliance is also sought to be placed on a decision of this court in the case of Messrs. Credible Technology and Services and another versus the Chief Manager, comma, State Bank of India in WP number 4972 of 2020, dated 13th of March 2020. Full stop. Next para, learned counsel for the respondent bank seeks for a short accommodation to secure instructions regarding the submissions made by the learned counsel for petitioner that all the liability
I'll secure instructions.
has been cleared
In the
at the
process,
hands of
during the pendency.
partnership firm. Full stop. Next para. Release this matter on 29th of January.
Yes, I'll take instructions.
Yes.
Case number 65. Prasanna VR.
Yes.
But the writ of mandamus lord has been filed by the petitioner seeking directing the respondent number 2 and 3 to consider the representation of the petitioners by annexure A and B, my lords. Lord, the fifth respondent, my lord, is a society registered under the Cooperative Societies Act, my lords, has obtained the license to put up construction of commercial building from the Taluk Panchayat, my lord, Udupi. Then, my lord, he has the fifth respondent obtained the license and started to put up construction in the absence of any approach road, my lords. Therefore, the petitioner, my lord, wanted to, my lord, made an inquiry as to the existence of road to the commercial building to be put up by the society. Lord, then the petitioner noticed that, Lord,
Who are you?
Lord, I am the Lord, we are the members of the society. Lord, the committee of the society, my lord, wanted to put up constructions by encroaching the property of the forest department. Therefore, a representation is made. Tomorrow, my lords, it will be the money of the members and public, Lord, who will going to suffer. Therefore, a representation has been made before the forest department. Now, my lords, this government has filed a statement of objections. Lord, in which, my lords, they have stated that
Para number 2 of statement of objection.
there is no approach road, my lords, as admitted by the government. Para number 2 of the statement of objections, my lord, kindly see.
Yenri, you are acting prejudicial to the interest of the
Lord,
whole society.
My lord, it is.
What is this you are trying to do?
My lord, kindly see, my lords, the management of the society, my lord, has misappropriated certain amount.
We will
And-
direct them to remove you from membership. If you are not happy, please go away from the society.
My lord, it is
What is
not-
this you are trying to
My lord,
do?
it is not like that, my lords. I am only bringing to the notice of the government.
Now the government is saying no such encroachment.
My lord, they.
What
Kind-
more survives for
But
consideration?
kindly see, my lords.
Huh?
Kindly
You
see.
are acting prejudicial to the interest of your own
No,
society.
no, no.
On
Lord,
that
it is
ground
incorrect.
itself, they should remove you.
Lord, it is incorrect. Lords, kindly see, my
We will
lords.
direct them to consider this and we will dispose of the writ petition. In the light of the statement of objection
Please,
filed by the
Please,
respondent.
please,
Barkali.
please, please.
The petitioners claiming to be members of the fourth respondent society are before this court complaining that the fourth respondent society has secured a building license from the Gram Panchayat,
Taluk Panchayat, my lords. Udupi
Taluk Panchayat ಬರೋದಿಲ್ಲ.
Lord, annexure F, my lords, kindly see, my lord, annexure
Gram
F.
Panchayat, it will be
Taluk paragraph-
either Gram Panchayat or municipality
But
or
This
corporation.
is, my lords, issued by the executive officer, Taluk Panchayat, Udupi, my lords.
Building license ಅವ್ರು ಕೊಡಕ್ ಬರೋದಿಲ್ರಿ.
ಇದು ಅಲ್ಲ building license, my lord, issued by the Grama Panchayat.
Gram Panchayat, concerned Gram
Plan
Panchayat.
approved, my lords, by the.
ಬರೋದಿಲ್ಲ. ತಾಲೂಕ್ ಪಂಚಾಯತ್ ಬರೋದೇ ಇಲ್ಲ, ಪವರ್ಸೇ ಇಲ್ಲ.
Like building lots sanction license issued by the Grama Panchayat lots, before which lots they have taken the lot plan, lot single layout plan
ಬರೋದಿಲ್ಲ.
from the
ತಾಲೂಕ್
competent
ಪಂಚಾಯತ್
authority.
ಪವರ್ಸೇ ಇಲ್ಲ. Under which provision?
Lot single.
It will come under the Karnataka Town and Country Planning
Yes,
Act.
lot
Gram Panchayat
Grama Panchayat has issued a license.
Yes.
Grama Panchayat has issued a license pursuant to the lot.
So, however,
Please.
it is the contention of the petitioners that there is no access to the commercial building sought to be put up by the fourth respondent society. And according to the petitioners, while making an access to the building, the society is encroaching upon public property.
Forest land.
Forest land. Forest land ಹೆಂಗ್ರಿ ಆಗುತ್ತೆ?
ಅಲ್ಲ ಅವರು.
What is this?
ಅಲ್ಲ forest land, I have produced this sketch.
ಗ್ರಾಮ ಪಂಚಾಯತ್ ಅಂತಂದ್ರೆ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಲಿಮಿಟ್ಸ್ ಒಳಗಿಡೋದು ಬಿಲ್ಡಿಂಗ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಕೊಟ್ಟಿದ್ರೆ
ಹೌದು. ರೋಡ್ ಆಕ್ಸೆಸ್ ಇಲ್ಲ ಅಂತ ನಮ್ಮ ಕ್ಲೈಮ್.
ಗ್ರಾಮ ಪಂಚಾಯತ್ is permitted to give such permission only in respect of the ಗ್ರಾಮ ಠಾಣ.
Lord, property belongs to the,
ಬರೋದಿಲ್ಲ.
property belongs to the fourth respondent, there is no dispute.
ಹಾ.
Lord, they have obtained the license, there is no dispute.
ಗ್ರಾಮ್ ಅಂದ್ರೆ ಮತ್ತೆ ಫಾರೆಸ್ಟ್
ಇಲ್ಲ, forest ಇದೆ ಅಲ್ಲಿ, reserve forest, I have produced the RTC also.
That is why they have filed a statement of objection clearly stating, no, we don't have any such forest.
65 meters ಅದು ಫಾರೆಸ್ಟ್ ಒಳಗಡೆ ಆದ ಹೋಗುತ್ತೆ ರೋಡ್.
ಇದೆ.
ಮೀಟರ್ಸ್ ಮಾತ್ರ ಈ ಫಾರೆಸ್ಟ್ ಒಳಗಡೆ ಹೋಗುತ್ತೆ
ಆ?
65 meters ಮಾತ್ರ. ಸೊ ಅದ್ರೊಳಗಡೆ ನಾವು ಅದನ್ನ ಡಾಂಬರೀಕರಣ ಮಾಡಕ್ಕೂ ಬಿಡ್ತಾರೆ, ಅದು ಓನ್ಲಿ ಮಡ್ ರೋಡ್
ಕಚ್ಚಾ road ಇದೆ, ಅದನ್ನ ನೀವು
ಅಪ್ರೋಚ್ ಮಾಡಕ್ಕೆ ಯೂಸ್ ಮಾಡ್ತಾ ಇದ್ರೆ ಅದನ್ನ ನಾವು ಡಿಸ್ಟರ್ಬ್ ಮಾಡಕ್ಕೂ ಆಗೋದಿಲ್ಲ.
Have you filed any photograph?
Lord,
ನೀವು ಆದ್ರೂ ಮಾಡಿದಿರೇನ್ರಿ?
ಇಲ್ಲ, photograph
Statement of objection ಅಲ್ಲಿ?
sketch I have produced, my lords, annexure E.
ಹಾ?
Annexure E is the sketch, my lords, RTC, my lord, annexure C.
ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಪ್ಯಾರಾ ನಂಬರ್ 2
ಏನ್ ಹೇಳಿದೆ? Forest lands. Full stop. Next para. Statement of objections have been filed at the hands of the Deputy Conservator Forest, Kundapura, where it is clearly stated that the allegation of the petitioners that the fourth respondent is forming a road in the forest land is totally incorrect. Full stop. It is stated that neither there is any encroachment of forest land nor formation of any new road on forest land, at the hands of the fourth respondent. Full stop. Next para. In that view of the matter, this court finds that the petitioners are acting inimical to the interest of their own society. Full stop. Consequently, the writ petition stands dismissed while directing the fourth respondent society to take action against the petitioners for such inappropriate behavior on the part of the petitioners who make allegations against their own society which are totally unfounded.
May I make one request, my lord? ಅವರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಕಚ್ಚಾ ರೋಡ್ ಅಲ್ಲಿ ಯೂಸ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ, we are not allowing them to make a.
Yes.
66.
Right.
Prasad BS. 66.
Hearing for the petition, my lord. Actually, praise time for the hearing.
Huh?
For next week.
At the request of learned counsel for petitioner, release this matter on 29th of January.
67. SP Prakash.
Connected matter.
67.
67 amma. 67
For the respondent.
ನೀವು petitioner ಇದರಲ್ಲಿ.
ಅದ್ರಲ್ಲಿ
ಹಾ.
kindly have it next week, 29, kindly.
At the request of learned counsel for petitioner, release this matter on 29th of January.
Appear for petition in this matter.
Pasha.
But the petitions, but the petitioners are, my lord, slum dwellers, mostly scheduled caste people, my lord. But looking into their, my lord, economical condition, my lord, the BDA under Swayam Narav Yojana, my lord, in the year 1994 had constructed 36 units in a 3-building, my lord, apartment and given houses. But since, my lord, those measuring, my lord, 8 into, sorry, my lord,
Ramnagara constituency,
illi CV Raman Nagar constituency,
CV Raman Nagar.
Yes. Bangalore.
Ah, ah.
So, my lord, since, my lord, those buildings, my lord, they were in a not livable condition, it was in dilapidated condition. But some NGO, my lord, observing the condition, my lord, approached the slum board to, my lord, to take over the property and reconstruct the houses and give it to, my lord. But the slum board, my lord, went, my lord, observed, my lord, the condition of the building, my lord, and returned to the, my lord, the BDA. Subsequently, the, my lord, BDA, by the intervention of Honorable Lokayukta, my lord, transfer the record to the slum board. But now, my lord, the slum board is, my lord, delaying the construction. Lord, in the last previous date of hearing, Lord, this honorable court, Lord, there is some order has been passed. Where they undertook, Lord, there is a scheme, Lord, the central government scheme and the state government scheme, Pradhan Mantri Awas Yojana, under which, Lord, 3 counts, Lord, some portion of the amount, Lord, the central government scheme will be given. Lord, under the state government, Lord, some portion of amount will be given. The rest, Lord, the petition should undertake to pay. Lord, the petitioners were ready, Lord. Petitioners were ready to, Lord, pay their shares, whatever, Lord, provided, Lord, the slum board, Lord, undertakes, Lord, to develop the property. The order passed, Lord, on 8/11/2024.
7.61 lakhs.
Yes, Lord.
For what?
For, Lord, the construction estimation, Lord.
Of what building?
Of each unit, of each unit of the apartment, which is, Lord.
ಹೆಂಗ್ರಿ ಆಗುತ್ತೆ 7.61 lakhs ಅಲ್ಲಿ ಏನ್ರಿ ಆಗುತ್ತೆ?
ಅಲ್ಲ ಅದು
ಅಲ್ಲ, ಇದು 8 by
ಜಾಗನೇ
18.
ಅಷ್ಟಿರೋದು
8/18.
8/18.
8/18.
18.
All of them
ಅಲ್ರಿ, it's a multi-storied building.
ಹೌದು.
now multi-story building.
Each share, Lord, there are 36 units. 36 each unit, Lord, our estimation ಪ್ರಕಾರ 7,56,61,000. ಅದರಲ್ಲಿ ಪ್ರಧಾನ ಮಂತ್ರಿ, Lord, your lordship will see, Lord, page number 58. This slum board resolution, Lord. Para 3, ರಾಜೀವ್ ಗಾಂಧಿ ವಸತಿ ನಿಗಮಕ್ಕೆ ಈಗಾಗಲೇ ಸಲ್ಲಿಸಿರುವ ಯೋಜನೆಯ ವರದಿ ಅನ್ವಯ ಪ್ರತಿ ಮನೆಗೆ ಘಟಕ ವೆಚ್ಚ 7,61,000. 2018-19 estimation, Lord.
Sri Murugesh Charity appears for slum.
BDA.
BDA. This construction is to be done by whom now?
Slum board. BDS transfer the record, Lord.
PN Suresh Babu na?
ಹೌದು.
PN Suresh Babu.
ಹೌದು.
Where is he?
He was appeared last date of hearing.
ಏನಂತ ಹಾಕಿದ್ದಾರೆ ಅವರು ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಬ್ಜೆಕ್ಷನ್ಸ್ ಅಲ್ಲಿ?
Statement of the last date of hearing, Lord, they have undertook that, Lord, 36 units ಇದಾವೆ. ಅದರಲ್ಲಿ only 12 petitioners had come before the court. The others are joining ಅಂತ ಹೇಳಿ. Lord, I have submitted, Lord, there is apart from that space, there is other space. If they are not joining hands, Lord, to develop the entire property, they can construct, Lord, who are coming forward, and they can allot it. But anyhow, Lord, they have to make a deliberation, Lord, since the buildings are not in a condition of livable. It is in dilapidated condition. I have produced the photographs. Slum board has to take an action, Lord, either to, Lord, evacuate, Lord, the persons. Otherwise, Lord, it will be disastrous. ಎಲ್ಲ ರೂಫಿಂಗ್ ಎಲ್ಲ ಬೀಳ್ತಾ ಇದೆ.
Why BDA is necessary in this matter?
Since Lord, the BDA initially in the year 1994
Original lot.
under
Land allottees are BDA.
ಅವ್ರು ಮಾಡ್ಕೊಟ್ಟಿದ್ರು.
Original?
Original, the place where these people are staying. Now the building belongs to BDA.
BDA.
BDA. Is the BDA. when they
BDA
develop-
has constructed them Lord the
Already given
36
them.
units in a 3 apartments under Swayam Neravu Yojane and allotted to these petitioners. But these petitioners were not residing there from past
30 years.
BDA.
decades. Yes, BDA.
Under what scheme?
ಸ್ವಯಂ ನೆರವು ಯೋಜನೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಮಾಡ್ಕೊಟ್ಟಿದ್ದಾರೆ.
BDA.
BDA ಮಾಡ್ಕೊಟ್ಟಿದ್ದಾರೆ.
94 ಅಲ್ಲಿ.
94 ಅಲ್ಲಿ. 94 ಅಲ್ಲಿ. As per annexure A, my lord. Since my lord, now it is not in a livable condition, my lord, an NGO approached them, my lord, the slum board to take over the property. And
BDA has filed a statement of objections?
ಇಲ್ಲ, BDA has not given any. The BDA has transferred those records, my lord, that your lordship will get it, my lord. Annexure E. Resolution ಮಾಡಿ ಡಾಕ್ಯುಮೆಂಟ್ ಅವ್ರ ರೆಕಾರ್ಡ್ಸ್ ಎಲ್ಲ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ದಾರೆ. Annexure E ನಲ್ಲಿ. May I read, my lord? ಕರ್ನಾಟಕ ಕೊಳೆಗೇರಿ ಅಭಿವೃದ್ಧಿ ಮಂಡಳಿ ಆಯುಕ್ತರ ಪತ್ರ ಸಂಖ್ಯೆ ತಿಳಿಸದಂತೆ ಬೆಂಗಳೂರು ಅಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ ಸ್ವಯಂ ನೆರವು ಯೋಜನೆಯಲ್ಲಿ ನಿರ್ಮಿಸಿದ D1, D2, D3 ಬ್ಲಾಕ್ಗಳ ತಲಾ 12 ಫ್ಲಾಟ್ಗಳು ಒಟ್ಟು 36 ಫ್ಲಾಟ್ಗಳ ಕಟ್ಟಡ ಮತ್ತು ಬೆಂಗಳೂರು ಅಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರದ ಮಾಲೀಕತ್ವದಲ್ಲಿರುವ ಜಮೀನನ್ನು ಕರ್ನಾಟಕದ ಕೊಳೆಗೇರಿ ಅಭಿವೃದ್ಧಿ ಮಂಡಳಿ ಹಸ್ತಾಂತರ ಮಾಡುವ ಬಗ್ಗೆ ಹಾಗೂ ಫಲಾನುಭವಿಗಳಿಗೆ ನೀಡಿರುವ ಅನುದಾನದ ಬಗ್ಗೆ ನಿರಾಕ್ಷೇಪಣಾ ಪತ್ರ ನೀಡುವ ಬಗ್ಗೆ ಈ ಜಾಗದಲ್ಲಿ ಕೊಳೆಗೇರಿ ಅಭಿವೃದ್ಧಿ ಮಂಡಳಿಯಿಂದ ಪ್ರಧಾನಮಂತ್ರಿ ಆವಾಸ ಯೋಜನೆ ಹೌಸಿಂಗ್ ಫಾರ್ ಆಲ್ ಸರ್ವರಿಗೂ ಸೂರು ಯೋಜನೆಯಡಿಯಲ್ಲಿ ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರದಿಂದ ಅನುಮೋದನೆ ಪಡೆದು ಮನೆಗಳನ್ನು ನಿರ್ಮಿಸಿ ಬೆಂಗಳೂರು ಅಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರವು ಈಗಾಗಲೇ ಹಂಚಿಕೆ ಮಾಡಿರುವ ಫಲಾನುಭವಿಗಳಿಗೆ ಮನೆಗಳನ್ನು ಹಂಚಿಕೆ ಮಾಡುವ ಷರತ್ತು ವಿಧಿಸಿ ಮಾನ್ಯ ಲೋಕಾಯುಕ್ತರ ಆದೇಶದಂತೆ ಕರ್ನಾಟಕ ಕೊಳೆಗೇರಿ ಅಭಿವೃದ್ಧಿ ಮಂಡಳಿಗೆ ಸದರಿ ಜಮೀನು ಮತ್ತು ಕಟ್ಟಡವನ್ನು ಉಚಿತವಾಗಿ ಹಸ್ತಾಂತರಿಸಲು ಪ್ರಾಧಿಕಾರದ ಸಭೆಯ ನಿರ್ಣಯಕ್ಕೆ ಮಂಡಿಸಿದೆ. ಅದರಂತೆ ಪ್ರಾಧಿಕಾರ ಸಭೆಗೆ ತಯಾರಿಸಿರುವ ಟಿಪ್ಪಣಿಯನ್ನು ಮಾನ್ಯ ಆಯುಕ್ತರ ಮುಖಾಂತರ ಮೂಲಕ ಮಾನ್ಯ ಅಧ್ಯಕ್ಷರ ಅವಗಣನೆಗೆ ಮತ್ತು ಅನುಮೋದನೆ ಸಲ್ಲಿಸಿದೆ.
The entire property is handed over to the slum clearance board. Now they can't say, no, BDA is a necessary party. ಬರೋದೇ ಇಲ್ಲ.
Now the development has to be
So,
undertaken by.
Even under the provisions of the slum clearance act.
Yes.
And the powers vested with the slum clearance board, they should be having a provision.
Yes.
As to how to proceed.
Yes.
When such buildings constructed.
Yes.
By the board.
Yes.
Becomes dilapidated and becomes unusable.
Yes.
They can't now
BDA
try to
cannot go
shift the
back.
blame to BDA. ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. Have they said anything about
Declaration of a slum.
BDA has not filed any objection. BDA has transferred the records since they are not declined to to
ಏನು ಕರ್ನಾಟಕ ಸ್ಲಮ್ ಕ್ಲಿಯರೆನ್ಸ್ ಆಕ್ಟ್ ಅಂತ ಇದೆಯನ್ರಿ? ಕೊಡಿ.
There, my lord, it has to be declared as a slum.
ಅದೆಲ್ಲ ಆಯ್ತು. ಅದಾದ್ಮೇಲೆ once construction is made by the board and allotment is made, how to go about that ಅಂತ? If the building becomes dilapidated.
But here it is struck that now the prayer here is to construct a fresh building.
ಅಲ್ಲ, ಅವ್ರ ಪ್ರೇಯರ್ ಏನಾದ್ರು ಇರ್ಲಿ. That is why I am asking, there should be some provision for the board itself as to how to proceed in such conditions. Even many constructions are put up by the slum clearance board, and if they become dilapidated, how to go about that ಅಂತ ಅವ್ರಿಗೆ ಪ್ರಾವಿಷನ್ ಇರ್ಬೇಕಲ್ಲ.
Redevelopment.
ಬರ್ಕೊಳ್ಳಿ. Matter is called out. There is no representation for the fourth respondent. For the second respondent, Karnataka Slum Clearance Board, Slum Development Board. Full stop. This court finds in the statement of objections filed at the hands of the board, that initially the construction of the multi-storied building were put up by the Bangalore Development Authority.
Please.
Under the Pradhan Mantri Awas Yojana scheme.
ಅಲ್ಲ ಸ್ವಯಂ ನೆರವು ಯೋಜನೆ ಅಂತ ಹೇಳಿ ಸ್ವಯಂ ನೆರವು ಯೋಜನೆ ಅಂತ ಹೇಳಿ 1994 ಅಲ್ಲಿ BDA
Under the Swayam Neravu
ಯೋಜನೆ
However, at annexure E is a resolution passed by the Bangalore Development Authority.
Annexure E and Annexure F, Lord. The records for transfer.
That the entire construction and the immovable property is transferred to the Karnataka Slum Development Board. At annexure F is the communication dated 7/3/2020, where the entire premises stands handed over to the
Slum Board.
Karnataka Slum Clearance Board, Slum Development Board.
Some development.
Full stop. Next para, in that view of the matter, comma, the statements made in the objections filed at the ends of the board.
Please.
That the Bangalore Development Authority is a necessary party to the proceedings and the construction has to be put up by Bangalore Development Authority, comma, cannot be accepted. Stop. Next para. The commissioner, comma, Karnataka Slum Development Board is hereby directed to place on record the relevant provisions which would enable the board to take up reconstruction of its dilapidated structures. Full stop. Next para. Learned AGA is directed to convey this order to the commissioner, second respondent commissioner, comma, for compliance. Release this matter on 4th of February.
We said part heard, Lord, so that we reach.
No, no. Yes.
6 to 9. N. Sriram Reddy.
Therefore, the respondent, Your Honor.
At the request of learned counsel for petitioner, release this matter on 29th of January.
Serial number 70, adjourn. Serial number 71, YK Narayan Sharma.
I appear for the plaintiff in this matter, my.
For the petitions, yellow petitions.
Yes.
All these matters relating to that concession during the COVID period, my lord. It was granted, then it is withdrawn. Of course, the balance we have already paid. There is only the disputed portion is remaining, and they have they are keeping that security deposit and not refunding that amount. That amount is a dispute so far as we are concerned, my lord. Similar are the matters like that. During COVID period, this is regarding Mysore KSRTC canteen. The canteen was closed for some time, and sometime there was no passage of the buses. All these things at that time government considered and directed them to give concession. Concession was given, and that concession is now withdrawn.
What concession?
Concession regarding the rent, my lord, the rent payable.
The bus terminals, not the shops and hotels.
ಬಸ್ ಸ್ಟ್ಯಾಂಡ್ಗಳಲ್ಲಿ ಹೋಟ್ಲು
ಎಲ್ಲ ಬಸ್ ಸ್ಟ್ಯಾಂಡ್ ಹೋಟೆಲ್ಗಳು
ರೆಂಟ್ ಫ್ರೀ ಮಾಡಿದ್ರು, ರೆಂಟ್ ಎಲ್ಲ ಡಿಡಕ್ಷನ್ ಕೊಟ್ಬಿಟ್ರು. ಈಗ ಅದನ್ನ ವಾಪಸ್ ಕೊಡಿ ಅಂತ
ವಾಪಸ್ ಕೊಡಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಕೋವಿಡ್ ಪೀರಿಯಡ್ ಎಲ್ಲ ಆದ್ಮೇಲೆ KSRTC ಲಾಸ್ ಆಗ್ತೈತೆ, ನಾವು ಕನ್ಸೆಷನ್ ಕೊಟ್ಟಿರೋದು ವಾಪಸ್ ತಗಂತೀವಿ ಅಂತ ವಾಪಸ್ ತಗೊಂಡು.
You are all tenants.
ಟೆನೆಂಟ್ಸ್, ಶಾಪ್ಸ್, ಹೋಟೆಲ್ಸ್,
The shops and hotels.
ಹೌದು, ಸಣ್ಣ ಸಣ್ಣ ಅಂಗಡಿಗಳು.
Mine is a little different, my lords, but same BMTC. I am a contractor for putting advertisements on buses. They told me during COVID period, whenever buses are not running, you don't have to pay. And after 4 years, now they are saying make payment. The issue therefore, my lords, is same. In today, my lords, they have served objections on me today in the afternoon. In 71.7, they have served objections on me today.
So in all these matters, Mr. P.D. Surana and H.R. Renuka are appearing for the
KSRTC
corporations. Yes.
Statement of objections have been filed.
ಹಾಕಿದ್ದಾರೆ ಅಷ್ಟೇ. ನಮ್ಮ
Some they are filed, not in all.
ನಮ್ಮದ್ರಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ.
4 or 5 months is the period. Subsequent court takes a decision, it will withdraw the concession. The amounts are somewhere in the range of around 5 lakhs, something around that. A period of around 4 to 5 months. What was given by them by way of a policy decision is taken away by the board by way of a policy decision. That is why I said they are precluded from taking the withdrawing concessions were already effective.
27/8/21, they give that concession. 21/3/2022, they withdraw.
Where is that concession?
Letters are referred to, my lord. They do not say there was no concession. They say that ಪರವಾನಿಗೆ ರದ್ದತಿ ಆದೇಶ ಅಂತ ಆಮೇಲೆ ಅಕ್ಟೋಬರ್ ಮಾಡಿದ್ದಾರೆ. That so we are saying that once it is granted, they are withdrawing it by this order, which is not permissible. That is an estoppel.
By which communication that concession was granted?
Earlier, my lord, during the COVID period. During COVID period. COVID period.
By means of resolution, my lord.
ನಿಮ್ಮ petition ಅಲ್ಲಿ ಎಲ್ಲಿದೆ, Mr. ನಾರಾಯಣ್ ಶರ್ಮಾ?
Please see page 20, my lord.
In my representation, I have produced my lord.
Imbaraha.
Yes, yes.
Annexure B.
Correct, my lord. Mahayana Shulka, etc., etc. There was a government order also, my lord. I could not get that order, and based on that, they gave the concession. So they refer to all that, and they say that now you pay the amount, we will deduct out of the security deposit.
ಎಲ್ಲಿದೆ concession? Where is that concession?
My lord, ನನ್ನ ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಅವ್ರದ್ದು ರೆಸಲ್ಯೂಷನ್ ರೆಫರೆನ್ಸ್ ಎಲ್ಲ ಹಾಕಿದ್ದೀನಿ ಸರ್. ಇನ್ ಮೈ ರಿಟ್ ಪಿಟಿಷನ್ 10,460 of 22.
The concession given is not in dispute, my lord. Whether they can withdraw it is the dispute.
10,460 of 22. Annexure A.
10,460.
ವಿಷಯ ಕೋವಿಡ್ 19 ಎರಡನೇ ಅಲೆ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಏಪ್ರಿಲ್ 21 ಮತ್ತು ಜೂನ್ 22 ಮಹಿಳೆ ನಿಗಮದ ಪರವಾನಗಿದಾರರಿಗೆ ಪರವಾನಗಿ ಶುಲ್ಕ ಪಾವತಿಯಲ್ಲಿ ನೀಡಲಾಗಿರುವ ವಿನಾಯಿತಿಯ ಬಗ್ಗೆ ಉಲ್ಲೇಖ. ದಿನಾಂಕ 27/8/21 ನಡೆದ CCG ಸಭೆಯಲ್ಲಿ ತೀರ್ಮಾನ. ಸೆಕೆಂಡ್ ಒನ್ ದಿನಾಂಕ 2/6/21. ಮೂರನೇದು ದಿನಾಂಕ 2/6/21. ಮೇಲ್ಕಂಡ ವಿಷಯ ಮತ್ತು ಉಲ್ಲೇಖಕ್ಕೆ ಸಂಬಂಧಿಸಿ ಏಪ್ರಿಲ್ 21 ಮಾಹಿತಿಯಲ್ಲಿ ದಿನಾಂಕ 7/4/21 21/4/21 14 ದಿನ ಸಾರಿಗೆ ನೌಕರಿ ನಡೆದಿದ್ದು ಬಸ್ ನಿಲ್ದಾಣ ನಿಗಮದ ಸಾರಿಗೆ ಪೂರ್ಣ ಪ್ರಮಾಣದಲ್ಲಿ ಕಾರ್ಯಾಚರಣೆ ಹಾಗೂ ಕೋವಿಡ್-19 ಎರಡನೇ ಅಲೆಯ ಭೀತಿಯ ಮುಂಜಾಗ್ರತಾ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸರ್ಕಾರವು ದಿನಾಂಕ 21/4/21 ರಾತ್ರಿ ಕರ್ಫ್ಯೂ, ವಾರಾಂತ್ಯದ ಲಾಕ್ಡೌನ್ ಇತ್ಯಾದಿ ಕಠಿಣ ನಿಯಮ ಜಾರಿಗೆ ತಂದಿರುತ್ತದೆ. ದಿನಾಂಕ 27/4/21 ರಾತ್ರಿ 9 ಗಂಟೆಯಿಂದ ದಿನಾಂಕ 12/5/20 ಬೆಳಗ್ಗೆ 6 ಗಂಟೆಯವರೆಗೆ ಜನತಾ ಕರ್ಫ್ಯೂ. ಪುನಃ ದಿನಾಂಕ 24/5/21 ಬೆಳಗ್ಗೆ 6ರಿಂದ ಗಂಟೆಯವರೆಗೆ ಲಾಕ್ಡೌನ್ ಘೋಷಿಸಿದೆ. ಏಪ್ರಿಲ್ 21 ಮಹಿಳೆಯಲ್ಲಿ ಜೂನ್ 21 ಮಹಿಳೆಯಲ್ಲಿ ದಿನಾಂಕ 20/6/21 ಲಾಕ್ಡೌನ್ ಮುಂದುವರೆದಿದ್ದು ಮೈಸೂರು, ಹಾಸನ, ದಕ್ಷಿಣ ಕನ್ನಡ ಮತ್ತು ಕೊಡಗು ಜಿಲ್ಲೆಗಳಲ್ಲಿ ದಿನಾಂಕ 5/7/21 ಮುಂದುವರೆದಿದೆ. ಈ ಕಾರಣಗಳ ಮೇರೆಗೆ ಏಪ್ರಿಲ್ 21 ಮತ್ತು ಜೂನ್ 21 ಮಹಿಳೆಗಳ ವಿನಾಯಿತಿ ಮೊತ್ತವನ್ನು ಇನ್ನಷ್ಟು ಪರಿಷ್ಕರಿಸಿ ನೀಡುವಂತೆ ಸಾಕಷ್ಟು ಮನವಿಗಳನ್ನು ಈ ಕಚೇರಿಯಲ್ಲಿ ಸ್ವೀಕರಿಸಿ ಪರಿಶೀಲಿಸಲಾಗಿದೆ. ಈ ಸಂಬಂಧ 27/8/21 ಮಾನ್ಯ ವ್ಯವಸ್ಥಾಪಕ ನಿರ್ದೇಶಕರ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ನಡೆದ CCG ಸಭೆಯಲ್ಲಿ ಸುದೀರ್ಘವಾಗಿ ಚರ್ಚಿಸಲಾಗಿರುತ್ತದೆ. ನಿಗಮದ ಬಸ್ ನಿಲ್ದಾಣ, ATM ಕೌಂಟರ್ ಮತ್ತು ಮೊಬೈಲ್ ಟವರ್ ಪರವಾನಗಿದಾರರನ್ನು ಹೊರತುಪಡಿಸಿ ಏಕೈಕ ಪರವಾನಗಿ ಒಳಗೊಂಡಂತೆ ಪುತ್ತೂರು PPC ಬಸ್ ನಿಲ್ದಾಣ ಸೇರಿ ಎಲ್ಲಾ ವಾಣಿಜ್ಯ ಮಳಿಗೆಗಳ ಪರವಾನಗಿದಾರರಿಗೆ ಬಸ್ ನಿಲ್ದಾಣ, ಬಾರ್, ಬಸ್ ಮೇಲಿನ ಜಾಹೀರಾತು ಪ್ರದರ್ಶನದ ಏಜೆನ್ಸಿದಾರರಿಗೆ ಹಾಗೂ ಸಾರ್ವಜನಿಕ ಉದ್ಘೋಷಣಾ ವ್ಯವಸ್ಥೆ PS ಪರವಾನಗಿ ಏಪ್ರಿಲ್ 21 ಮತ್ತು ಜೂನ್ 21 ಮಹಿಳೆಗಳಲ್ಲಿ ಮಾಸಿಕ ಪರವಾನಗಿ ಶುಲ್ಕ ಪಾವತಿಯ ಸಂಬಂಧ ಕೆಳಕಂಡಂತೆ ಕ್ರಮಗಳು ತಿಳಿಯುತ್ತದೆ. ಏಪ್ರಿಲ್ 21 ಮತ್ತು ಜೂನ್ 20 ATM ಕೌಂಟರ್ ಮತ್ತು ಮೊಬೈಲ್ ಟವರ್ ಹೊರತುಪಡಿಸಿ ಮೇಲ್ಕಂಡ ಎಲ್ಲಾ ಕರಾರು ಒಪ್ಪಂದವನ್ನು ನಿಗದಿತ ಮಾಸಿಕ ಶುಲ್ಕ 70 ಈಗಾಗಲೇ ನೀಡಿರುವ ಪರವಾನಗಿ ಶುಲ್ಕ ಮಾತ್ರ 20% ವಿನಾಯಿತಿ ನೀಡುವುದು ಮತ್ತು 30% ಪಾವತಿ GST ಸಭೆಯಲ್ಲಿ ಯಾವುದೇ ವಿನಾಯಿತಿ ಇರುವುದಿಲ್ಲ.
ಮೇಲ್ಕಂಡ ಎಲ್ಲ ಪರವಾನಗಿದಾರರಿಂದ ಕರಾರು ಒಪ್ಪಂದದನ್ವಯ ನಿಗದಿತ ಮಾಸಿಕ ಪರವಾನಗಿ ಶುಲ್ಕದಲ್ಲಿ 70% ವಿನಾಯಿತಿ ನೀಡುವುದು. ಈಗಾಗಲೇ ನೀಡಿರುವ 50 ಪ್ಲಸ್ ಮಾಸಿಕ ಪರವಾನಗಿ ಶುಲ್ಕಕ್ಕೆ
ವಿನಾಯಿತಿ ಮತ್ತು 30% ಮಾಸಿಕ ಪರವಾನಗಿ ಶುಲ್ಕ ಪಾವತಿಸಿಕೊಳ್ಳುವುದು. GST ಪಾವತಿ ಯಾವುದೇ ವಿನಾಯಿತಿ ಇರುವುದಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಹಾಲಿ 21 ಮತ್ತು ಜೂನ್ 21 ಮಹಿಳೆಗಳ ಮಾಸಿಕ ಪರವಾನಗಿ ಶುಲ್ಕವನ್ನು ಉಳಿಸಿಕೊಂಡಿರುವ ಬಡ್ಡಿ ರಹಿತವಾಗಿ ಪಾವತಿಯ ದಿನಾಂಕ 15/9/20 ಕಾಲಾವಕಾಶ ನೀಡುವುದು ಮತ್ತು ಈಗಾಗಲೇ ಪರವಾನಗಿ ಶುಲ್ಕ ಪಾವತಿ ಹೊಂದಾಣಿಕೆ ಮಾಡಿಕೊಳ್ಳುವುದು. ಜುಲೈ 21 ಮಾಹಿತಿಯಿಂದ ಮುಂದಕ್ಕೆ ಪರವಾನಗಿ ಶುಲ್ಕ ಪಾವತಿ ಯಾವುದೇ ಮೇಲ್ಕಂಡ ಅಗತ್ಯ ಕ್ರಮ ಕೊಳ್ಳಲು ಆಗಸ್ಟ್ 21 ಮಹಿಳೆಯಲ್ಲಿ ಪರವಾನಗಿ ಯಾವುದೇ ಬಾಕಿ ಮೊತ್ತ ವಸೂಲಿಗೆ ಕ್ರಮ ವಹಿಸಲು.
ಪರವಾನಗಿ ಶುಲ್ಕ ಅಂದ್ರೆ
ಲೈಸೆನ್ಸ್ ಫೀಸ್.
ಲೈಸೆನ್ಸ್ ಫೀ.
None of you are concerned with license fee.
ಇವ್ರದೊಂದೇ ಆದ ಅಡ್ವರ್ಟೈಸ್ಮೆಂಟ್ ಇದೆ.
ಇಲ್ಲ.
Advertisement.
None of you are
ನಮ್ದೆಲ್ಲ ಶಾಪ್ಸ್.
Only with payment of rent.
Payment of
70% rebate.
So annexure B is the
ಅಲ್ಲ ಒಂದು ನಿಮಿಷ ಲೈಸೆನ್ಸ್ ಫೀ ಅಂತ ಹೇಳಿ
ಲೈಸೆನ್ಸ್ ಫೀ ಅಂತ ಹೇಳೋದು ರೆಂಟ್ ಅನ್ನೇ ಅವ್ರ ಲೈಸೆನ್ಸ್ ಹೇಳೋದು.
they are a
Both
license.
mean the same, your lordships.
Because the PPI,
They are not claim.
and it cannot be termed as a license fee ಅಂತ ಹೇಳಿದ್ರೆ that is equivalent to rent. Leave and
ಅದೇ ಲೈಸೆನ್ಸ್
all
ಫೀಸ್.
consensual. License in
What
terms
we are
of
thinking is
permission.
only 70% rebate which they have given, they should not have withdrawn it.
my lord, annexure C is the notices given to the petitioners, my lord, who are running the hotel, my lord.
What was given was only April
Only 2 months. April
and June.
Only 2 months.
2 months.
2 ತಿಂಗಳಿಗೆ 70% ರಿಬೇಟ್ ಕೊಟ್ರು. ಅದನ್ನ ಅದಾದ್ಮೇಲೆ ಮತ್ತೆ
My lord, annexure C ನಲ್ಲಿ ಕ್ಲಾರಿಫೈ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. annexure C ನಲ್ಲಿ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದನ್ನ 6 ತಿಂಗಳದ್ದು ನಮ್ಗೆ ರಿಕವರಿ ಕೊಟ್ಟಿದ್ದಾರೆ. annexure C ಏಪ್ರಿಲ್ 21 13,180, ಮೇ 21, ಜೂನ್ 21,
After 6 or 7 months.
after 6 or 7 months. ಇದನ್ನ ಈಗ ರಿಯಾಯಿತಿ ಕೊಟ್ಟಿರೋದನ್ನ ನಮ್ಗೆ ವಾಪಸ್ ಕಟ್ಟಿ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ರಿ, ಅಲ್ಲಿ they have reduced it. You see, May, it is 15,966. Page number 19, annexure C.
ಪ್ಲೀಸ್ ಮೇಡಮ್.
ನಿಮ್ಮ ಪೆಟಿಷನ್ ಅಲ್ಲಿ
ಹೌದು.
ಮೇ ತಿಂಗಳದು 15,966.
ಮೇಗೆ 100% ವಿನಾಯಿತಿ.
ಮೇಗ 100% ವಿನಾಯಿತಿ.
Why? Where is it?
Even in the first COVID also there.
ಫಸ್ಟ್ ಕೋವಿಡ್ ಆಲ್ಸೋ 100% ವಿನಾಯಿತಿ.
ಎಲ್ಲಿದೆ ರೀ?
ನಮ್ಮ ಎನೆಕ್ಷರ್ ಎಫ್ ಅಲ್ಲಿ ಕ್ಲೀನ್ ಆಗಿದೆ ಅದು. ಎನೆಕ್ಷರ್ ಎಫ್ ಅಲ್ಲಿ ಇವ್ರು ಲಾಸ್ಟ್ ಕೈಲಿ ಎನೆಕ್ಷರ್ ಎಫ್ ಅಲ್ಲಿ ಪೇಜ್ 26 ಅಲ್ಲಿ ಕರೆಕ್ಟ್ ಆಗಿ ಅದನ್ನೆಲ್ಲ ಹೇಳಿದ್ದಾರೆ ಅವರು. ಹೇಳಿಬಿಟ್ಟು ವಾಪಸ್ಸು ಕೇಳಿದ ಪಾರ ಇದೆ, 2 ಪಾರವು ಅದರಲ್ಲಿ ಇದೆ.
ಅಲ್ಲ, ಇನ್ಫ್ಯಾಕ್ಟ್ ಏಪ್ರಿಲ್ ಮತ್ತೆ ಜೂನ್ ಆಸ್ ಡಿಸೈಡೆಡ್ 70% ರಿಬೇಟ್. ಸೊ 11,176 ಅಂತಾರೆ. ಇಟ್ ಈಸ್ ರೆಡ್ಯೂಸ್ಡ್. May 15,966 because that
reduce ಮಾಡಿ
resolution does not talk.
I may permitted to read the preamble. ಮೇಲ್ಗಡೆ annexure C ನಲ್ಲಿ preamble. ಕೋವಿಡ್-19 ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಏಪ್ರಿಲ್ 21, ಮೇ 21, ಜೂನ್ ಮಾಹೆಯಲ್ಲಿ ನೀಡಲಾಗಿದ್ದ ವಿನಾಯಿತಿಯನ್ನು ಹಿಂಪಡೆದಿರುವುದರಿಂದ ಪರವಾನಗಿ ಶುಲ್ಕ ಮತ್ತು ಇತರೆ ಶುಲ್ಕವನ್ನು ಪಾವತಿಸುವ ಬಗ್ಗೆ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಕೋವಿಡ್-19 ಎರಡನೇ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಬಸ್ ನಿಲ್ದಾಣ ವಾಣಿಜ್ಯ ಮಳಿಗೆಗಳ ಜಾಹೀರಾತು ಪರವಾನಗಿ ತಮಗೆ ಕರಾರು ಪಾವತಿಸಬೇಕಿದ್ದ ಮೊತ್ತದಲ್ಲಿ ಏಪ್ರಿಲ್ 21 ಮಹಿಳೆ 70% ಮೇ ಸಂಪೂರ್ಣ ವಿನಾಯಿತಿಯನ್ನು ಹಾಗೂ ಜೂನ್ 21 70% ವಿನಾಯಿತಿ ಕೇಂದ್ರ ಕಚೇರಿಯಿಂದ ನೀಡಿದ್ದು, ಅದರಂತೆ ತಾವು ಪರವಾನಗಿ ಶುಲ್ಕ ಇತರೆ ಶುಲ್ಕ ಪಾವತಿಸಿರ್ತೀರಾ. ಮುಂದುವರೆದು ಸದರಿ ಪ್ರಸ್ತಾವನೆಯನ್ನು 21/3/22 ಜರುಗಿದ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಸರ್ಕಾರ ನಿಗಮ ನಿರ್ದೇಶಕರ ಮಂಡಳಿ 447 ಸಭೆಯಲ್ಲಿ ಮಂಡಿಸಲಾಗಿದ್ದು, ಸದರಿ ಪ್ರಸ್ತಾವನೆ ಮಂಡಳಿ ಸಭೆಯು ತಿರಸ್ಕರಿಸಿದೆ ಎಂದು ಉಲ್ಲೇಖದಲ್ಲಿ ಪತ್ರದ ಮುಖ್ಯ ಸಂಚಾರ ವ್ಯವಸ್ಥಕರು ತಿಳಿಸಿ, ಸದರಿ ಅವಧಿ ನೀಡಿರುವ ವಿನಾಯಿತಿಯು ಪೂರ್ಣ ಮೊತ್ತವನ್ನು ಸಂಬಂಧಿಸಿದವರನ್ನು ವಸೂಲಿ ಮಾಡುವಂತೆ ತಿಳಿಸಿರುತ್ತಾರೆ. ಫುಲ್ ಅಮೌಂಟ್ ವಿಡ್ರಾನ್ ದಿ ಬೆನಿಫಿಟ್.
ಅದನ್ನ ಅವರ ಎನೆಕ್ಷರ್ ಎಫ್ ಲೆಟರ್ ಅಲ್ಲಿ 22 ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳಿದ್ದಾರೆ. ದೀಸ್ ಆರ್ ದ ಕನ್ಸಿಷನ್ಸ್ ಗಿವನ್, ಇದನ್ನು ಹಿಂಪಡೆಯಲಾಗಿದೆ, ಅದನ್ನು ಕೊಡಿ ಅಂತಲೇ ಕೇಳಿದ್ದಾರೆ. ಎನೆಕ್ಷರ್ ಎಫ್ ನನ್ನ ಕೇಸಲ್ಲಿ ದೇ ಹ್ಯಾವ್ ಅಡ್ಮಿಟೆಡ್ ಇದು ಕೊಟ್ಟಿದೆ, ಅದನ್ನು ಮತ್ತೆ ಹೇಳ್ತಾರೆ ಹಿಂಪಡೆಯಲಾಗಿದೆ, ವಿನಾಯಿತಿಯನ್ನು ಹಿಂಪಡೆಯಲಾಗಿರುತ್ತೆ, ಅದನ್ನು ಕಟ್ಟಿಕೊಡಿ ಅಂತ ನೆಕ್ಸ್ಟ್ ವಾರ ಎನೆಕ್ಷರ್ ಎಫ್ ಪೇಜ್ 26 ಅಲ್ಲಿ ನನ್ನ ಪಿಟಿಷನ್ ಅಲ್ಲಿ. ಅದನ್ನು ಐ ಡಿಡ್ ನಾಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಅರ್ಲಿಯರ್ ಒನ್, ಅವರು ಒಪ್ಪಿಕೊಂಡದ್ರಿಂದ. ರೇಟು ತಿಂಗಳು ಎಲ್ಲ ಹಾಕಿದ್ದಾರೆ ಅದರಲ್ಲಿ ಅವರು ಡಿಟೇಲ್ ಆಗಿ.
ನಿಮ್ಮ annexure D melod clearly they have written the letter melod. Annexure D page number 26.
Though there was a proposal sent, the board has not accepted it.
ಹೌದು,
That is
ಅದನ್ನ
what they are saying.
ಮುಂಚೆ ಎಲ್ಲ ಇದು ಬೆನಿಫಿಟ್ ಕೊಟ್ಟಿದ್ದನ್ನ ವಾಪಸ್ ತಗೊಂಡಿದ್ದಾರೆ.
No, it was a proposal sent.
ಪ್ರಪೋಸಲ್ ಕೊಟ್ಟಿದ್ದು ಒಪ್ಕೊಂಡ್ಬಿಟ್ರು. ಆಮೇಲೆ ಅಲ್ಲಲ್ಲ ದೇರ್ಫೋರ್ ಮೇಲೆ annexure B ನಲ್ಲಿ ಇಟ್ ಇಸ್ ಕ್ಲಾರಿಫೈಡ್ ಮೇಲೆ annexure B ನಲ್ಲೇನೆ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರು.
ಆ 3522 ಲೆಟರ್ ಅಲ್ಲಿ ಕ್ಲೀನ್ ಆಗಿ ಹೇಳಿದ್ದಾರೆ. ಐ ಕ್ಯಾನ್ ಪಾಯಿಂಟ್ ಔಟ್ ದಟ್ ಕ್ಲಿಯರ್ಲಿ. ಇಟ್ ಈಸ್ ನಾಟ್ ಅ ಪ್ರಪೋಸಲ್, ಇಟ್ ಈಸ್ ಆಕ್ಸೆಪ್ಟೆಡ್ ಬೈ ದೆಮ್ ಅಂಡ್ ಗ್ರಾಂಟೆಡ್ ಅಂತಲೇ ಇದೆ.
annexure C ನಲ್ಲಿ ಅದನ್ನ ಕ್ಲಾರಿಫೈ ಮಾಡಿದ್ದಾರೆ. ವಿಡ್ರಾ ಮಾಡಿದೀವಿ ಅಂತ, ಕೊಟ್ಟಿದ್ದನ್ನ ವಿಡ್ರಾ ಮಾಡಿದೀವಿ ಅಂತ ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳಿದ್ದಾರೆ. ಪ್ಯಾರಾ annexure C ನಲ್ಲಿ ಪ್ಯಾರಾ 3 ಮೈಲಾಡ್ ಮುಂದುವರಿದು ಸದರಿ ಪ್ರಸ್ತಾವನೆಯನ್ನು ದಿನಾಂಕ 21/3/22 ಜರುಗಿದ ಕರ್ನಾಟಕ ನಿಗಮ ನಿರ್ದೇಶಕರ ಮಂಡಳಿಯಲ್ಲಿ ನಾನು ಸಭೆಯಲ್ಲಿ ಮಂಡಿಸಲಾಗಿದ್ದು, ಸದರಿ ಮಂಡಳಿಯು ಸಭೆ ತಿರಸ್ಕರಿಸಿ ಎಂದು ಪತ್ರದಲ್ಲಿ ಮುಖ್ಯ ಸಂಚಾರ ವಿನಾಯಿತಿ ಪೂರ್ಣ ಮೊತ್ತವನ್ನು.
But the board has not accepted it.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇದು ಇಫ್ ಐ ಆಮ್ ಡಿಸ್ಟರ್ಬಿಂಗ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್, annexure ಎಫ್ ನೋಡಿ ನನ್ನ ಕೇಸಲ್ಲಿ 26ರಲ್ಲಿ.
Now you will have to convince the court.
No, you annexure ಎಫ್ ನೋಡಿ ಸ್ವಾಮಿ ನನ್ನದ್ರಲ್ಲಿ.
Even if it's a concession given, and if the board were to reconsider and say it cannot be granted, how can we compel them?
My lord, it's
Or
because of COVID
direction.
situation, my lord, we are not asking any during if there is businesses are running, my lord, in these circumstances, because of COVID, my lord, they have taken decision. ಈಗ ನಾವು ಯಾರು ಬಿಸ್ನೆಸ್ ಮಾಡಿಲ್ಲ 2 ವರ್ಷ ಸುಮ್ಮನೆ ಇದ್ವಿ. ಈಗ ಒಬ್ಬೊಬ್ರಿಗೂ 1 ಲಕ್ಷ 2 ಲಕ್ಷ ಕಟ್ಟಿ ಅಂತಾನೆ. It is my lord.
You are
In the interest of
you are talking only of 2 months. ಅಷ್ಟೇ.
ಅಲ್ಲ ನಂದು 2 months, ಕೆಲವ್ರದೆಲ್ಲ ಜಾಸ್ತಿ ಇದಾವೆ.
How?
Resolution ಪ್ರಕಾರ
Concession, if at all given,
please my lord,
was only for 2 months.
yes my lord. ಆ 2 months ನೇ
Beyond that, you cannot ask for anything.
ಇಲ್ಲ ಬೇಕಿಲ್ಲ ಅಷ್ಟೇನೆ. ನಾವು 2 months ತಾನೇ ಕೇಳೋದು.
ಆ 2 months ಕೂಡ, how can you say, no, they should be bound by their.
ಅಲ್ಲ ಅವರೇ ಕೊಟ್ಬಿಟ್ಟು ಅವರೇ ವಾಪಸ್
Correct, sir.
ಸರಿ ಅದ್ ಸರಿ. ಇನ್ ದಿ ಸರ್ಕಮ್ ಕೋವಿಡ್ ಇರೋದ್ರಿಂದ
See,
so the
what
intelligence of the Sam court, my lord,
Please understand.
please my lord,
Even when RBI issued guidelines
please my lord,
to all the banks for recovery of the loan, what was directed was that for those months, even if EMI is not paid, don't take action. But you are required to pay it subsequently. It cannot be waived off.
Again, it was optional.
here is different, my lord. Here, my lord, we are running the business.
Udri, what constitutional right do you have?
We don't have.
It is only a concession.
We are further discriminated. The
Yes.
Sister concern BMTC, similar benefit they have given and they have extended it. They have not withdrawn it. But so far as this case is concerned, they are doing like this.
It is a sister concern.
Ah.
When they both are same department, one department is giving concession, another department, same this thing department is denying benefit to the.
Lord, Madras High Court in somewhat similar circumstances, Learned single judge relies not on section 51 of the Contract Act and says, if the facility is not made available by you to the licensee, for example, what's here in my case, bus is not flying, then the Madras High Court says, for that time it is also contractually required that because facility is not made available, the reciprocal liability to pay will not arise. That is the rationale employed. To say, therefore, during the existence of COVID, whenever facility is not open, for example, in this case, if the shop itself cannot be opened, they say for that time one may not be required to pay fees. That is the premise.
Also, my lord, there were 4 circulars. What has been withdrawn is the benefit given under 2 circulars. And it is a settled position, my lord, that circulars are binding on the department which has issued them. And now internally, they cannot say a higher authority has now withdrawn the circular and then. That is settled position.
Starts my lords at page 240. Just show my lords the first paragraph to show that facts are somewhat similar. Then I'll directly go, my lords, to para 9. Petition filed under 226 to issue a writ of mandamus forbearing the respondent from demanding license fee from the petitioner for the period from so and to reduce, revise and refix the license fee in a manner proportionate with the opening time permitted for the period from so for municipal shop number so Christopher Basan, Nagarkoil in view of COVID-19 pandemic. Then your lordship and lord, please come to para 9, page 248. The question is whether notwithstanding the stipulation of absolute performance cast on the licensee, the court would be justified in treating the lockdown as a forced event, which will release performing his obligation corresponding. My answer is affirmative. Section 51 of the Indian contract states that when a contract consists of reciprocal promise to be simultaneously performed, no promisor will perform his promise unless the promisee is ready and willing to perform his reciprocal promise. As per 54, performance cannot be same in the other has been performed. The local body must keep the bus stand open and in good repair. The licensee must be permitted to keep the license shop open. If the local body has directed the licensee to close down the shop, it cannot demand fee from the licensee for the period when the shop remains closed. Of course, the licensee must be free of any wrongdoing. If the licensee is made to suffer for no fault of his own, by direction to close down the shop, then the question of payment of fee, right? This is clearly an implied term in the contract.
But the corporation did not stop you.
No, curfew, they refer to curfew.
Government, this having regard to section 51, it is inter se parties. And the corporation did not stop you, isn't it?
I see what all from my lordship. The only thing I can submit, my lords, is they are both state under Article 12. So direction of one could be, my lords, with your lordship's indulgence, considered as direction of both. So ultimately, both are state. The High Court, my lords, has also taken a similar view at page 191. Relevant page, your lordship will please find, my lords, at 220.
Learned counsels for the petitioners.
ಒಂದು ಪಾಯಿಂಟ್ ತಮಗೆ ನನ್ನ ಹತ್ರ ತೋರಿಸಬಹುದಾ?
On two judgments of the High Court of Madras in the case of R. Narayanan versus the government of Tamil Nadu and others in WP bracket MD number 19596 of 2020 and connected matters. And
the decision of the Delhi High Court in at page 191.
WP number 3733.
A decision of the Delhi High Court in the case of Srimati Geeta Jeena versus government of NCT of Delhi in WP bracket C number 3733 of 2020 and connected matters. Full stop. However, there is no representation for the respondent corporation. Full stop. Release this matter on 30th of January at 2:30 PM.
In this matter, interim order to continue, interim order.
Interim orders granted earlier stand extended till the next date of hearing.
That in this one case is made a different malad, WP 26-210 but 2022, which is with regard to blacklisting malad.
ಅದ್ ತೆಗಿಬೇಕಾ ಇದ್ರಿಂದ?
ತೆಗಿಬೇಕು.
ಯಾವುದು?
26,210 of 22.
ಸೀರಿಯಲ್ ನಂಬರ್ ಹೇಳ್ರಿ.
71 ಅಲ್ಲೇನೆ 71.
71.
71.4.
78.4. 71.4 shall be dealing from these matters.
It may be called on 30th, sir.
Huh?
Blacklisting. ಅದಕ್ಕೂ ಅವರೇ ಅಪಿಯರ್ ಆಗೋದು. Same.
Blacklisting. ಅದಕ್ಕೆ ಸಂಬಂಧ ಇಲ್ಲ. Let us see. Yes.
May I make one
Have it on.
indulgence, sir? 65, may be permitted to withdraw the petition.
Yes. ಅದು
Instead of,
after arguing for some time,
Please, please.
learned counsel for petitioner seeks leave of the court to withdraw the petition.
Please, madam.
Stop. The submission of the learned counsel for petitioner is placed on record. Full stop. Next para. Accordingly, the petition stands dismissed as withdrawn.
Please, oblige. 65 minutes, sir.
Yes.
We tried contacting, technical people are not available. ಅವ್ರು ಹೇಳೋರು ನಾನು ಹೇಳಂಗೆ ಅವರು ಹೇಳ್ತಿದ್ದಾರೆ. Kindly have it on Monday, please.
Monday.
Because the Friday ನನ್ಗೆ ಐ ಆಮ್ ರಶಿಂಗ್ ಟು ದಿ ಸಿವಿಲ್ ಕೋರ್ಟ್. ಇವಾಗ PDG ಅವರೇ ಫೋನ್ ಮಾಡ್ತಿದ್ದಾರೆ. ನಮ್ಮ ಎಲೆಕ್ಷನ್ ದಲ್ಲಿ ಗಲಾಟೆ ನಡೀತಾ ಇದೆ. ದಟ್ಸ್ ದ ರೀಸನ್.
ಯಾವತ್ತು ಎಲೆಕ್ಷನ್ ಇರೋದು?
2ನೇ ತಾರೀಕು 1.5 hour ಆಗತ್ತಲ್ಲಿ ಅಡ್ವೊಕೇಟ್ಸ್ ಆಚೆ ಬರಕ್ಕೆ.
24th can we have ಅಂತ ಕೇಳ್ತಾರೆ.
24th ಸ್ವಲ್ಪ ಕಷ್ಟ. Tomorrow and after I have some difficulty.
25th
Magistrate court ಅಲ್ಲಿ meeting candidates. My lord, my issue is only because that's why Monday.
We'll have it at 2:30.
Saturday. ಇವರು ಇಲ್ವಂತ. Monday or Tuesday, my lord. Tuesday ತೊಂದ್ರೆ ಇಲ್ಲ ನಂಗೆ.
28th.
ಅಷ್ಟೊಳಗೆ ಅಟ್ಲೀಸ್ಟ್ ಅಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗತ್ತೆ ಅಂತ ನನ್ಗೆ.
29th. Release this matter on 29th at 2:30 PM.
ಅದೇ ಅದ್ ಗೊತ್ತು, ತಮ್ಗೆ ಗೊತ್ತು ಅದೇನಿದೆ. We'll not, I've said, we'll
Yes.
come back on that.
Yes, all right.
1.5 hour ಆಗುತ್ತೆ. ಅಲ್ಲಿ ಗಲಾಟೆ ಅಲ್ಲಿ. ಟ್ರಾಫಿಕ್ ಕಾನ್ಸ್ಟೇಬಲ್ ಕೆಲಸ ಮಾಡು.
ಬೆಳಿಗ್ಗೆ ಮೆಮೊ ಮೂವ್ ಮಾಡಿದ್ವಿ, ಕಳಿಸಿಲ್ಲ ಅಂತ ಹೇಳಿದ ಬ್ರಾಂಚ್.
What happened in item number 63? Item 63, please. Is there a next date?
Sir. Sir. Online.
Yes,
Huh?
item 63.
Item 63.
12596. Writ petition.
28/1. Item 63.
28 January.
28 January.
Okay, thank you.
70. Next week ಬರುತ್ತೆ ಸರ್, ಈಗೇನಿಲ್ಲ, ಎಲ್ಲ ರೀಚ್ ಆಗುತ್ತೆ, ಏನು ಯೋಚನೆ ಇಲ್ಲ. ಡೇಟ್ ಕೊಟ್ಬಿಡಿ. ಡೇಟ್ ಕೊಡಕ್ ಬರಲ್ಲ ಸರ್, ಡೇಟ್ ಇಲ್ಲ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ. ಈಗ ನೋಡಿ ಎಲ್ಲ IAS ಯಾವ್ದಾದ್ರು ಬರ್ತಾ ಇಲ್ವೋ ಎಲ್ಲ ಬರುತ್ತೆ, ಏನ್ ಯೋಚನೆ ಮಾಡ್ಬಿಡಿ, ಎಲ್ಲ ಬರುತ್ತೆ. Every matters will come and it will be. ಹಾ ಫೈಲ್ ಹೋಗಿಲ್ಲ ಅಂತ.
ಇಲ್ಲಿಂದ ಕಳ್ಸಿಲ್ಲ ಸರ್, ಇಲ್ಲಿಂದ ಕಳ್ಸಿಲ್ಲ ಸರ್, ಎಂಟ್ರಿ ಇಲ್ಲ ಸರ್. ಸರ್ ಇಲ್ಲ ಹೇಳಿದ್ರು ಅವರು, ಇಲ್ಲೇ ಹೋಗ್ತಾರೆ ವಿಚಾರಿಸಿ ಅಂತ ಕೇಳ್ಕೊಂಬಂದ್ರು ಸರ್ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ. ಪೆಂಡಿಂಗ್ ಸರ್, ಅಯ್ಯ ಹಾಕಿದ್ವಿ ಸರ್, 2 ಸಲ ಅಯ್ಯ ಹಾಕಿದ್ವಿ ಸರ್. ಇವತ್ತು ಕೊಟ್ಟಿದ್ದಿಲ್ಲ, ಅಷ್ಟಕ್ಕೂ ಕೊಟ್ಟಿದ್ವಿ ಸರ್.
Doctor sir. Sir.
Zero. ಇವತ್ತು ಹಾಕಿರೋ ಗ್ರೂಪ್ ಅಂತಿದ್ರೆ ಬರಲ್ಲ ಸರ್. ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಸರ್, ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಕರೆಕ್ಟ್ ಆಗಿ.
Sir, court officer sir. ಇದೀವಿ ಅಂತ ಹೇಳಿದ್ರು.
ಇಪ್ಪತ್ತೆರಡರಿಂದ ಅಲ್ಲೇ ಬನ್ನಿ ಸರ್, ವೆಹಿಕಲ್ ಹೇಳಿ
ಸರ್
ಯಾವ್ದ ಮೈಕಲ್ ಹೇಳಿ ಸರ್.
ಅದೇ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್, ನಾನು ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿದ್ದೆ 4 ಮ್ಯಾಟ್ರು ಇಯರಿಂಗ್ ಆನ್ ಐಎನೇ ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ ಮೆಮೋಸ್, ಅದಕ್ಕೆ ಕೇಳೋಣ ಅಂತ. LM ಚಿದಾನಂದಿ ಆಫೀಸ್ ಇಂದ 4 ಮೆಮೋ ಮೂವ್ ಮಾಡಿದೆ, ಎಲ್ಲ ಐಎ ಹಾಕಿದ್ದೀನಿ. ಕವರ್ಡ್ ಮ್ಯಾಟ್ರ್ 4.
ಯಾವ್ದು ಮೇಡಮ್ ಅವ್ರೆ?
4 ಕವರ್ಡ್ ಮ್ಯಾಟ್ರ್ ಸರ್ ಕೊಟ್ಟಿದ್ದೀನಿ, ಇವತ್ ಬೆಳಗ್ಗೆ ಕೊಟ್ಟೆ ಸರ್. ಒಂದೇ ಒಂದ್ ನಿಮಿಷ ನಂಬರ್ ಹೇಳ್ಬಿಡ್ತೀನಿ.
ಅಲ್ಲಿ ಹೋಗಿದೆ ಮೇಡಮ್, ಎಲ್ಲ ಡೇಟ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಬಿಟ್ಟಿದೀವಿ ಡೇಟ್.
ಹೌದಾ, ಯಾಕಂದ್ರೆ ಅಲ್ಲಿ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. ನಾನು 4 ಮೆಮೋ ಕವರ್ಡ್ ಮ್ಯಾಟ್ರ್ ಎಲ್ಲಾನು ಹಾನರಬಲ್ ಕೋರ್ಟ್, ನಾನು ನಂಬರ್ ಕೂಡ ಹಾಕಿದ್ದೀನಿ, ಕವರ್ಡ್ ನಂಬರ್ ಕೂಡ ಹಾಕಿದ್ದೆ, ಅದಕ್ಕೇನೆ.
ಹೋಗಿದೆಯಲ್ಲ ಎಲ್ಲ ಹೋಗಿದೆ ಮೇಡಮ್.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ನಾಗರಾಜ್ ಫೈಲ್ ಬಂತಾ? ಫೈಲ್ಸ್ ಬಂತಾ? ಇದೊಂದು ಒಂದೇ ಒಂದು ರಂಡಿ. ಎಲ್ಲ ಆಲ್ ವೆಲ್ಕಮ್.